Good morning, Ms. Flotela.
Good morning, Deputy Chief Justice.
How are you?
I am well, thank you, DCJ. How are you?
I'm fine, thanks. Are you comfortable?
Yes,
Alright.
I'm a bit nervous.
Perhaps I should declare that I've known you since you were a young girl, and I'm shocked to see that you are graying. And
I am great.
What does that say about me? In fact, I was shocked when I looked at your application form, and I saw that you have a 17-year-old, because to me you remain that young. You are the 17-year-old. Okay. You hold a BProc degree from the University of Transkei.
Indeed, DCJ.
And after you had obtained that degree, you went on to do a master's degree specializing in commercial law with UNISA.
Yes, DCJ, that's true.
How did you find that experience, studying on your own?
I enrolled for the LLM when I was doing the, I think I was a PA at Vacancies Attorneys. So there was a lot of time, and they allowed me to study.
All right.
Yes. And
at some stage later, you did a course in a diploma in alternative dispute resolution with UP.
Yes, DCJ, that's true.
Right. Just tell us a bit about your legal career. What have you done? Where have you been that brought you here?
Yes, I started my legal career as a candidate attorney with the firm Vacancies Attorneys in Port Elizabeth. It was a firm that specialized in property law and property rights law. After admitted as an attorney, I was there for a year. Thereafter, I went home, back to Mthatha. And fortunately, when I was in Mthatha, there was a position that was available, that of a legal research assistant for judges in Mthatha High Court. Although I was already admitted as an attorney, I availed myself for that position because early in my career, I decided that I would like to be a judge one day. And then when that opportunity came, I did not hesitate to avail myself for that position. So I was there for 3 years as a research assistant for judges. After that, I was then employed by the Department of Justice as a state attorney.
Yes.
I was placed in the property law department, where I dealt with all property law related litigation, starting from the restitution of rights, evictions, ESTA, PI applications. I also was a conveyancer responsible for transferring the government's properties from the Republic of South Africa to national government of the Republic of South Africa. So for 9 years, I dealt with the restitution of land rights. I practiced mainly in the land claims court and also in the High Court. Until from 2006 until 2015. 2015, I resigned. I had reached the ceiling for being in the state attorney. I established my own practice Flatella Attorneys Incorporated, where I also specialized in property matters, now representing the claimants. Whilst in the state attorney, I was representing the department and the Commission on Restitution of Land Rights. I was now in the panel where I represented the claimants, the farm dwellers, and labor tenants. So I dealt with all aspects of Esther. I also dealt with mainly my practices as it can be described as human rights, public interest law, although it was not an NPO, but I felt that spending much time in the state attorney, I needed to practice in my area of choice. I'm an activist, so the human rights law and especially the land law is very important to me. So I use that opportunity to practice as such.
Yeah. In your application form, in that part where you are asked to describe your contribution to the pursuit of justice, you say something that touched me deeply. And you speak of the social strife that you witnessed in many of the matters you handled dealing with land law. And you highlight that the most vulnerable in those matters were women, and often their children left destitute because there's no adequate protection for them under the law. And you go on. Is that what has caused you to apply for this job? Why do you seek this job?
Yes, I, very early in life, before I even enrolled for a BProc degree, I witnessed injustice. I was born in the village, but early in life, I traveled a lot because my aunts were working in 2 different towns where you had to pass. For instance, my 2 aunts were working in Mzimkhulu. You had to pass Kokstad, that is, it was the Republic of South Africa, to reach Mzimkhulu. And when you, every time we traveled to Mzimkhulu, we were stopped, searched, and my aunts had to produce the travel, the passport. And
it was called the travel document.
It was called the travel document then, and my name and my cousin's name were under my aunt's my aunt's name. And I was very inquisitive child. I was asking my aunt, why are we always stopped by the police, and why are we always searched? And those ones that were not political conscientized. So there was the other one that was working as a principal in Queenstown. Also in Queenstown, you had to, in Esbelin, to reach Esbelin, you had to pass Queenstown.
There was a border there.
Yes, so there was always. So I witnessed this injustice at a very young age. So I asked, that aunt was very political conscientized, and she told me, and she told us about the history of land dispossession and conquest, and told us why we are searched, that we were not regarded as citizens in this country, and we were just given the places to stay, and whilst at the same time witnessed people from white group, they were moving freely. Even when we entertained ourselves, I'm born in the Wild Coast area. So during holidays, we would go to Mzamba and see and Port St. John's, but would see our fellow South African, the whites, moving with boats like they were enjoying, and there were segregation even then. There were parts of the ocean that we could not swim and all that. So then I was then told about the history. And with me, I grew up knowing that I have to be part of the people that are going to see to it that there is justice, there is equality, even if that meant I should go and join those who were fighting. So that is my background, and then I learned about law, that it can be used as an instrument to bring forth freedom to people. So I resolved that I would enroll for law and do law and use law as an instrument of revolution.
Yeah. You have acted as a judge in the High Court.
Yes, DCJ I have.
Where? In which divisions?
Yes, I was invited last year in the Eastern Cape Division by JP Mbenenge. For 6 weeks, I was in Mthatha. In the Eastern Cape Division, both in Mthatha and in Grahamstown.
And I see that you also acted in the South Gauteng High Court.
Yes, I acted in the Land Claims Court. So when you act in the Land Claims Court, you automatically act in the South Gauteng High Court and in the Gauteng Division. So both Johannesburg and Pretoria. So I was acting in the Land Claims Court and in the Gauteng Division.
So you are no stranger to the Land Claims Court?
No,
actually.
I'm not stranger at all.
Did you manage to produce judgments during your acting stint?
Yes, in the Land Claims Court, I did produce some judgments. Although I must say, I acted at the time when it was during COVID. So the matters that we really did, it's ESTA matters. The restitution matters were postponed until the issue of the pandemic was resolved. So I did produce some judgment in those matters. And also in the High Court, I acted in the High Court. I did produce some judgments.
Well, those judgments seem to have impressed the relevant people. The professional bodies, right, have sent very complimentary reviews on you, and they describe your judgments as progressive and many other, they use many other good words to describe them.
Yes.
Did you manage to produce them promptly?
Some, yes. Some, no.
What does that mean? Please explain. Do you delay judgments?
Yes, there was an issue with regards to my firm. I am a one-woman controlled. It's owned and controlled by me. During last year, my support staff were affected by contracted COVID. So I was struggling throughout the period of my acting stint with regards to the support, the secretaries and my intern. So especially during the fourth term, that's where the problem is. You will see that there were many reserved judgments during that time. I had struggled with the support.
How long did it take you on average to deliver them?
I think 3 and others 4.5
Months?
to 5 months, yes.
Was it not possible to get help? Did you approach your judge president? Why could you not be given assistance if there was something the matter with your own staff?
During the, as I said, it was during the time of COVID.
COVID.
Yes, during the time of COVID, it was very difficult to communicate, but I had, Judge Mir will know, I had raised the issue with her. But I think I did not with Justice, with JP Mlambo. And I told him, I just was pushing, thinking that I would be able to do it, but it was just overwhelming. It was before me, and Gauteng is one of the busiest courts. But I had explained to him later, and he told me that I should have told him he should have arranged, and he should have gotten help for me.
Yeah. Well, you know better now.
Yes, I do.
All right. Thank you so much, Ms. Flutella. I will hand over to the commissioners to put questions to you if they have any. And may I just remind my fellow colleagues that it's strictly 2 questions. We go back to our ground rules now and we enforce them. We have many candidates for today. So no preambles, no observations, no statements of fact before we put the actual question. Let's just get to the question. Minister.
Judge Mir,
Sorry?
the president of the court is here.
Oh, my goodness. Thank you so much. Judge Mir?
Thank you. Good morning, Ms. Flutella.
Good morning, Judge
You have
Mir.
a long association with the Land Claims Court. We first got to know you when you litigated actively as a member of the State Attorney's Office.
Yes.
And more recently, of course, you acted.
Yes,
You acquitted yourself well as an acting judge, notwithstanding the difficult circumstances during which you were with us, which was during COVID. And as you rightly say, you dealt mostly with ESTA matters. Now, as you know, our court is a circuit court. We travel all over the country, sometimes far-flung rural areas, to hear cases. Is there any reason why it is going to be difficult for you in terms of your health or your personal circumstances to avail yourself to travel the length and breadth of the country, if needs be, to hear cases?
Thank you, Judge Mir. There is no difficulty at all for me to travel throughout the country. As I disclosed in my application, that the RA that I'm living with is on remission. When it was acute, very acute, I mean, I could not walk, I could not write, but I traveled during the Fees Must Fall protests to represent the students, because I am known as an activist in the country. So I traveled to Cape Town. My base was in Cape Town. I traveled to Limpopo. I even traveled to Venda whilst I was still very sick. So I am able to drive myself now. There is no problem at all with regards to traveling.
One last question. You described yourself as an activist.
Yes.
Do you think being an activist judge can be problematic?
No, I don't think so. I don't think so, because the activists, as I know them, they are the ones that are balancing the rights well and are not afraid to go to where others are afraid to go. So I think all of us should be activists all of us should be activists, especially then in the land claims court, where you are dealing with the most vulnerable and the most privileged. So in terms of balancing their rights, I think my background of being an activist is going to assist a lot in the land claims court.
Thank you. No further questions.
JB? Oh, thank you so much. I'm sorry, I just got distracted for a minute. JP Mlambo?
Thank you very much, DCJ. Good morning, Ms. Flatella.
Good morning, JP.
I was a bit worried when the DCJ was talking to you about the challenges you had in delivering those judgments. I was worried that you were not going to disclose that we actually did speak afterwards.
No, not like that, JP. I had disclosed, yes.
Yeah, but I think I just want this commission to know you were not, what I told you was you should have spoken at the time, because as part of my support for women to come to the bench, especially those who run practices, I understand the challenges they have. And that's what I told you, you
Yes.
remember?
Yes,
To say
you
you
told
should
me.
have spoken earlier so that one knows what challenges you have and what support structures one can put, or what sort of leeway can be given to you for you to hand down those judgments. You confirm that discussion?
I confirm that discussion, JP.
Yeah. But other than those judgments in that period, you've not had occasion to reserve more than beyond 3 months. Am I correct?
Yes, yes, JP.
Okay. And you regard yourself as ready?
I am ready, JP.
Yes. Thank you. Thank you, DCJ.
Thank you, JP. MEC Mamabolo, are you available on the virtual platform?
Yes, good morning. I am available, but at this point, I don't have any questions. But I am here. Yes, thank you.
Thank you, thank you. Commissioners, do you have questions? Minister, go ahead.
Thank you. Good morning, Mr. Watela.
Good morning, Minister.
Mine relates to the fact that for sure you know there is a land court bill now in Parliament. What do you see as your role going forward in expediting the matters that they've been clogging the court role in the land claims court as soon as you are appointed and as when the bill become an act?
Thank you, Minister. I hope the land court is going to be established very soon, because as you correctly state, there is a backlog in the land claims court. What I have what I've learned in the Gauteng Division about the case management flow. They have a comprehensive case management flow. I should think if the land court adopts that or create that, it is going to be very effective. For instance, the land court comes at the land claims court come at the very end of the process, because the processes are the commissioner, the commission, the office of the commission. It has enormous responsibility from assisting the claimants in filling or in completing the land claims to the negotiations and mediations. So the land claims court comes very late when they certify that it is not feasible for the matters to be resolved. Then it is then that the matters are sent to court for adjudication. So once those matters are sent to court for adjudication, once the judges are allocated the matters, that is when the case flow management should start to follow up on the matters that must be dealt with, to follow up with the commissioner's office and the participating parties. That in that way, it is going to be easy to deal with the matters and to have matters heard and to decide on the matters.
Yeah, my second question relates to the Tobejan and others versus the Regional Land Claims Commissioner.
Yes.
Looks like it's a matter you presided on, and you have seen the comment of the GCP.
Yes, yes.
So what worries me there is that our expectation is that the land court should help develop jurisprudence in this field of the law. So their concern there is that your judgment did not explain adequately why the relief that was not sought was granted, and why the parties did not appear to have been provided an opportunity to make submissions. What is your view to that and into your ability to help develop well-reasoned judgments?
Yes, I think there's a first judgment. The matter came before me as a review of the decision of the commission to publicize the land claim in the government gazette. So during and it came, issues were convoluted and all that. So during the course of my consideration of the matter, I found that there are other documents that I would like to have sight on, and the land claims court as a court of equity were allowed to call for further documents in order to make a good judgment. So I called for the file from the office from the office of the commissioner, because they had attached the extracts from the file, and their course of action was based on that extract. So I needed the whole file to find out what really happened. So that is what happened. So I issued that as a rule nicer, and it was done, and that was I was able then to deal with the matter thereafter.
Thank you, DCJ.
Thank you, Minister. Commissioner Matoro-Lepu.
Thank you, Deputy Chief Justice. Good morning.
Good morning, Ma'am Tlep.
How are you?
I'm fine, thanks, Ma'am Tlep.
Okay, what I just wanted to say is that I really allowed you for really taking up, making yourself available for the land claims. As you know, that the legal aid is now in charge of legal aid matters. We've been trying to train a lot of female advocates, young female advocates, to take up land claims matters. But one of the things that discourages us is the issues of the Lamusa judgment. I think somehow it stagnated the matters for going forward. What is your take on that?
The Lamusa judgment deals with the reopening of the land claims. And then, according to that judgment, the Parliament was given time to deal with the Act, so that it is within it passes the constitutional matter. Unfortunately, the Parliament failed to do that. So all those claims are now freezed. So that is the status quo of the matter.
Just for up, will you make yourself available to train the women advocates and attorneys that I'm talking about?
Yes, you know, I have, during the time when I was a state attorney, and even as a director in my law firm, I brief women, black women advocates, and you know, and I have introduced many in the land rights matters. But the issue, Mamdlepe, really is the fees that are being offered to the claimants. Claimants are the most vulnerable. They are the most oppressed, most degraded. If you want to see the apartheid life, you look at the lives of the farm dwellers and farm workers. But you find that the government, in supporting them, the rates that the advocates and attorneys are paid, it's an outcry. Yet their own advocates are paid the rates that are in line with the. So that is why you will find few or less qualified people that will take up the claimants' cases. Yet the claimants' cases are highly defended. The landowners, they defend, they are well resourced, and they defend those claims. So it's like it's as others that had agreed to the rates, because I would disclose the rates, they would say we would take it as a pro bono. You know, I'll just take it as a pro bono, as a service to my people, but the rates are really not fair for the claimants, because they are not getting the best legal representation due to the rates that are being paid.
Thank you so much.
Thank you, Commissioner Klepu. Commissioner Moimang?
Thank you, Deputy Chief Justice. Good morning, Flatella.
Good morning, Dada.
Just one question from my side, which is informed by the latest land court bill that was passed by Parliament. Do you think the proposal to establish a specialist land court with its judgment appealable by the full bench of that court will help to deal with all land-related matters as regulated? Thank you.
Yes, I had a look and considered the land court bill. With regards to that, my only worry was the resources, whether the government is going to be able to establish that court. I thought to make things easy, I thought putting land court under the high courts, like we have tax courts that are accommodated in the high courts, and for access also, because if the land court is going to deal with all land matters, not only land claims matters, the High Court, for instance, if you look at the PI jurisprudence, they have been dealing with these land matters, except those that are exclusively the restitution of land rights, land rights. So I thought the High Court is in a position, because High Courts are already been established, they are there, and even they can lend some judges also to deal with these land matters, because they are, it's really an issue that is pressing. High Courts are dealing with land matters every day, and I must say that the eviction jurisprudence has evolved and is solid, compared to Esther jurisprudence. So I thought that would help. But yes, if the government's vision is to have the land jurisprudence, then it is a good move that we have the land court and the land appeal court, because the judgments currently, you can only appeal in the Supreme Court of Appeal. So it takes a long time, for the parties to get justice.
Thank you, Mefratela. Thank you, Deputy Chief Justice.
Thank you, Commissioner. Commissioner Marumachai?
Thank you very much, DCJ. Good morning.
Good morning.
I wanted to ask you one question, but your response to the previous question led me to another question that triggered my mind. When you say PI is solid, I'm not sure. Are you aware of the recent Constitutional Court case, the Grobler versus Phillips?
Yes.
You're aware of that judgment?
Yes.
In that judgment, I just want to hear what your views are, because it appears that the Constitutional Court in that case was faced with the rights of the old woman who was sought to be evicted, and the owner who wanted to buy the property to build houses for his old parents. And then it crafted a judgment, a very generous judgment, placing the onus on the owner to provide alternative accommodation and not on the state. In light of that judgment and the reasoning, do you still hold the view that PI is as solid as you said?
At least, Commissioner, the issue, the really primary issue is the lack, is landlessness. The old woman that was staying there with, he claimed that he had lifetime rights to stay in the property, and Mr. Phillips offered to buy him her property and all that. The issue is landlessness, and when you don't have a solid laws that protect people without land, so it becomes very difficult, to enforce the rights of an occupier as against the rights of the landowner. The test there is you can evict if it's just and equitable. So when Mr. Phillips, if Mr. Phillips offered that accommodation, then it was regarded as just and equitable. Then there was no way that the Constitutional Court would say she must stay in the property.
No, thank you very much for that. The second question that I have for you is in relation to, because you authored a judgment which, but I'm more interested in the appeal judgment that you did, the Mahlangu versus
Mahlangu.
Duplessis. And I thought it was a very progressive one, but it showed the tension, right, in South Africa in terms of religion and our cultures in those rural areas and the level of intolerance. And I thought it was a very positive judgment. But what I want to get from you is, do you feel that the law generally, and Esther in particular, is doing enough for people who are residing in farms, given some of the challenges that they are experiencing? Some are evicted, some they have to leave their graves, and all those things. Do you think the law in particular, the law generally, and Esther in particular, it's adequate in assisting those people who find themselves in unfortunate circumstances?
No, I don't think so. I think Esther's jurisprudence is shaky when it comes to, although it's meant to assist those who do not have legal land tenure. But at the end of the day, the laws, there is no, except the restitution and the Labor Tenants Act, that at least gives land to the labor tenants if they are declared labor tenants. With regards to the occupiers and farm dwellers who stayed so many years in the farms, they, despite Esther, they don't have law that is protecting them against inevitable the eviction.
Thank you very much. Thank you very much, DCJ.
Thank you, Commissioner Marai. Commissioners on the virtual platform, do you have any questions for the candidate?
Good morning, Deputy Chief Justice. It's Glynis Aju, please.
Good morning, Ms. Bredenbach. Do you have a question for the candidate?
I do, thank you.
Oh, please go ahead.
Thank you. Good morning, madam.
Good morning, Councillor.
I'm assuming from the questions of the Minister that you're familiar with the Land Court Bill.
Yes.
I'd like to hear your views on the importance or not of the fact that the court will be a court of law and equity for limited purposes. Just your view on the equity portion thereof, please.
Sorry, Commissioner, I did not hear you. I think you're fast.
Okay, sorry. The bill will have a limited applicability as a court of law and equity. I'd like your views on that limited application of a court of law and equity, the importance thereof, please.
Yes. In this case, in the land matters, it is important that the courts that deals with land matters be the court of equity, in that the laws that were enacted by the previous governments, you know, dispossessing people of the land and excluding them from economic, from land and from mines, so those people that have been excluded by laws has to be protected, are now protected by the Constitution. Now, when you deal with the matters, you have to be, you have to consider their rights, the human rights, and you have to, in interpreting the law, you have to take consideration of the history, because if we are, we are saying the Constitution is our document, is our law to achieve equality, dignity, and all. We should, the courts should have regards to the history in order to interpret, in order to grant those people fair hearing. So equity, I support that the courts that deals with the land matters, especially restitution matters and landlessness matters, they must be the court of equity rather than
Thank you.
adversarial.
Thank you.
Thank you, Commissioner Bredenbach. Any more
Deputy
questions
Chief
from
Justice.
the virtual platform? Welcome, Commissioner Singh.
Good morning. Thank you very much, Deputy Chief Justice, and good morning to all the commissioners and our staff that are there, and good morning to Ms. Flotella.
Good morning, Mr. Singh.
Good morning. May I proceed with my question, Deputy Chief Justice?
Yes, please.
Yeah, thank you very much. Ms. Flotella, in Parliament, well, in the last year or 2 years or so, we've been dealing with the question of amendment to the Constitution, Section 25. And you would know that we didn't receive the 2/3 for an amendment to the Constitution. But of late, we've had the expropriation bill come through Parliament, which received a simple majority for it to proceed to the NCOP. What difference do you see in the intention of the Section 25 amendment to the Constitution vis-a-vis the intention of this expropriation bill that has received a simple majority in the National Assembly? That's my first question. Thank you.
Yes, you're asking the intention of the bill. The issue, Mr. Singh, is the primary issue in all this. It's I think when we got freedom, you know, we ignored the part of the land and landlessness, and now we are dealing with secondary issues because we realized after some time that there is no land available for the majority of people here. So now we're trying to use expropriation and all that to address the issue of landlessness. But I should think the issue of the amendment of the Constitution, I don't think there is a need to amend the Constitution to deal with the expropriation. Even the 25(3) was not tested in our courts. So I do think that, or it's my view that the government should be willing to deal with the issue of the land, and whether it's true that expropriation, the jury is still out. We'll see if the government is going to be able to expropriate land, because even in the presence of 25(3), there is no. I don't remember that there is any matter that has been tested in court regarding expropriation.
Okay, thank you for that. My second question would relate to PI, and the Professor Commissioner asked about PI and its intentions. And there again, I think it's a very good act because it prevents illegal eviction of farm workers and destruction of graves, etc. But here too, of late, we found that in urban areas, there are people that are illegally occupying homes, which are registered in the names of individuals, and they try and hide behind PI. And I think that becomes quite a dilemma. So do you think there may be need to re-look at the PI Act to ensure that these unscrupulous occupiers, illegal occupiers of homes that just come in to take over a home, it could be your home, it could be my home, it could be any of the commissioners' homes in an urban area, try and hide behind the PI Act?
Yes, yes, Commissioner Singh, as I said, I think the primary issue is landlessness. People would not just go and occupy people's home. I think it's out of desperation of not having alternatives. But then the PI does not say, does not give rights to take over the home. But in the event of eviction, the Act states that the rights of the people, because they are the people, they have the same equal rights, must be protected. Because eventually, PI does not take away the rights of owners in terms of Section 25(1). It just makes it making sure that the rights of the occupiers are protected.
Thank you very much, Ms. Platella. Thank you very much, Deputy Chief Justice. Good to be back. Thank you.
Yeah, we're glad to have you back too. We've missed you. Commissioner Ngweto, you sure you want to ask a question?
No, DCJ, I'm holding myself. Thank you for making yourself available, Acting Judge Flatella. I'm very pleased that you are here, and I would have asked you one question, but I think I probably should not.
Thank you, Counsel. Yeah, you should not. I know where you're going to.
In your application form, you disclose that you suffer from a certain medical condition, which is, however, in remission and does not affect the quality of your work. But one of the professional bodies has asked that we find out from you anyway if you will be able to withstand the rigors of judicial office if you are appointed.
Yes, thank you, DCJ. Yes, I live with rheumatoid arthritis. I'm not afraid to disclose that because it's an autoimmune disease, but it is on remission, as I say. The living with RA is not a problem. As I said, the matters that I dealt with when in my firm, when it was still acute, and the matters that I am known for, I dealt with them when I was really, really sick, you see. So it's not a problem. The issue is support, is support system that I should think I must state that one needs support in terms of your functioning PAs or secretary, I don't know, you have secretaries or PA, and perhaps the research assistant that would be available when she or he is needed.
Did it adversely affect your work output at all when you were acting as a judge?
No, DCJ, as I disclosed earlier, that what affected my work outputs is not having a support system, because my PAs and my interns were affected by COVID, and I had to, most of the time I had to be alone and do things and deal with the workload, which was too much. Too much to do by myself without any support. I employed new people, but it is difficult when you have to teach those people. But yes, that is what I would put out there.
All right. Thank you so much. Well, it does not appear that there are any more questions for you. Thank you for making yourself available for this interview.
Thank you.
Unless you want to say anything more to us, you're free to go.
No, I think
You
my
can't
work
wait
speaks
to leave.
my work speaks for itself. So,
Okay.
yes.
Thank you so much. You're excused.
Thank you.
May we please ask non-JSC members to leave the room so that we can deliberate on this interview? Are the colleagues on the virtual platform back from the tea break? Are you there?
Yes, I'm back. MEC Namabodo, present.
All right. Thank you, colleagues. Good morning. Are you acting as a judge now? No? Good. All right. Good morning, acting judge Francis Subia. Did I pronounce your name correctly? All right. How are you?
Well, thank you. And how are you?
I'm fine, thanks. You have applied for one of the vacancies in the Gauteng Division.
Yes, I have.
All right. Is this your first interview?
It is my first interview,
it is.
Justice.
All right. You hold 3 law degrees, a BUris, LLB, and LLM.
Yes, I do, Justice Maya. I have got my LLM degree in 2003.
In what area of the law was that focused?
The focus was in regard to civil procedure, women's rights, and family law.
All right. I see you have a quite checkered career that looks a bit like mine. You've been a sales coordinator and everything else in between. I did the same. Builds character, I must say. But your legal career started in 1995 when you worked in the Department of Justice as a registrar?
Yes, Justice Maya. In fact, I think I had my first run-in with the law when I started working as a legal secretary after a little bit after I finished high school.
Oh, yes.
And I was sort of moonlighting and finding work, and I studied part-time. I completed all my degrees part-time by working on a full-time basis.
All right, so that's when the bug bit.
I think the bug bit a little earlier in high school. Coming from the background that I have come from, I knew that something was to happen in our country and that I wanted to be a part of it. And the way to do that would be through human rights. And the most wonderful thing that I think happened for us as South Africans was to have this amazing constitution with a Bill of Rights. And fortunate for us, it is the supreme law of our country.
All right, you became a prosecutor in 1998, and from there you built your way up to the magistracy and lectured in between.
Yes, I have been lecturing since 1998 at Justice College. I then, of course, went on to also lecture at SAJ, and we were part of the team that assisted in getting SAJ started. So I have developed a number of different programs for SAJ, which I have done at Justice College as well. So I have done a lot of mentoring and lecturing, and I've also written a book on taxation of legal costs.
Yes, we'll chat a bit about that book a little later.
Thank you.
Which subjects did you teach at Justice College, both at Justice College and with Sajay?
Justice Meyer, your question?
I'm asking which subjects you taught
Oh,
at Justice College
well,
and at Sajay as well.
Well, a number of topics. In fact, I would lecture extensively in civil law, in civil procedure, and I've also dealt with legal costs and taxation. I went on to teach or lecture to registrars of the High Court as well as clerks of the court. I was also involved in lecturing on the Equality Act and the establishment of the equality courts in the country. I also had involvement in respect of the setup of the judicial jurisdiction for the regional courts. So I've been involved in a number of different levels of lecturing, mentoring, and as well as judicial decision-making.
Yeah. And are you a SAJ instructor?
From time to time, when I have been asked, I have gone and delivered lectures. In fact, in the setup of SAJ, at some point, I ran a train-the-trainer course, where I trained senior magistrates from the magistracy to conduct training themselves through SAJ. And that was a very successful process. And I think it also then gave the empowerment to others to begin training.
Yeah. And you, in the midst of all that, you found time to write this book, Taxation on Legal Costs in South Africa.
Yes, and the reason for that actually came from, there used to be a request quite often from the courts in South Africa, as well as courts outside of South Africa. I'd been invited to lecture in Southwest Africa, in Lesotho, Swaziland, Botswana. And then it became quite, I realized that there was a need for this kind of training in taxation of legal costs. And that was the reason which spurred me on to say, well, it's time to put all of this information in a book, which Juta published. And I hear that it has been dubbed the Bible of taxation.
Yes.
I've heard a number of commendable remarks on the book. So I think it is serving the purpose for which I intended or wrote the book, the reason why I wrote the book.
Well, it has been cited in decisions, court decisions, not only here, but across our borders as well.
Yes, yes.
All right. How long were you a magistrate? Sorry, how long have you been a magistrate?
Yes, I was appointed, actually one refers to it as Mandela Day, on the 18th of July 2000. So that gives me 22 years.
Yeah. You've had a number of acting stints in the Gauteng Division since 2016.
Yes, I have, and that has been a wonderful opportunity given to me by the Judge President.
Did you manage to produce any written judgments during those stints?
I have produced a number of written judgments from all those stints, and some interesting ones, some normal ones, run of the mill, but yes,
Yeah,
I have.
You get a mixed bag. Any of them reported?
Justice Meyer, my judgment in regard to the Conversion Act was actually, when I wrote it, I did not think of reporting it, but when it did go to the Library Committee, they came back and said this judgment should be reported. And I said, well, yes, then, have it reported. So I'm not particularly sure that, in fact, it did get reported. I was under the assumption that it did in fact get reported, but it is cited in SAFLI, and it has been used quite widely in respect of the procedure that I set out in that particular judgment. It has been quoted in a number of legal articles, even an article appearing in the Human Rights Journal. The particular matter dealt with the unfortunate situation that emanated from our apartheid years, when people in our country, black people in our country, could not own land in urban areas. And as a result of this historical tragedy, one could call it, then the matter came before me as an eviction matter, and I looked at it more deeply, and I saw that in fact there are more issues to consider here. I did quite a bit of my own research, and that is perhaps one of the judgments that I took the stance to set out the historical development of the legislation that emanated in the Conversion Act, and how in fact one would deal with those specific rights.
You've never been overturned on appeal?
Well, so far I have not. I had, in fact, given leave to appeal in a matter that I have requested to find out what, in fact, happened to that matter. But all my investigation from the clerk of court as well as the registrars of the High Court, I don't seem to have, they have not given me any feedback, so I don't know if I've been overturned on that. But I have not been overturned on anything else that I know of.
You don't have any reserved judgments, old reserved judgments, that is?
Today, as I sit here, there's not a single reserved judgment.
Any old badly head matters?
In fact, in the magistrate court, I have a part-heard matter that I'm hearing tomorrow. So yes, that's the only part heard. In respect of the High Court, I have no part-heard matters. And I will be going back to ACT from Monday again.
Okay. One of the professional bodies who sent in comments on your suitability for the position raised the concern that one of the judgments to which you refer, the Roman pizza one, is they could not find it anywhere.
The ones on the Roman pizza one?
Yes.
Okay, so remember, that is a judgment I wrote in the Equality Court. I do have a copy of it here.
Oh.
But it did go on appeal, and my judgment was confirmed.
So it does exist indeed, and
oh, for sure,
does not
without
exist.
doubt. In fact, it had quite a lot of media attention here in Gauteng as well as in Durban. It was in the Soweto newspaper as well, and the headlines read, "Pizza chain to eat humble pie." Yeah. So it exists.
Now you've stirred my curiosity. What was it about, very briefly?
What it was about, it raised the issue of discrimination, and it was discrimination based on religion in regard to opening a pizza chain, where it was found that because those particular investors were non-Muslim, they were, after dealing with the company for more than a year, at the last moment, they pulled out of the commercial contract, the agreement, and they said, well, we're not going to go on further in giving you the opportunity to run a pizza franchise simply because you are non-Muslim.
And you found against them, of course?
I found that there was discrimination, and such kind of discrimination is not, shall I put it plainly, allowed in terms of the Constitution. And in that regard, even if you are a powerful commercial company, you have to adhere to the supreme nature of the Constitution.
Thank you, Acting Judge. JP Mlambo, do you have questions for the candidate?
Thank you very much, DCJ. Good morning, Ms. Subia. Francis Subia, sorry.
Good morning, JP.
Mine is just to assist you to tell the JSC what you've done when you came to ACT in Gauteng. And I'll help you do that because you completed that spreadsheet. Let's start with criminal trials. You're a magistrate, you say, for about 22 years, am I correct?
Yes, that's correct, JP.
Have you sat in criminal trials in that period?
In regard to being a magistrate for 22 years, yes, I've done lots of criminal trials and handed out many, many judgments. In the High Court, of course, I have dealt with appeals in criminal matters. I've also sat in a full court appeal where I wrote the judgment, and the senior judge approved of it and thought it was a good judgment. Yes.
Okay. That's criminal trials, and you've sat in the agent court for a week. Is that correct? I thought it was more.
JP, it was only for a week. In fact, the newly established family courts that we're now running in the Johannesburg Division is where I had that opportunity to sit.
I see. How did you find the tempo in the agent court?
I think because it's a new court, it was not that strenuous. I coped and managed very well.
I see. And then you had 2 weeks in special motions.
Yes.
Not the opposed motions, but the special motions.
Yes, I have.
Did
I
you-
have dealt with that. I believe that those matters were perhaps much longer, more voluminous. Some of the matters would have had more than 4,000 pages, and I've dealt with that, yes.
Well, they are called special motions for a reason, isn't it?
Absolutely.
You wrote those judgments?
I have.
And,
Whatever has been put before me, I have written those judgments.
And did you comply with the 3-month period in terms of those particular judgments from the special motions?
Yes, for sure, Judge President. I make sure that all my judgments are delivered timeously. I set myself a certain limit,
Yeah.
and I get through them. Thank you.
And you sat for 6 full weeks in opposed motions, am I correct?
Yes.
Now, do you agree with me that the opposed motions court is where you accumulate reserve judgments?
Yes, once you hear the matter, and if there are a number of issues for you to deal with, then it is likely that that is where you will acquire your reserve judgments.
Yes,
I
yes.
agree with you.
And have you ever featured in my dog box list of long outstanding judgments?
No, not at all. I don't think I've ever gone more than 2.5 months. I
Yeah.
think it might even be less.
I see, right. And you regard your period as a magistrate and having acted and you coming back. In fact, before I get there, as an acting judge in Gauteng, when you finish acting, you send a report of your acting stint to the JP, isn't it?
Yes, I do.
And you attach judgments for the JP to read.
Yes.
I see. And that's where you get a review about how you've performed once you send that report to the JP.
Yes, I think it is an opportunity to let the JP know what you've done in that period of time.
And to raise concerns if you
And of course, to raise concerns that may have occurred during that acting stint.
I see. My last question to you is your comment. You've been a magistrate for nearly 22 years. You've lectured other judicial officers. You've written a book on something that happens almost daily in the high courts in particular. You've acted, the spreadsheet says 42 weeks. Is that what says to you, you think you can take on a full-time role as a permanent judge in Gauteng?
Yes, Judge President, I think that I feel that I am ready, and the manner in which I tested it as well, which was concern for me, was to see that I can in fact do a full term, and I've had opportunities to do that. And my test was if I can manage my full term, come out of it with all my judgments delivered, then I can appreciate the nature and the volume of the work that comes through the Gauteng High Courts.
Okay.
And I feel that at this stage I'm ready, I'm mature enough to deal with the workload, and I have the necessary competencies by acting in the High Court, and this is a wonderful opportunity to serve the public in this particular manner.
Yeah, and your list of judgments, you've listed 54 judgments. These are all High Court judgments.
Judge President, some of them I have put in relate to the Equality Court, as well as to the Harassment Court,
Yes.
the Domestic Violence Court as well.
In the Magistrates Court?
Yes, and I've indicated that.
Yes, I think it's about 4 of them.
Yes.
Thank you. Thank you, DCJ. No further questions.
Thank you, JP. Any questions, colleagues? Any questions from the commissioners on the virtual platform?
Yes, Honorable Deputy Chief Justice.
Yes,
Yes.
Is that Commissioner Bernard? Yeah, oh, go ahead, please.
Yes, Commissioner Singh also asked to ask a question, but I'll go ahead. Good day, Judge, or at least, acting Judge. If I could ask you just on your IT, I see on form, paragraph 5 of your form, you're also involved with creating for the South African chapter of the International Association of Women Judges, the website, if I read correctly. So maybe just tell the Commission about your intellectual technology background or knowledge, please. Thank you.
Thank you, Commissioner. Well, I must say that I am fairly savvy with electronic media now. I type all of my own judgments. I think through my fingertips now. It's a skill that I learned a long time ago. In respect of the Women Judges website, it was a wonderful initiative that we had, but it needed to be upgraded and upskilled, and that is what I worked on. It is a website that is managed by the DOJ, so I have had the assistance of the director there to have whatever matters that I wanted to have put onto that website to be uploaded. But yes, I've completely enjoyed doing that initiative. It was something that I did not have any particular IT expertise or development of how to do these amazing things that are now done on a virtual platform, but I learned, and I upgraded all of the information that is on that website. I've also included, during my period on the Women Judges Association on the executive, I produced 16 newsletters covering all the events of the Women Judges Association during that 4-year period, and all of that has been uploaded on the website. So for me, it was a learning curve, and I learned and adjusted. Thank you, Commissioner.
Thank you, DCJ.
Thank you, Commissioner Bernard. Commissioner Singh?
Yeah, thank you very much, Deputy Chief Justice, and good morning, Ms. Frances Subia. You mentioned that you served on the Domestic Violence Court and the Equality Court. Now, what role do you see, if any, that courts could play in eradicating or reducing the scourge of gender-based violence in our society? That's my first question.
Commissioner Singh, thank you for the question. In regard to the scourge, which is actually a pandemic in our country with violence against women, it is unfortunate, but my view is that more women on the bench will send a very positive message out to the public, as well as the fact that when there are more women on the bench, it will create this particular situation that will have an impact in the sense that women will see that there are women on the bench and they are concerned about their particular plight, and in that particular way, it will have an impact to improve the position of women, because women understand women's issues. And one of the issues, especially in the domestic violence courts, I think it's a wonderful initiative. It's an initiative that, in my personal view, from working in the domestic violence courts, I think the interim orders as well as the final orders that are made in these courts have a massive impact. Yes, there are some very unfortunate situations that still emanate. So my view is that more women on the judicial bench would be a positive thing in the eradication of violence against women in our country. I think you also mentioned the Equality Court. And at some point in our country, it appeared like the equality courts were deemed to be a white elephant, but a lot of more media attention on it, and the fact that the processes are made easier, it's accessible in the magistrate court. I think once again, those particular issues that safeguard our human rights that are championed in our Constitution also has that manner of coming before our courts and to provide the proper solutions or orders that can grant relief to women in this regard.
Thank you. I think you mean women understand women issues better than us men, and I agree with you there, if that's what you mean. My second question, and the last question, is you cite in your documents that you remember the Sri Satya Sai International Organization. And it's an organization I'm very, very familiar with, knowing the humanitarian work that they do for millions of people around the world, let alone for thousands in South Africa. And I think the human values approach to this organization and its teachings, has that helped you in any way as you sit on the bench as a magistrate or a human being to develop your thoughts on being fair-minded, etc., etc.?
Commissioner, absolutely. I align the human values program that is spread by the organization with the human rights that are entrenched in our Constitution. For example, human dignity. That is a human value. And this is something that has been recognized in our Constitution. And therefore, I would say that the values also that are taught by the organization, without doubt, I think makes me or contributes to me dealing with matters in a fair manner, as fair as I can be. It also makes me conscious of the social context of the people that come before us. And administering justice in a country like ours is a huge privilege, an honor, and giving, or rather really hearing at grassroots level the issues that people, or the disputes that people have, and having a role to play in that, in assisting people to realize their rights and have their disputes resolved, is one of the most wonderful ways in which to serve, and it is something that I have learned through the values emanating from the organization. Thank you, Councillor.
And I think you would liken it to Ubuntu Butu that we refer to in our own country.
Yes, and the issue surrounding Ubuntu is actually that we are all human, and it is our humanity that makes us one.
Thank you very much, Deputy Chief Justice. Thank you.
Thank you, Commissioner Singh. Commissioner Pillay?
Thank you, DCJ. Good morning, Mr. Bia.
Good morning, Councillor.
One of the key aspects about transforming the judiciary is ensuring that we have a proper pipeline from the magistracy to the high courts, where presiding officers in the magistracy are able to act in the High Court and eventually make themselves available for appointment to the High Court. I think it's important to ensure mobility, firstly, but secondly, it's an important transformative tool to ensure that the High Court is properly reflective. Can you just tell us your experience? Are there any obstacles to people getting selected, firstly, for acting appointments? And secondly, what needs to be done in order to improve that pipeline and to ensure there's proper mobility from the magistracy to the High Court?
Thank you, Councillor, for that question. In fact, it's a very important question for us to consider. In that respect, I would say that I have noticed that acting appointments are given to magistrates as well as advocates and legal practitioners who are attorneys. That is in terms of the Gauteng Division. So whenever I've acted, I've seen a widespread, and I have been very pleased to see that there are a number of magistrates have been given the opportunity to act. I think there are certain tools that are in place which are welcomed, and in this regard, I can think of SAJE offers an aspirant judges course, which you have an opportunity to apply for. So as a magistrate sitting on a bench, you are invited to apply. When you apply, you are interviewed, and from that interview, a selection is taken, and then you're given the opportunity to attend the aspirant judges course. And that is a course that is lectured or tutored by judges who are on the bench, judges coming from the High Court as well as the SCA and the Constitutional Court. And that gives you also a preparation, a ground to prepare for your acting stints. Thereafter, of course, I think it depends on the judge president who invites you to come and act. I'm not particularly sure. I would assume that once a judge president is aware of your judgments and aware of the kind of work that you can do, then you are invited. So my thinking in regard to the mobility would be that at the level of the magistracy, recommendations must be met. There are a number of competent magistrates who can do the work and will excel. In fact, we can see that there are many competent judges in the high courts as permanent judges who started off being magistrates. Thank you.
So can I just ask, it's a bit concerning that this would depend on who you know, whether or not an invitation is extended for you to act. What's the scope for a magistrate being invited to act? Is there bureaucracy involved, or does it really just boil down to who you know ultimately?
Well, I think it applies across the board by virtue of the fact that one would, to be invited to this particular interview, I had the opportunity to act. Had I not had the opportunity to act, I would not be invited here. So similarly, I would say that in the magistracy, the fact that there are those opportunities to go on those particular courses, and that you are only allowed to attend the course once you have attended a particular interview. So perhaps, I'm not sure in regard to whether automatically, if you were to say, I have sat 20 years on a bench, or I've sat 10 years on a bench, automatically I should get the right to go and act in a high court. I think perhaps those are considerations that one must take into account, and if it means that we have to put a process in place, then it is something that we ought to deliberate on.
Thank you. I think it is something we ought to deliberate on. Thank you.
Commissioner Nokes?
Thank you, DCJ. It's just two questions. One, how a trial court must approach the evidence of an expert in a trial?
In my view, the manner to approach an expert evidence would be, firstly, it depends on the complexity of the matter. If you're sitting in a matter that is going to run for 10 days, and if I may take an example, perhaps a medical negligence matter, then one would have a number of experts. You could easily sit with perhaps 12, 14 experts. The best approach would be that you have joint expert reports, and that these joint experts then in fact deal with the pertinent issues that remain in dispute. Having read those reports, right, it becomes quite clear what would be the issues in dispute, and those issues in dispute then will have to be dealt with in the trial. And my view then is that is how one ought to deal with the expert reports or experts in a trial matter. Eventually, it comes to a point where you will hear the experts on those particular issues, and you will make decisions in regard to which issues that you may agree with, what you may disagree with, and what you will take as binding or important in you making your final decision in the matter.
Well, I hear, but my point was the expert has given testimony. He has evidence before you. How do you treat that evidence? I thought you just answer, how do you treat the evidence of this expert? He has testified. Is that opinion, the opinions of that expert, the conclusion, are they binding to you as a court, or how do you deal with it?
All right, once you hear an expert on an issue, remember the expert can be cross-examined by the opposing party. And then there's a re-examination. So in regard to the problematic issues, you've already dealt with them. And yes, the court ultimately makes a decision. It's not that if in fact an expert comes and gives an expert opinion, and the court has to now decide whether it accepts that opinion and the reasons why it does, or whether in fact it rejects that opinion.
The last question. In a trial where the court is conflicted, is confronted with conflicted versions of the witnesses, the plaintiff and the defendant, and the evidence is equally balanced, is conflicting, is mutually destructive, how the court must treat that evidence, how the court must resolve that dispute.
Okay, there's two ways to look at it. One would be from the perspective of if you're dealing with an application proceedings, and when you are dealing with the trial proceedings. In an application proceedings, if it is completely conflicted, you have an option to refer the matter to hearing of evidence. If it is a trial matter, then in regard to the conflict, the court can move through different stages, and one of the stages would be to make credibility findings on those particular aspects or factors that come before the court. So that in effect is how a court may deal with a dispute of factors in a trial matter.
Thank you, Commissioner. Commissioner Marungai.
Thank you very much, DCJ. Good morning. I'm here.
Good morning, sir.
I just want to ask you a question in relation to a case that you were involved in. You said with Judge David Antawolta, Buthelezi versus Minister of Police. You remember that case?
Yes, I do remember the matter.
I found it very interesting when I was reading it.
Yes.
Because as I understood it, it was a delictual matter, but a delictual matter. In other words, a police officer or the state was sued for unlawful entry and all those things. Yes. It was a delictual matter, and the defense was rooted in the Criminal Procedure Act. What I want to find out from that case, because I could not understand how the search in that particular case, you found that it was unreasonable, while Section 26 of the Criminal Procedure Act clearly provides police officials, when they reasonably believe that a particular person who has information in relation to a particular crime can actually assist for them to enter the premises. And I just want you also to assist me with how you use the right to privacy and the best interest of the child to come into play. I was just confused as to the interplay between all those things in light with this section that I've just spoken about. Thank you.
Thank you, Councillor. In regard to that particular matter, what was interesting is that the plaintiff sought that he had a right to privacy, and the police had invaded his right to privacy by searching his house. And Section 25 and 26 of the Criminal Procedure Act empowers the police in specific circumstances to search without a search warrant. Now, what the interplay was, and what we found was that, yes, they did have the right to go and search by virtue of the fact that it was in the best interests of the child. The child went missing. The child was missing for more than a day, and the child was last seen at that premises, on that property. And that is what gave the police the right to go and search and look in the house. And to that extent, the plaintiff had accepted, he had agreed, yes, that he knows that he'd been told the public was out there and they were standing there and they were considering that they're going to be pretty violent if, in fact, the police does not get a chance to look into their house and see, in fact, if the child is there or not. Now, how the decision moved from that perspective, and where, in fact, we did, in terms of the delictual claim, we did grant the plaintiff a portion of his claim, was because while that search was taking place, another police officer came in there and he said, do you have a license to trade in liquor? So the idea being is that the police were only granted the right into that home by virtue of the fact to look for this missing child. And that we found as, you know, the paramountcy in the Constitution, the best interest of the child is paramount. And in that respect, yes, the police could go in and search. But in regard to this other police officer who now came and said, yes, you do run a shebeen here, but do you have the license, the liquor license? And on that portion, we found that indeed that police officer did not have a right, and he invaded the privacy of the plaintiff and therefore found for him on that portion and granted him, I think it was 30,000 or something.
Yes, it was 30,000.
Yeah.
No, thank you very much. My last question is in relation. I've seen that in the judgment that you have given us, some of them have been delivered on the same day. Were these at the magistrate court? Are there any that you delivered at the High Court on the same day? Because I always thought that there are cases really that judgment can be given there and there. You don't have to postpone the matter and say the judgment is reserved and stuff. Are there any in the High Court that you delivered on the same day? And I think it's commendable. Of course, the question of quality of the judgment and research can come into question, but I think at times that is commendable.
Thank you, Councillor.
All right.
Thank you, DCJ.
All right. It does not appear that there are any more questions for you, Acting Judge Francis Sobia. Oh, there is one from your JP. JP Mlam.
Thank you very much, DCJ. It's a follow-up on the questions asked by Commissioner Pillay. And yes, there is some form of a process about how we source magistrates to come to the High Court. But she made a comment that it's who you know. That's how you come to act. Did you know me when you started acting in the High Court?
No, Judge President, I had no idea who you are. I did not know you. It appears like I was recommended from the judgments I had written and the fact that I used to lecture at Sajay, and I was known from my lecturing. And then I had never met the Judge President, ever known him at all, and I was then invited to come and act.
Yeah, but you agree there should be a process.
I think it would be useful if we have a process. There would be openness and transparency, and they would give other competent magistrates and people opportunities that I have been given.
Yeah, but the current process is your leader in your court makes recommendations to the JP, and the JP requests substantiation of why are you recommending these people, right? And it happens in Gauteng. But I think the questions from Advocate Pillay is that perhaps if the process has to be improved, you are best placed to ensure that there's a process that's there that opens it up to almost everyone who has an interest in acting in the High Court.
Absolutely, I agree with you 100%, JP. And I think I'd also like to say that I have not acted in other divisions, but I've only acted in the Gauteng Division. And I want to reiterate that every time I have acted, the acting judges have come from the magistracy, from the attorney's profession, as well as the advocates. And that can only be because they've been invited by the judge president.
One last question, DCJ, and it's related to this. At some stage in Johannesburg, amongst a number of members of the Johannesburg Society of Advocates, the South Gauteng High Court was called the South Gauteng Magistrates High Court because of the number of magistrates who were acting in the High Court. I'm putting that to you deliberately because you sat in special motions and you would have had silks appearing before you. I've had a number of feedback from magistrates, especially magistrates from the district court like you, who detected some form of, I don't know, negativity towards them from silks. What was your experience?
Well, I have never had the same experience. I've always been well received.
Yes.
And I think I've found counsel from silks from all levels have treated me with the required human dignity that is accorded to a judge.
Thank you. Thank you. Thank you, DCJ.
Thank you.
All right. You are excused, ma'am. Thank you so much for presenting yourself for the interview.
Thank you, Justice Maya, and thank you for the opportunity. Thank you, councillors.
Good morning, Advocate Holland Motor.
Good morning, Deputy Chief Justice. Good morning to the commissioners.
Are you comfortable?
I am now. After a 3-hour traveling from Pretoria and the traffic, I'm comfortable now. Thank you.
Gauteng traffic.
Yeah.
What can we do? You hold a BUris and LLB degrees.
That's correct.
Which led you to work with the Department of Justice, first as a clerk, then you became a prosecutor, magistrate, you taught at some stage, and in 1998 you joined the Pretoria Bar.
That's correct.
And that's where you still are to this day.
Correct.
All right. You have had numerous judicial acting stints in the Gauteng Division, both in Joburg and Johannesburg and Pretoria?
Mostly in Pretoria, but I also one term was acting in Johannesburg, but specifically in the criminal court there.
but you started acting in these courts in 2015 and have repeatedly went back.
Correct.
And the last stint ran until this past June.
Yes, but which is also not on, because I acted now 2 weeks ago in the recess at the request of the Deputy Judge President. I assisted in the past recess as well.
All right. Well, I'll leave it to your JP to flesh out what
Yes.
you did during those acting stints. As I recall, you've previously been interviewed for a vacancy in this same division, not so, in 2019, was it?
Sorry, can you just repeat?
You previously came before this commission for an interview for a vacancy
Yes.
in this division.
I have been here on 3 occasions.
Oh, 3 times?
Yes.
I recall, when was the last one? In 2019?
The last time was in April of this year, but for
I was
the
not
Limpopo
here, that's why I
division.
don't recall.
Yes.
Well, I'm aware of the 2019 one, and my recollection is that you had a fairly good interview, and the only real quibble then was a paucity of judgments which you have produced despite all these opportunities you've had to act.
Yes.
Has the number of your written judgments increased since that interview?
Yes.
How many written judgments have you produced so far?
In total, my reserve judgments from when I started was, it's about 68. I have no outstanding judgments. There were plus minus 15 to 20 applications for leave to appeal filed, of which only 2 were successful. 5 were, my judgments were, 4 were upheld in the Supreme Court of Appeal. So in total, there's only 2 judgments which was overturned.
All right. I'll leave it here for now. Commissioners, JP Mlambo, do you have questions for your candidate?
Thank you very much, DCJ. Good morning, John.
Good morning, JP.
I got it right. It's not Johan, it's John.
It's John, yes. and if I may say, we're not going to discuss the Gunners and Man United at this stage.
No. No, that's off the table.
Yeah.
You've acted for a total of 14 weeks in the opposed motion court.
Correct.
And that's a court where you would pick up reserve judgments.
Mostly there, and also from time to time on the urgent court.
In the urgent court. And you've set for, I think it's, in the urgent court, you set for a total of 6 weeks.
Correct.
Now, you've acted for a number of longer stints where you would have allocations in the urgent court or post-motion appeals.
Yes.
Am I correct?
You're correct.
How were you able to handle that? Because all those are heavy-duty courts.
May I say, JP, you learn, if I take it from the beginning where I started in 2015 up until now, you learn to be more productive and to manage it better.
Yeah.
Fortunately, your opposed motions is normally a week in advance, which is being allocated to you by the senior judge. And then it's not a 9 to 5 work. In the afternoons and the evenings, there were evenings where you toiled through your opposed motions to prepare, late past midnight, just to go to court prepared, because it's a firm belief with me, you don't go into any court, especially the opposed motion court, unprepared. So you have to do it after hours, yes.
Yeah. And have you had occasion to sit in full courts,
yes,
appeals, and did you write those judgments?
Yes, I've written 2 of the 3 judgments in the full courts where I sat.
What was the feedback from the presiding judges?
The last one now, Judge Kabushi didn't even change a comma in the judgment. She was totally satisfied. The first one, it was with Judge Potterell, and she made 1 or 2 adjustments style-wise, and the others where Judge Corrie van der Westhuizen was the senior judge, there were 1 or 2 remarks he made, but in general, no serious changes were made.
Yeah. And I just want you to tell the Commission why you've acted so long, because I've had a chat with the DJP, and am I correct that you've written to both me and him to say, should we run short of judicial capacity, like a judge falls sick urgently, we are welcome to call on you to come and assist?
When available, yes.
Yes.
The reason why I'm doing that is because my practice as a counsel, as a senior counsel, it has changed from the beginning, where you do unopposed work, where you get unopposed matters almost every day. While if you go, as your practice changes to be a practice of long trials, long opposed motions, you get it in advance so you can see where you are available and then avail myself if necessary.
Yeah. And you've acted in all the areas of the High Court, am I correct?
Correct.
Except for the tax court.
Except for tax court, yes.
Right.
Correct.
And I want to thank you for giving us that opportunity to run to you should we have problems. The minister is here. He knows how many sick leave he's granted to Gauteng judges.
Yeah.
And when we're desperate, we know where we can go. And it's not only yourself, but I want to thank you. Thank you, DCJ.
I may just add, JP, there was one request now about a month ago where Deputy Judge President Ledwaba contacted me on a short notice. I was not available because of personal circumstances. My wife was in a serious gas explosion, and I had to attend to her, so I was not available then. But on the other occasions when I contacted yourself or by Judge Ledwaba, you have the freedom to arrange with your attorneys to see where we can fit in.
Thank you. Thank you, DCJ.
Thank you, JP. Commissioner Dudu.
Thank you, DCJ. Good morning, sir.
Good morning, Commissioner.
What impressed me about you is that you seem not to give up. You are determined. It is for the 4th time now since I was part of this commission that you are here.
Correct,
Yes,
Commissioner. And the reason
don't
why
give up.
I want to serve my country, and I feel in terms of the Constitution, if I have the opportunity to serve my country further in this capacity, I would like to do it.
Now, can you share with this commission, 3 times you are unsuccessful and you are here again. What is the difference? What improvements? What are the things that you can put on the table and say, this time around, I'm geared up, I'm ready?
Well, Commissioner, the first time around, and I suppose, and I don't have statistics about that, very few white males are appointed first time around. And it's also the availability of posts. If you were at all the interviews, you would recall that the recommendations made by the different parties, starting with the GCB, the Law Society, NADEL, Black Lawyers Association, nobody questioned my capabilities. The reasons, and the last time around for Limpopo, the reason was, and you're not forwarded with reasons, but it was clear because of that. It was only 2 posts, and it was a lady and a black fellow colleague who was appointed for the representation. And I accept that. There was nothing wrong with my application as such. But to answer you further, from 2015, if I look back today, I've seen a huge growth in myself, my confidence, the quality of my judgment speak of that there is a vast improvement. Not that they were bad in the beginning, but with experience you grow. So I've gained a lot of experience. I'm comfortable, and if appointed, with my vast experience, and I expect that there will be a question about that with regard to my age, experience and wisdom can be fused with younger appointees. I have experienced it the last year or so, that even newly appointed judges approach me from time to time just to be a soundboard. And specifically Judge Makoba, when he approached me, he said, can I tap your wisdom in a specific matter?
It's okay, it's okay. Now, lastly, can you convince me that when I sit down, really considering you for the appointment to the bench, what is it that is exceptional that I must look at, considering one, your age, you are 66, and I'm looking at the composition of this division. Out of the 76 judges, 30 of them are white, 15 white females and 15 white males. What is it that you think is exceptional about you?
Exceptional about me is my vast experience. I also know that one of the white males, and the JP can confirm that, Judge Fourie is retiring at the end of the year, and Judge De Vos is not far away from retiring. So I have lots of skills, particularly if you look at my experience, criminal court-wise, and there's always a need for experienced criminal law presiding officers. So you get my experience, and you get, if I can quote the words of Judge who contacted me last week, the wisdom which comes with experience.
Thank you, Deputy CJ.
Thank you.
Commissioner Nyambi?
Thanks, DCJ. Morning, Advocate.
Good morning, Commissioner.
Todove has covered my first part. I'm going to ask just one question. As somebody that has acted for quite some time in Gauteng Division, probably if you can share with us a critical challenge that you think you'll address should you be given an opportunity to be a permanent judge in that division.
One of the challenges at this stage is the proceeding from hard copies to electronic copies in court, the case line system, which under the guidance of our JP, in my view, is functioning good, but there are some hiccups. One of the major things is to assist, which I've done now in the third term with an acting judge, and she battled because of lack of experience with how to proceed with all the directives which are there. And I could assist her on a daily basis when she came to my chambers and asked her. So if you appoint me, you get a lot of knowledge, but you also get the ability to assist people with lesser experience. In view of my past as a part-time lecturer at the universities, as a lecturer at the Justice College, and the 16 ongoing years I've been involved in the training of pupils at the Pretoria Bar. So I'm always open to assist, and every system can be improved, so yeah, that is, to see that the court in Gauteng runs even more sufficient than it is at the moment. To try and come with, and it's difficult to give you examples without being there at court where a specific problem may arise on a specific day. But there are issues which can be addressed, and with the open relationship I have with the JP and the DJP, can discuss it with him how to assist.
I'm tempted to ask you the last one. What might be your weakness?
Sorry?
What is your weakness?
My witness.
Your weakness. What is your weakness?
Sorry. The acoustics. My weakness is that I tend to, maybe it's a weakness, I tend to work too long hours, and maybe then from time to time come too late at home. A weakness which I have is that, and I was accused, and the JP knows, she was my master when I started pupillage, Judge Tolmay. She accused me of still having, and the Afrikaans is staatsdienstmentaliteit, because I'm in chambers just past 7 in the morning. That's a weakness. If I compare myself with many of the other colleagues there. It's a weakness to be there too early, and I was unfortunate in one occasion. I left the court. As I came out of the court, the JP was also in court on a full bench, and we walked into one another. It was after hours, so it's a weakness, if you can describe it. No, I don't know of other weaknesses, supporting the wrong teams or so, off the record. That may be so, but no. I have a passion for children. That you can see as a weakness, that I'm overprotective towards children, to young people. You'll also notice out of my application, my involvement with the Jacaranda Children's Home, where there are, in our house, which we administer, 12 young boys, of which at this stage 8 are black boys, which we're trying to rehabilitate and to put back into community so that we can keep them and make of the useful citizens. So a weakness is, yes, my preference for children.
Don't worry, we support the same team. It will come right one day. Thank you, Advocate.
Thank you.
No, we support the same team. It will come okay. Thank you, Advocate. Thank you, TCJ.
Thank you, Commissioner Nyambi.
Thank you very much, DCJ. Good afternoon.
Good afternoon. Yeah, it's past.
I have 2 questions for you. The first one is in relation to, I see that you have said in some of the reviews that came from the magistrate court in relation to the decisions of that court. Of late, there have been a lot of decisions from different divisions of the High Court where the quality of the responses from magistrates and the delays associated with that, and lack of compliance with the time frames in Section 303 of the Criminal Procedure Act have been lamented by the judges. How can we solve that? Because that goes at the heart of the accused person's rights in getting their issues, their appeal heard and all those. How can we deal with that?
Commissioner, and yeah, I'm going to refer back to the first time I met the JP, before I started acting, it was at the quarterly PEC meetings, and there all the role players were together. That is one of the forums where this can be addressed. You have a problem, and that is a mindset problem with the greatest respect to many colleagues in the lower courts. Because of the independency of magistrates, you can tell them nothing. I've seen that in my own experience when I had Section 304 reviews in chambers, that you get the response either late or improper response, and you have to send it back again and again and again. Yes, it's to the detriment of the accused person. There must be better cooperation, and the JP may decide in his wisdom that somebody is specifically appointed to address this on an ongoing weekly or monthly basis. What we had in the previous dispensation, when I was in Witbank and Magistrate, I was also an assistant prison warden. Because of my duties, I had to go to the prison once a month to go and see what was wrong, to have interviews with inmates, and to see how we can assist them in the process there. And maybe it is something which can be addressed, is that there is a better or a new communication channel with the various chief magistrates so that you have it under your thumb.
No, thank you very much. My second question to you is, and you are coming from the bar, which has been on the news over quite some time, but we are not going to get into that. There is an outcry in South Africa that we have a lot of female graduates, law graduates, who some of them go into the bar. But for some reason, we do not see these female advocates being partnered with more senior colleagues doing the juicy work, right? Your pension law, your insolvency law, your competition law. We don't see a lot of them doing that kind of work. Obviously, we'll see white male, then we're going to see white females, then we're going to see selective black male, who are the usual, right? In your practice, what is it that you have done, if at all, to ensure that those females, black females in particular, are given the, because I don't think it's much an issue of training. I think it's more about opportunities, because training goes with experience and opportunities that you are actually being afforded to. What have you done in your practice to try to assist these black females to be able to get another lift for them to progress in their career?
Commissioner, you would have seen out of my application is that in my capacity as the chair of the pro bono committee for many years in Pretoria, I roped in specifically black females, quite a number of them with me. I take pro bonos and then take them with me to expose them and to expose them to attorneys. I have also a system in place, being on the training committee of the Pretoria Society of Advocates, is that in March, when the different groupings are done, and a group is allocated to 2 juniors and 1 senior counsel to work with them during their practical workshops, I identify there specifically black females with potential to take them and to monitor and to guide them through the year, through their training, and then also to introduce them to some of the attorneys which I feel will help them so that they can get junior work. I have the last one, it is not a black person, it's a white person who's totally blind. And I assisted him through his pupillage. And I sat with him so that he could prepare his application for his admission. And I had one of my attorneys to do that for him free of charge. And now he's doing some of the unopposed motion work, which I said, give it to him or give it to 1 or 2 of these black ladies. I've done that in the past, and I will continue with that. If I'm appointed, I will continue with my mentoring role at the Pretoria Society, and I've also been approached in the last 2 months by the Tshwane Society of Advocates, by my good friend Mosampaga SE. As soon as they are accredited to the LPC, is that I'm going to assist them with training there as well.
Thank you very much. Thank you very much, DCJ.
Commissioner Pillay?
Thank you, DCJ. Good afternoon, Mr. Hollenmutton.
Good afternoon, Commissioner.
Just to follow up to the questions that were asked by Commissioner Marumo Wachai, in your application, you deal with the Transformation Committee, and I think you specifically deal with this initiative that you referenced now, where you bring what seems to be extremely junior people on board on a fee-sharing arrangement where you sacrifice a portion of your fee so that they can be paid to work on the matters which you say they otherwise wouldn't be exposed to.
Correct.
Which gives you the impression that this is an initiative designed more to expose juniors to work rather than a typical senior-junior situation where you rely on your junior to actually do work. I don't know if you're getting the distinction I'm drawing.
I follow what you say, is no. It is twofold. It's to expose them, but also to ask them to do some of the initial drafting of papers, etc., so that they can get acquainted to that and that their self-confidence can grow. In May of this year, I was in the SCA, it was a white junior lady which I took with me, and I asked her beforehand to do the most of the research, and I just went through her after the drafts, the heads were drafted and so on, to see and to correct and to explain to her why I'm doing that. So yes, it's not only to help them financially, but that's necessary, but also to give them exposure to develop themselves and to be introduced to attorneys.
Now, that would be comparable in the ordinary situation to what we in Johannesburg call the third counsel rule,
Yes.
where we would create a position for a third counsel to meet the kind of objectives you're referring to. I'm more interested in your first junior. Now, how many juniors have you worked with where you've had a fully fledged junior being a black woman or even a black man for that matter?
If my memory does not fail me, it may be 3 to 4 who I took in on full briefs. The others were out of my own initiative to expose, or to have these people exposed to this and to be introduced.
So you're saying that you've only ever worked with 3 black juniors?
No.
In the first, can I just finish
on full brief. On full brief,
yeah. I just want to finish my question because it's an important distinction.
Yeah.
And it's a distinction we've tried to draw over and over again because we know that it's the go-to position to create a role for a junior for exposure purposes. So I'm going to describe that as a third junior role. I'm really looking for information on when I get briefed on a matter, I pick my juniors, and when I pick them, I pick people who I know I can rely on and who I can depend on to run with the matter, and I give strategic input. That level of junior.
Yeah.
And you're saying that you've only ever worked with 3 juniors on that
3 or
basis.
4, if my memory is correct, but those are whom I've identified during their pupillage to work through, to mentor them. I do not leave them at the end. I take them, and where possible, if there is such a brief, and with the consent of your instructing attorney, I take them in. So I start with them during pupillage, and I take their hands further.
Now, may I ask why that number is so low? It strikes me that 3 black juniors is an extremely low number. Just to give you context, for example, and I don't want to compare apples with oranges, but I'm really just giving you context. At the Johannesburg bar, if you were making an application for silk, we would look at a number under 15, for example, to be low. So can I just get a sense of why that number is so low, why you haven't worked with more black juniors in a working relationship where you rely on that junior to contribute to the matter?
The simple reason is it depends on the briefs which you receive. Pretoria and Johannesburg are worlds apart with the kinds of brief. Commercial briefs are far, far more in Johannesburg, and you have the opportunity to do it there. Many of my briefs where I take these people in are RAF matters where I don't need to do it, but I do it because I want to assist and I want to expose them. So it's a different situation with regard to the kind of brief which you receive.
So when you say these people, you mean the black juniors you've referred to?
Which I draw in. Most of them, yes.
And how many white juniors have you worked with?
2.
So you've only ever worked with 5 juniors?
No. I've worked with many of them on a pro bono basis, but on a brief matter, it's about 5 to 6 on full brief. Then there were 4 or 5 which I took in, and I shared my fees with them. So in total, it should be more than 10, but I didn't keep record of it. I'll have to run through my memory for that.
And final question, the matters where you worked with black juniors, those were RAF matters. Is that what you're saying?
Most of them, 2 of them were unlawful arrests, where it was black juniors. We're busy with one which we're preparing the documentation, all the pleadings for a leave to appeal, which it's a colored junior and a black junior who I'm assisting. They asked me if I can assist them. I said, you go on, I will assist you. I'm coming in on pro bono. I'm not going to charge you a fee. The full fees will be shared between you 2 guys.
So can I just understand the 3 matters were matters where black juniors brought you in as the leader?
About 3, 4 matters.
So it's where you are brought in by a black junior?
By junior, where I've been approached, but then there were matters where I take them in. So in total, it must be at least 10 with whom I've worked in a senior-junior relationship.
Thank you, Chief Justice.
Commissioner Magwanisha.
Thank you very much, TCJ. Good afternoon, Advocate Mata.
Good afternoon, Commissioner.
Mine is a follow-up from what Commissioner Nyambi raised. My observation is that you have identified, you know your witnesses, but I don't see any commitment from yourself to look at those or to change or to improve yourself on those weaknesses. It's important that we must always strive from developing from being hard workers to be smart workers. Judges are very important in the development of our society. Now, from my observation from your response, and I think if my memory serves me well, it's not the first time that that question was asked to you, is that there is no time that is being made or concerted effort on your side to do strategic reflections. And the issue would be, how will you develop society if you don't do strategic reflections? And you seem to be fine with it. Your comment, please.
My comment, Commissioner, is that, yes, I do planning in my preparation. I strive towards working smarter, but working smarter does not mean you have to work at a lower input of take-in of all the necessary reading, which is as you're supposed to do. I work towards it, better managing myself so that I have more time available to develop. At first, when you start, you read everything. You read everything every letter. You start to develop by preparing smarter. To go past in thick briefs, to go past the normal notices which are not important, but which is just correspondence between the parties. In the beginning, you go through that because you may be afraid that something is hidden in that, but you develop a system to read what is important, and then it is to develop to work smarter. Yes, I do that.
Thank you, TCJ. Thank you, Advocate Mata.
Thank you.
Thank you, TCJ. Good morning.
Good morning.
Well, it's the afternoon. Good afternoon.
Good afternoon. That's fine.
Can I just ask you one question? It's sort of related to Advocate Pilay's question, but on the other side of the coin. My anxiety is to see that the candidates that apply, some of them may be white, of course, because this is a multiracial society, but I want to see that they have a commitment to transformative adjudication. And the reason for that is because South Africa is one of the, well, actually the most unequal society in the world. And our constitution says equality is at the heart of the constitutional enterprise. Now, I've been looking in vain to find your approach to adjudication that shows commitment to applying constitutional values. And I sort of thought maybe it's the cases you got, maybe it's the place where you were, and I just can't find any grasp of your commitment to transformative adjudication as a judge, so that we can say, all right, yes, he's white and he's 65. But he has an impeccable record in transformative adjudication. And quite frankly, there's just nothing on your record. I just want to put that to you so that you can look at it and comment and say, I'm wrong.
Thank you, Commissioner. Yes, the one observation which you made, it depends on the type of cases which is allocated to you. Not all cases has a premier question to be addressed, that is a constitutional issue. But all cases must be done in terms of the Constitution. So, because I only appeared in the Constitutional Court on 2 occasions, it does not mean I do not uphold the Constitution. My commitment to that is, and if you read the nomination letter by Mpaga Essie, my role in transformation from the early 80s, where I started. As a judge, your duty is first to adjudicate what is placed before you. And if there's no specific constitutional question which had to be dealt with, then there's no need. But if there are, then you address them in the judgments. And there were issues with regard to the rights of children, which I've addressed. There was one matter which, with the consent of the acting Deputy Judge President Pottrell, where there were 6 different opposed applications between the two parties, the mom and the dad. I asked her whether it would be fine if I consolidate that so that we can do it and handle it. And yes, you have to consider the Constitution and all that, because it affects the rights of access of the parents to the children, but primarily the rights of the children. So indirectly, most of my judgments, there will be evidence of the upholding and the commitment which I have towards the Constitution.
Sorry, if you don't mind, if I can just follow this up.
Yeah, you're welcome.
Because I think your answers creates more problems for me. Look, I'm not going to criticize you for, you say, well, you've done transformation, I must look at all of these black juniors you've trained, etc. That's fine. That's what Commissioner Pillay was asking you about. What I'm looking at is the mindset. It's the fact that when the cases come, the judge knows that they are bound by Section 39(2) as a starting point to approaching every case. What I'm struggling with is this idea that no, if no one raises a constitutional issue, it doesn't arise. In fact, your answer says, if no constitutional issue is raised, then I don't have to apply it.
No. It's with respect incorrect.
Yes,
If there's no specific constitutional point raised, it does not mean that I have to apply the law in terms of the Constitution. I continue with that, to give them a speedy, a fair trial with everything which the Constitution requires from me. But if there's not a specific question where the constitutionality of a specific regulation or so is at stake, there's no need to go into that. You have to consider the workload which a judge in the Gauteng Division has. So if it's not a specific point, you're not going to belabor that. But underlying all my judgments can be measured against the Constitution, and you will find that I am following the Constitution as for in each and every instance.
All right, thank you.
Any questions from the, yes.
Just to follow up, is it possible for you to give us an example of a judgment in which you do that?
A judgment, one matter was in the specific Detroit matter where the mother brought an urgent application, that is the third application. What she called is to set aside the judgment by my brother Malmela with regard to, it was the passport which was authorized for the father and his parents to take the child on a cruise to the Portuguese islands. In that, you have to look at what are the rights of parents, children leaving the country. Isn't there anything of personal, minor children being trafficked, etc., etc. So you have to go and look, and you have to go to balance all the rights, which is enshrined in the Constitution, whether it's the parents' rights, whether it's the juveniles' rights. You have to look at that. You have to, there's another matter which it was 4 applicants, which was a consolidated application report. It's in my bundle as Rensburg and others, where they entered into contract with the vocational training contracts with the principals, but they did not disclose that prior to entering into that, they were involved in other schemes in which they earned a living. Now, if you look at the regulations of the LPC, they have to disclose that to the LPC before they enter into that. Now, it is a question of this person's right to earn a living, and you have to compare it with the compulsory provisions of the LPC, whether he has to obtain that permission before he enters into that. The ultimate is that when it was disclosed, the LPC asked for guidelines on that. And I gave a guideline and said, because it's disclosed at this late stage, it's not for the principal nor the LPC to condone it, but it's for the court to have a look at it, whether the training which they underwent was not jeopardized by these other activities. The one instance, the guy was assisting his mother as a bookkeeper in her real estate business, etc. So you have to balance the right on the one side of the public right in the administrative law, in the LPC, also with the right to earn a reasonable living, a constitutional right. But there are limitations on it, and that's one of the limitations which they should have adhered to before they entered into the agreement. So there are many aspects which we can go through each and every judgment if you want to.
Thank you.
No, I'm sorry, Chair, I do need to follow up on this because these two judgments that have been given really do create problems. On the first judgment, you say that you applied the rights of parents.
After considering the rights of the child.
Yes, but I'm talking about the rights of the parents that you mentioned. Are they in the Constitution?
Every child has the right to be properly taken care of, firstly by his natural peers, or then by all the others which you find there. That the child has the right to proper taking care of board, lodging, etc., etc. So there's the converse thereof, that the parents also have certain rights and obligations towards their minor children.
Then on the second one, you say the rights you were engaged with were the rights to earn a living.
Yes.
Thank you.
The right to which I refer there to is the right of every person to follow the occupation which he wants to follow, subject to the limitations in the Constitution.
Any questions from the virtual platform?
Yes, Deputy Chief Justice.
No, thank you.
All right. You have first go.
It's Singh.
Yes. Go ahead.
Thank you very much, Deputy Chief Justice. Good afternoon, Advocate.
Good afternoon, Commissioner.
I've been in the other interviews as a panelist when you appeared before us, and I just want to refer to one response that you gave us in the last interview. When I put it to you that there was a possible collusion between advocates and between attorneys dealing with the RAF. And you explained that you had not encountered collusive conduct, but you have certainly come across widespread abuse of contingency fee agreements, which you said was at a startling 95% of the time. And you asked that, call for this abuse to be stamped out, which I think all of us fully agree with. But then Commissioner Fourie didn't quite agree with your answer. And we didn't have an opportunity to question you thereafter. Have you given thought to this answer that you've given us? And what do you think that members of the judiciary could do with any attorney or when you witness attorney abuse in RAF matters?
Thank you, Commissioner. I recall that, and you also said that it would be fine if we can talk, me and yourself, afterwards. We didn't have the opportunity. What I meant when Commissioner Fourie questioned me is that a contingency fee agreement, in my view, is there to ensure that the neediest of people have access to court. But what happens, not at much at this stage, but what happened a couple of years ago, is that 95% of RAF matters were done on contingency fee agreements. But the moment there is a merit order, in my view, there's no longer justification for a contingency fee agreement. Because, and that is why myself and Commissioner Fourie differed from one another. I'm not denying anybody access because they're already in court. They have an order. So, and I've taken this up with Judge Jody Collopin while he was still in Pretoria, and he's on the Rules Commission. And he said it's an interesting point, and I'll have a look at that, is that after a merit order has been granted, why is there still a need to have a contingency fee agreement where they charge double fee or 25%? whether they can just continue the normal, because they are in court and they have a merits order which they will get their normal fee. So if that can be taken into account, it can save, in my view, I may be wrong, but it can save the RAF vast amounts of money, because they're no longer going to pay 100% or double that, or 25% of the award which has been made. And I know of one or two instances where the award is made, they take the 25% attorneys and they also take the full tax account. I had one matter where a person via another attorney approached me and we went to court. Well, it didn't end up in court because the attorney settled it as soon as the application was served on him. Because we then served an application on him for repayment of an award of 4.8 million. The third party received about 1.8. The rest was allegedly costs. We know that there was a 207,000 rand account which was taxed. And we just, because the third party and his father came via another attorney to us, and we just issued summons against, application against that person, and we cited the Road Accident Fund and the Law Society then as second and third respondents, not to take any order against them, but that they just take notice of this practice. And within a week, there was a repayment of in excess of 900,000 rand by the attorney to the client, to our client, who should have originally received that. So yes, it can be done. But coming back to that, my difference with Mr. Fourie, and I stand with it, that after a merits order, there's no justification to continue on a contingency fee agreement because you're no longer at risk. I hope that answers your question.
Just as a follow-up, I know that as judicial officers, you have to deal with the attorneys or advocates that represent clients in RAF matters. But I think just last week I read of a ruling where the client who came from a rural area was not even aware that a matter had been settled, and the legal counsel pocketed the money. Now, how can it be made easier for South Africans who have to go to attorneys to submit this claim for them to know that a claim has been settled and that they have a right to that settlement, and not wait for their own attorneys or legal representatives to let them know? Thank you.
Commissioner, that may be an administrative elephant in the whole RAF field. It may be that it can be considered is that when there's a person from a rural area, and many of them are illiterate and they don't know the difference between, say, 100,000 or 200,000 rand. I don't think the RAF has the capacity to police all this. If we lived in a 100% correct society, we could have policed that. But it's very difficult to police it. Maybe there must be some sort of investigation, is that before amounts are paid over into trust accounts of attorneys, that there's some sort of rectification or document authorization signed by the client, which was properly explained to him or her what was the amount which was awarded and when it was and so on. But yes, I hear what you say, and it's a difficult thing to root out that those clients are in many instances not informed, and then they get a settlement amount. And we are all here, literate people, but those illiterate people, they're from the far off areas, from Malamulele or anywhere else. 100,000 is a lot of money for them. Do they know the difference between 100 and 200,000? I doubt it. But this is the system, and we must find some sort of solution in that.
Thank you, Deputy Chief Justice.
Commissioner Bredenbach?
I have no questions. Thank you, Deputy Chief Justice.
Oh, what was it? Commissioner Bernard?
Thank you, DCJ. Advocate Colin Muter, could I ask you, you mentioned you worked with someone. What are the specific challenges in our court system and in the work that we have to do as legal practitioners that are faced with persons that are visually impaired?
Electronically, if we lived in a first world country, we may have the electronic assistance to assist these people. It's very difficult. Referring to this visually impaired council which I assisted, there's another lady which also did a pupillage, and I had an arrangement with another council to monitor her. And this is just a perception, not out of the law, but out of the community in general. They worked one evening during their pupillage after 5, and they phoned an Uber to take them home. And when the Uber arrived, of course, none of them, neither Brendan nor Renette, could see them. But the Uber guy saw that they had their guide dogs with them, and he turned around and he just sped off. This is the perception we have with these people. So when these two passed their pupillage, I went to the specific chambers, to Groenkloof chambers and to Club chambers, and I negotiated with the management of each of these chambers is to take in these two now newly admissioned advocates to assist them, but for a specific period, and I don't know exactly what the period was reached, that you give them a small office free of charge so that they can settle themselves, which is also accessible for their guide dogs. And about 2 months ago, I was there at Groenkloof and I paid Brendan a visit, and his guide dog, Rex, was with him in his chambers. So we have to sensitize. We have to sensitize the people that we are working with, visually impaired people. They cannot hear, or they can hear, but they cannot see what is going on around them. It is like sensitizing people to change of heart with transformation, etc. There will always be resistance against that. Not only visually impaired, but people, for instance, who are paraplegics, who are in a wheelchair. What do we do about them? Is all our courts accessible to them? No. But one of the things I learned very, very, very early with a person, a friend of mine, his son was in a rugby incident. He broke his vertebrae, and he's now confined to a wheelchair. You don't talk down to the person in a wheelchair. You go and sit next to him so that you're on the same level. It's just small things to sensitize, and that we have to do in courts as well, with the court personnel to make it accessible, the courts. We have a colleague, if I be so bold to refer to Judge Mzalele as my colleague, my sister, my friend. She's in a wheelchair. Fortunately, there's a ramp for her, and she uses a specific court. But when she has to be assisted in full court or so, then there's special arrangements to be made, so that either to the court which she normally takes, or to take the ramp, it's a mobile ramp, to assist her. So there are many things which we have to do in this country to assist visually impaired, but also other impaired persons. But it's going to cost a lot of money. And maybe if the state capture all these cases through and we get some of those monies back, it can be utilized so that we develop these persons. Does that answer your question?
Thank you very much. Thank you, DCJ.
Thank you, Commissioner Burnett. Commissioner Baloyi?
Thank you, DCJ. Good afternoon. I'm here.
Good afternoon,
yes.
Commissioner.
I'm looking at page 33 of the questionnaire, where you've listed the times that you have acted, and you started 2015, and it's quite an impressive list of 83, a total of 83 weeks of acting. Now, often counsel struggle with making themselves available to act because of work that is on their desks and the difficulty of juggling that and coming back to it. Now, I look at your 83 weeks and the fact that in 24 years of your practice, you have worked, I think you've said about 10 juniors, a total of 10 juniors on full paid briefs, if I understood you correctly. But certainly the number of juniors that you've used, less than 15 it seems, on full paid brief. And I taking into account the kind of work where you say predominantly your practice is road accident fund, and I see medical negligence as well. Now, the road accident fund work we know has pretty much dried up for practitioners. And so what I'm trying, and what I can't see from your application is then what is your practice, in fact? And the question for me is significant to get a sense of your exposure in litigating. And keep in mind when you answer that most of the road accident fund matters anyway, most of the time they get settled by far the majority. And even medical negligence, often the merits get settled and there will be conversations about quantum. We know by far the majority gets settled. With all of that, what is in fact your practice and your exposure that we should take into account in considering your suitability or your readiness to sit as a full-time judge?
Thank you, Commissioner. Coming back to the question, and if I understood you correctly, incorrectly, please correct me, is that although I have 24 years experience, it's very seldom that before the first 10 or 12 years have passed that you are in a position to take in juniors, or are you requested by your attorneys to take in a junior? So it's a smaller window in my experience. And then my acting as well, I try to focus my practice to such an extent as when I'm approached or avail myself to act, so that I can, with the consent of attorneys, move some of my matters to other times if possible, or to only act when, because of a trial practice, you're not in court every day, you know in advance, most of the times 3 to 4 months, there's a notice of set down for trial, so you can space yourself in between. No, my practice was not only or predominantly road accident fund. I did a lot of criminal work. I do other contractual work, insolvency, etc. With the downscaling of road accident fund work, I still do a lot of administrative law. I do a lot of unlawful arrests. I've been on the other side where I've been taken in twice on 2 occasions by the state attorney so that I can assist them. I have done road accident fund on behalf of the road accident fund, the work there, because the attorneys approached me, because they see you on the one side and they will also want to engage you on the other side. So if taken into account the times which I acted, then excluding your first 10 to 12 years of practice, where you very seldom take in a junior, there were times which I could fit in juniors, depending on the kind of work, and I've given you an indication of the juniors which I've taken in.
Thank you. Thank you, Advocate Holland Muta. We have exhausted the questions we had for you. You are excused.
Thank you, Deputy Chief Justice. Thank you to all the commissioners. And may I wish you well with the rest of the week and next week.
You too. Thank you so much. Good afternoon.
Good afternoon, DCJ.
How are you?
I'm fine under the circumstances.
Yes.
And how are you? And good afternoon to all the commissioners.
Yeah. You joined the Department of Justice as a young man of 22.
Yes.
And you were employed as the court interpreter.
Yes, yes. There was no money to go to varsity, so that was the only way to get employment then.
Yes, and you never left. You've been with the department until now, until today.
Yes, I never left. I think maybe I felt that I'm born to be here, so that's why I remained.
And while you were working with the Department of Justice, you managed to acquire a number of academic qualifications, all your legal qualifications, your Deep Juris, B Juris, LLB.
Yes, DCJ. I started with matric, then I managed to get all my tertiary qualifications.
And you are currently reading for a master's degree in corporate law?
Yes. In fact, it was supposed to have been finalized long time ago, so there were some hiccups along the way, and I couldn't finalize it, but I'm still going on.
Well, all the best with that. I don't know how people manage to juggle demanding jobs with lectures and all that. I could never do it.
Thank you so much, DCJ.
Yeah, you can give yourself a pat on the back. You have been a magistrate since 1984.
Yeah, actually 85.
Oh yes, 1912.
Yes.
There's a discrepancy in your application form.
Oh.
Elsewhere, you say you were appointed in 1984, but at paragraph 6, where you list the chronology, it's 1985 to 1996. I just wanted you to explain something to me that left me a bit confused.
Okay.
You have listed that you were a regional court prosecutor between 1985 and 1988.
Yes.
And then directly thereafter, you say you became an additional magistrate in 1985. Is it possible to be both at the same time?
Yes, then it was possible.
Oh, I see.
When you get appointed, you got appointed as an additional magistrate, but then they could still deploy you as a prosecutor as well. For instance, I was already a magistrate when I worked as a regional court prosecutor for a short while, and then they deployed me again back to the regional court. And that was born out of, with the dawn of the democracy, there were some problems in Limpopo in particular, where old people were attacked and banned. They were accused being wizards. So there were a lot of public violence matters, and which needed to be attended to by the regional court. So I was requested to go and prosecute in the regional court during that period.
I see. You have had a number of acting stints in the Gauteng Division of the High Court.
Yes, since
starting in 2016.
Yeah, starting 2016. Yes.
And when was your last acting stint? This year?
I'm busy now.
Oh, you're still there?
I'm still there.
All right.
Actually, I've been there since the second term.
How has your work output been during these acting stints? Were you able to produce written judgments?
Yes, I think maybe some fear was inspired on me about people delaying to deliver their judgments. So I've always been striving to make sure that whenever I reserve judgment, it's with a date, that on this particular date I'm going to deliver, which normally it was not more than a week. Yes.
All right. How many judgments estimate you'll do?
If I remember very
under
well,
your belt?
I think I've got about 41 written judgments. Yes.
Not a bad track record. Any reserved judgments, or old ones at least?
As I said, DCJ, that if I reserve judgment, it will be with a date. and it will not be more than a week, so I don't have any reserve judgments.
You have indicated that you have one parthead matter.
Yes, I've been seized with this parthead matter since 2018. It had about 13 accused persons, 7 counsel, and they are facing 391 counts. Amongst others, it's fraud. So when you have a big number, there's always something that creeps in to disturb the smooth flow of the case, and also the volume of the case itself. But now we are at the tail end.
You have been, well, you've been involved in a number of initiatives of the department. You've assisted the Magistrates Commission with a number of projects. Would you tell us a little bit about that, just briefly, highlights?
Firstly, I realized, especially when I became the head of the office in Benoni, that every other day there would be people protesting outside the court, saying that there's an accused person, he must be given bail, or he must not be given bail, you know, protesting over various things. Then I started an initiative where I came to the local law society, the police, all the stakeholders, to say that people need to be taught about what is really happening instead of coming to protest all the time and demand their own things. And I started what we used to call a justice forum. And we will hold workshops in the communities where people that were involved were attorneys, some of them were politicians, so they will help us to try and invite the members of the community to come and attend. So we'll teach them that when a person is charged with a crime, this is what follows. And then we started to understand each other, and they started to understand what was happening. And then I was appointed at the Magistrates Commission, or designated, let me put it that way, at the Magistrates Commission since 2016. And I served on 2 other subcommittees, the Appointments Committee and the Ethics Committee. And when my term expired last year in August, then I think the powers that may be, my colleagues, they felt that they still need my services. So I was redesignated from November last year. So the designation is for about 5 years. So yes, I'm still serving, and I'm trying to contribute as much as I can.
I see you've never been overturned on appeal.
Not that I know of, except that I learned that there's a certain civil matter. It was a road accident fund matter where I dismissed it, and then they appealed to the SCA, and the SCA dismissed set aside my findings, but found that the driver and the plaintiff were 50% negligent, both of them. Yes, that is the only one that I can remember now.
Oh, all right. Well, that was not a complete overruling.
I missed that, DCJ.
No, I'm saying you were not completely overruled after all.
Yes, thank you.
All right, well, enjoy it while it lasts. Your day will come.
I'm looking forward to such days, and it's a process of learning when sometimes they overturn your judgment because you might have made a mistake somewhere.
We all do at one time or the other.
Yes, DCJ.
How is your state of health?
My health?
Your state of health, yes. I ask because of what is declared here.
Yes, it's excellent.
All right. If it's excellent, then you need not explain any further.
Oh, okay. I just wanted to say that 1999, I had a bit of a sick leave, and then thereafter, it was now during COVID, where I tested positive, but I was fine, and I was away for that prescribed 14 days period.
All right.
Yes.
lastly from me at this stage, you were once convicted of a criminal offense
Yes, DCJ.
and a certain sentence was imposed, but you appealed and
Yes.
were successful on appeal. Both conviction and sentence were set
Was,
aside.
yes, DCJ.
All right. So you are clean as you sit there.
Yes.
Okay. Well, thank you so much, Mr. Makamu. Colleagues, do you have questions for the candidate? JP, old age has just caught up with me. in a big
Thank you
way.
very much, DCJ. Abshen Dada.
Abshen, JP.
I just want you to focus on your acting stints because the spreadsheet reflects a total of 148 weeks that you've acted.
Yes.
And in criminal trials.
Yes.
Yeah. Now, am I correct that from 2018, you were allocated, and I don't want to go into the facts of the matter because you haven't finished it, isn't
Yes.
it? Yeah. But it's what we call white-collar crime.
Yes.
Right. That's the matter involving 13 accused.
Yes.
And how many defense teams are in that matter?
7.
7. But since 2018, you've been dealing with this matter.
Yes.
And that's what has added to your criminal trial weeks. Am I correct?
Yes.
Because you've been given the dispensation to say this trial must finish. So
Yes.
you are given timely appointments to come and finish it.
Yes, JP.
What you haven't set out in your spreadsheet, and I don't know why, is there have been occasions where your trial would collapse, say, on a Monday or a Tuesday.
Yes.
And you'll offer your services to the DJP and you'd get civil work, like RAF, in the civil trials or unopposed. Am I correct?
True, JP. I always say I've got only 10 fingers. I can only count up to 10 and I've got nothing else to do. So I always offer my services to do more work where it's available. I always approach my superiors, DJP in particular,
Yes.
who allocate. That's why I've got quite a number of civil matters that I've done.
Yes.
Yet I was on a criminal roll.
I see.
And to add on that, there are some occasions where I was allocated to the civil role, but a need arises just on the last minutes that my services are required in the criminal role, and then I will gladly go and do my job.
And
But
in
once,
fact, this criminal trial was allocated to a permanent judge, but
yes,
because of your criminal law experience and expertise, you were then allocated to run with this trial. Am I correct?
I will say yes, JP.
Right. But your criminal law experience and expertise is your biggest strength.
Yes, definitely.
But you have done civil work in the High Court and in the Regional Court.
Yes, in the regional court you do everything.
I see.
I'm still busy with criminal and civil cases in the regional court, and I've done that in the High Court as well.
Yeah. I think one last question, DCJ, is I think in your list of judgments that you've given, you've set out 57. But of those 57, I think we need to get 15 out because those were draft orders. There were no judgments written.
Oh, yes, yes.
Am I
yes.
correct?
You are correct, JP.
Thank you. Thank you, DCJ. Got no further questions.
Thank you, JP. Commissioner Moimang.
Thank you, Deputy Chief Justice. Good afternoon, Acting Judge Makamu.
Good afternoon, Commissioner.
Just one question from my side. Given the acting stint that you have had from 2016 up to 2022 as an acting judge. What I want to find out from you is in terms of the feedback that you might have received from JPs where you have acted, has there been any systems and mechanisms put in place to give feedback on the areas around how you reason your judgment to ensure that there is coherence and a point of convergence between legal assumptions that you put forward and the conclusion thereof. Secondly, the areas of structures, in areas around how you structure your judgment, with a view to ensure that there is coherence between facts and reasons, which ensure that there is clarity of thought in terms of judgment of the judgment that you deliver. But more than that, whether as part and parcel of that feedback, is there systems in place to ensure that issues around linguistics and communication skills are embedded in that feedback to ensure that in your following stint or where you are going back, there is improvement around those areas. Thank you, Acting Judge Makam. Thank you.
Thank you, Commissioner. Firstly, I took it upon myself that whenever I have written judgment, especially after having delivered it, there are some confidence that I have amongst the senior judges. And I request them to sit down with me and look at what I have written. And because I will take this, whether it's a weakness. I'm never satisfied with what I've done. I see it as it's having some shortcomings. But apart from that, to critique my judgments, fortunately, I think it's happening more in Gauteng. I don't know other areas. There's constant training. When one looks at the judgments that I have written in 2016 and the judgments that I have written in 2022, you can start to see the difference. And training is an ongoing process, and I am ready to learn. And whenever I'm afforded an opportunity to attend those kind of trainings, because those trainings are meant to assist us to improve on our delivery of work that we're doing, I make sure that I attend. And I'm not one who is shy of asking how I should do things. Then I always seek assistance.
Thank you, Acting Judge Makam. Thank you, Deputy Chief Justice.
Thank you. Thank you.
Thank you, DCJ. Afternoon, Acting Judge Makam.
Good afternoon, Commissioner.
You were a judicial officer during the bad old days of the old South Africa.
Yes, Commissioner.
Any bad experience that stand out that you were able to overcome then, that you are able to share with us today?
Something that might have happened during those days, one thing that is outstanding in my mind, I was already a magistrate, and as I said, I was requested to go back to prosecute in the regional court. And we had many regional courts then. They imported, if I may use that word, regional magistrate from Gauteng. So we ran many regional courts at that time. I remember one day, it's still a pain to me. We disposed of 4 rape cases in less than an hour. When I called the complainant, and the complainant testifies, and I will be asked, do you have any better witness than this one? And in short, that was saying to me, don't waste my time. There's no case here. And yet, that was not my belief. I thought that was racially motivated. And yes, as a magistrate, as I was prosecuting in the regional court, I remember we used to do circuit courts in the old Gazankulu. So I remember the other time we were going to work in Tulamahash, Mala, and our regional magistrate seemed to have had friends or shares in a particular hotel where there is a well-known Cheetah Inn. It was called Cheetah Inn as well. And although I was occupying the position of a magistrate and a prosecutor for the regional court, I remember when I went there, he wanted to have lunch there. And when he said, you must serve these people lunch as well, they said, it's fine. But they wanted to use the enamel plates that are used by the staff at the back. Then he said, at least give them decent plates. We were given decent plates. We were not allowed to go and eat in the dining room, but we sat in the scullery to eat. And these are some of the experiences that I experienced during those days. And also that sometimes when you are challenged by your white colleague and you try to stand your ground and say whatever you are saying, and also saying that at least I studied up to this. And this is the Afrikaans phrase, I'm not good in Afrikaans, but where I was told that my gratis may fail, and you can't tell me about your qualifications. And those were painful moments. But I decided to focus on the future and build myself up and forget to rely on those kind of attitudes from those people. Those are some of the experiences that I had. Thank you, Commissioner.
So you were complying?
Compliant? Yes. I had to comply because the system was such that I must comply. And in any case, there was this well-known phrase that comply and complain later.
If you can share with us your understanding of the doctrine of separation of powers.
The doctrine of separation of powers, I think it's applicable in the democratic state, where you have three arms of the state. And then where you have the legislature that enacts the laws, you have the executive who implement the law, and you have the judiciary who are interpreting the law. Then these three arms of the state, they are not supposed to be encroaching on each other, but there's checks and balances that we shouldn't encroach on each other. And we try to see that the parliament must do its job as a sovereign institution, because they are higher than any other department or any other institution of the government to make their laws. And the executive will implement the laws. And the courts will be there, the judiciary, to interpret that particular law when they are brought before court. So, yes, those are the doctrine of separation of powers is that all these three arms must be independent on their own.
Can I have the last one?
You look like you're still hungry for more.
No, thank you. Thank you, Acting Judge Makam. Thank you, TCJ.
You can ask it your last question.
No, I'm fine. I respect the two questions, TCJ.
Okay, all right. Commissioner Malema.
Thank you.
No, thank you very much, TCJ. I have two questions, and I'm not sure if there are two, but so when people were defying the system and joining the struggle, you decided to comply and become a magistrate.
I had to make a decision at that time. Although I subscribed to the ethos of struggle, but at the same time, one wouldn't forget where you come from. I was raised in a country, or rather a place, an area, which was so much impoverished. My family was so much impoverished as well, to an extent that poor people will call us poor. So I also wanted to improve the livelihood of my family as well, but not at the expense of the struggle. So I said, if I have to contribute, I will contribute from within, and not that I did not want to participate. I will give you one example. At the dawn of democracy, there was a mass meeting in a hall, and there was a decision that was taken that they want to go and attack the police station. And I stood up and said to them, if we want to do things right, let us not expose ourselves to the dangers of being killed unnecessarily. We can follow some other channels that will help us to perhaps protest, legally so, by applying, and then that will at least stop perhaps the bullets flying for that particular moment. But to go for destruction of the infrastructure that we'll need tomorrow, I don't think it's wise. And that in itself, after that particular meeting, they decided they are not going ahead with that. And then I was now a fugitive from that time. I was sought. And I ran and stayed in various places, and including one time we even went to Botswana, where I was a magistrate, but I was on the run. And it was because I was subscribing to the freedom of the nation.
So 1985 and 1986, it was the most volatile period where the youth were responding to O.R. Tambo to render South Africa ungovernable, and the formation of PSYCO. And during that period, did you trial any of the activists at that time? Or did you handle any of those political cases at that time?
You will recall that in the homelands during those days, I think the forces were very much in power, to such an extent that you will be destroyed immediately. So what we did is to try and advise those who wants who were free to go out and implement whatever was decided. I don't know whether I may be blamed for name dropping. For instance, Collins Chabane was my classmate and a very good friend of mine. And the day that he skipped the country, we were together. And the previous day, on a Saturday, or rather on Friday, he told me that let's go and attend the UDF meeting in Cape Town. I told him that I don't even have money because I was coming from a very poor family. He said, leave that to me. We did attend the meeting in Cape Town and came back again the same day. And then on Sunday, we were back, and people did not realize that we were not there. And then we sat down and decided that let's skip the country. Then later he said, look, maybe you shouldn't go with me now, so that I may have a way to come in when I come back. And then we remained in contact until when he was arrested, and he went to Rubin Island, and then he was released later, and then we started communicating again.
You're presiding on that case of Castle Matal versus Gazangul government, which he won during those times?
Unfortunately not.
Oh, okay. Thank
I
you.
did not preside over that matter, and I did not.
It was in the homelands, yeah. You
Yes.
won against the homeland.
And when cases of that nature come into the homelands, we had the presiding officers, the prosecutors, who were whites, and they're the ones who were seized with that matter. They wouldn't give it to you as a black person.
Thank you, TCJ.
Thank you, Commissioner.
Commissioner Steinberg?
Good afternoon.
Good afternoon, Commissioner.
In their review, you would have seen that the GCB is concerned that your judgments are not well or sufficiently reasoned and have on occasion relied on incorrect legal assumptions. I share that concern, and I want to just ask you specifically about a couple of your judgments in this regard. The first one is Mulai versus Pule Incorporated, which is on page 37 of your application.
Yes, I know that, that judgment
Yes.
very well. I remember it.
Now, in that case, there was a verbal, an oral agreement between an advocate and an attorney regarding a brief from the RAF. And the attorney said that the briefs, the agreement was that the advocate would only be paid once the RAF had paid. And the advocate said the agreement was he would be paid regardless of whether the RAF paid the attorney. Now, it seems that the legal test that you used was, you said the question, is it practical to pay the advocates only after the RAF has paid the defendant, on which there was no certainty as to when the fund will pay? And later you say the averment by the defendant is not practical and feasible for the practice of the advocate to survive, with time frame of when he will be paid for his services, where he completed his work. I want to ask you, where did you source that legal test?
Thank you, Commissioner. I think that was the first civil case that I had on my very first stint in the High Court. And when you act for the very first time and you are seized with these matters, obviously, your experience from the lower court cannot be exactly on par with the experience that you expect from the High Court. That particular judgment, I feel that if I can be given an opportunity to rewrite it, I may come to the same conclusion, but I may write it in a better way because of the training that I received since 2016 until now. And I will be able to apply the law and the principles more efficiently than it was done. I agree with you. The judgment itself, it's lacking in some areas. And I think it was due to maybe, let me say, inexperience by being in the High Court.
So what legal test would you apply now if you wrote it today?
Firstly, I may not be very crisp about it, but the fact of the matter is if there was a contract, and this contract, the parties, they agree, or like in this case, they don't agree, is whether whatever they have agreed, is it something that can be applied successfully? For instance, my concern in this matter, I may not come up with exactly what you are looking for, but was that the prescription period was still running, irrespective of the fact that there was that agreement. And there was a danger, because when he then sued Pule Incorporated, it was because he was about to run out of, the prescription was about to run in, and he won't be able to recover his costs after that, because it would have prescribed.
Where did the onus lie?
The onus lies with With the plaintiff, obviously, to aver that this is exactly what was agreed.
And how did he discharge it?
How?
How did he discharge his onus? Given that it was an oral contract, he had to prove that his version of the contract was right. How did he do so?
Unfortunately, I did not revise my notes to see exactly how that was done, but I was persuaded to believe his version, that indeed his version was the one that was more probable, and I admitted it.
Thank you. No more questions.
Thank you, Commissioner.
Commissioner Lokies?
Thank you, TCJ. Justice, I just want two quick issues. I noted that you acted on appeals mostly. Tell me, under what circumstances must the Court of Appeal interfere with the factual findings and inferences drawn by the trial court?
If the appeal court find that the court accord misdirected itself by applying, or rather, how will I put it? You find that the discretion that the court accord applied was misdirected and it was not properly applied. And the same thing with the facts. But otherwise, the appeal court will not easily interfere with the discretion of the court accord. The main thing is whether the court misdirected itself.
Last question. Are you familiar with the terms used mainly during legislative interpretation, terms such as reading in and reading down? And if you do, what is the meaning of the reading in and reading down of a legislation?
Reading in the legislation is to be able to see the spirit and that prevails when that particular act or that legislation was being considered. You should be able to read in it and be able to interpret it correctly. And then reading down is just actually, I'll put it as a practical kind of a question, to say that you apply your mind to exactly what is it's clear from that particular legislation.
I won't take it further. I leave it. I must leave it here. You
I will wait for you outside to give me the answer. Thank you.
DCJ.
Thank you, Commissioner. Commissioner.
Thank you very much, DCJ. Good afternoon, Judge.
Good afternoon, sir. Commissioner.
I realize that there is a case that you presided over, and of course you provided to us on page 44 of your bundle. Musiwach, I'm not sure if I'm pronouncing that correctly, and others, Mr. State. It was a recusal application.
Yeah, it's Dube and others, let's say, and two others.
Yes, that one.
Yes.
I just want to understand, because on the judgment, I see that you deal with the facts a lot. You go to the distance with the facts. Then you go into the law relating to recusal. Then you start quoting some of the paragraphs from the judgment. I just want to understand, in the context of this case, because an application for recusal, I mean, it's tried that it is an objective test, right?
Yes.
But there is a view that says there are presiding officers who lack self-reflection. In other words, they see it as an attack on themselves when they are confronted with the question of bias and the question of impartiality. What is your view in relation to litigants who bring recusal application? Isn't it not time to infuse some level of subjectiveness in the test? Because if in the mind of somebody who perceive you as being biased or as being impartial, wouldn't that carry some weight when you are confronted with that, or that will lead to, generally to lead to abuse? What is your view on that?
Commissioner, I'm a little bit conflicted in responding to your question because I'm still seized with that matter. As I sit here, there's an application. The state has closed this case.
No, it's fine.
There's another application.
We can leave it. No, it's fine.
Okay,
It's fine.
thank you.
Thank you very much,
Commissioner.
DCJ.
Any questions from the virtual platform?
Yes, Deputy Chief Justice.
Go ahead.
Thank you very much. It's a simple, practical question to Mr. Makamo, and I think it's good that we've got a person who started his career as a court interpreter for 3 or 4 years. From your experience over the years as a presiding officer and as a court interpreter, Mr. Makamo, can you tell us, do you believe that the interpretation services that are offered to people in court assists the presiding officers adequately in all times in coming up with fair judgments? And do you think there's anything that can be done to improve the lot of interpreters that we have in our country? And I mean across the board, interpretation of all languages. Thank you.
Thank you, Commissioner. Firstly, when I started as an interpreter, I did not have the view from the other side, particularly of the presiding officer. You'll find that we were interpreting before the magistrate who understand the language, the prosecutor who understand the language. But then I reached a stage where I sat as a presiding officer in a case where the language that is being spoken is completely foreign to me. And you can't make even a little idea as to what they are saying. And I will give one example. I was doing a matter. I'm not going to disclose the nationality of this particular individual. And there was this particular interpreter. And I will give an example of a question. On the 27th of April, were you present in Johannesburg? And the interpreter started to interpret to that particular individual. They went on and on and on and on for a very long time. Eventually, I said, this is a very short question, but why is it taking so long? And that gave me some doubts as to whether the quality of interpreting that we are having, is it the one that will help the court, or this person is helping somebody else? So yes, there are two sides of the story. There are interpreters who are very eloquent, who are extremely assist the judicial officers to understand exactly what the witness or whoever is talking is saying. But there are others that may leave a room for confusion in the mind of the presiding officer. So yes, we need to have more of very eloquent interpreters, and who are also trustworthy, who are loyal, who will interpret exactly what is happening. And if we have such kind of interpreters, then definitely that will assist the presiding officer.
Well, thank you very much, and I think that becomes our collective responsibility as commissioners in our different capacities to look into. Thank you very much, Mr. McConnell.
Thank you very much, Commissioner.
Thank you, Deputy Chief.
Thanks, Commissioner Singh. Does not appear that there are any more questions for you, Mr. Makamo. You are excused. Thank you.
Thank you very much, DCJ, and thank you very much. So, Commissioner Mali. Thank you.
Colleagues, shall we take the lunch adjournment? It's 1:30. We come back at 2:30. We're doing so well with time at some stage. Oh no, that's absolutely fine. All right, we'll come back at 2:30. Okay, all right. Don't forget that that candidate we invited to come and Good afternoon, Mr. Machis. I'm sorry. How do you pronounce your name? Machitse.
Matitse, like Dore.
Oh, thank you.
Thank you. Good afternoon, Justice Maya.
Are you well?
I'm fine, Justice Maya.
All right. You have a diploma, a deep juris.
Yes, Justice Maya.
Mhm. I didn't know, when was, I didn't know you could jump straight from deep juris to LLB.
I beg your pardon?
I'm saying I did not know that you could do an LLB with a deep juris and not a B juris.
Okay. During the time at UNIBO, or as we call it UNIBO in Northwest, yes, the difference was that it was a question of one did not have what you call exemption, and you were allowed to do the courses like any B juris student. Then in between, you'll get that like on the CV, I did attach it from UNI's exemption due to age and improving yourself in that regard. And thereafter, you were allowed and permitted to do LLB straight from there.
Oh, I understand now. So you did that diploma, then you did the LLB, and then an LLM in commercial law.
That's correct.
But you were not satisfied. You registered for yet another LLM in insurance.
Yes, I'm on the last course of LLM UNISA. I'm left with mini dissertation.
Yes, yes. But you have other qualifications as well. You have some certificates, and you just don't stop learning.
I like reading, that's the problem.
But commercial law is your area, your one area of interest.
That interests me,
That's
Justice
good.
Maya.
All right. You've been around. It took me a good minute to figure out precisely what you did, when, and how to tie in everything.
Yes.
But I see that between 1994 and 2015, you practiced as with 7 firms of attorneys.
Yes.
As an
The late
attorney.
Monama.
Why did you hop around so much?
I beg your pardon?
Why did you hop around so much? What was going on there?
Sometimes they say when you hop around is that you are not afraid of a challenge. You are going around to expand yourself, have a knowledge, and sometimes that firm of attorneys wherein you join, it's got something that you need that you expand your interest in. For example, but when I left Mabatu in 1996, after the new dispensation coming to Johannesburg, the aim was one, to come and expand and understand the law, because I was the first black notary and black conveyancer, and we had a problem of getting conveyancing work. As you know, it was difficult, especially in the area of Mafike and Mabatu. It was
Yes.
predominantly white, so we couldn't get much work, and one could not expand. Then I came to Johannesburg and joined a firm of Kunene.
And in between, you managed to sneak in other undertakings. You were once a commissioner in the small claims court.
That's correct.
You were with the asset forfeiture unit as a senior state
Yes.
advocate at the NPA.
Yes, that's correct.
What have you not done? But right now you are a regional magistrate.
That's correct.
Okay.
Justice
That's interesting. That's a wide scope of experience you have under your belt. You are a member of the South African chapter of International Association of Women Judges. What attracted you to that women's association?
Except I was recruited by two, Judge Collins and Magistrate Chetty. Besides that, I like to advance or give some lectures, assist upcoming magistrates, and more so, I was helping one particular magistrate that also pushed me to that, who was coming in and wanted to be monitored or a mentor, as a mentor on her and others. So I joined the women's judges because the main aim also was to advance and to help in that regard wherever I'm called in that field or in that site.
You've acted as a judge in the Gauteng Division
That's correct, yeah.
since
Just in
2016. Since 2016?
I beg your pardon, Justice?
Since you started acting there in 2016?
2016, January.
And your last acting stint was the 4th term of last year?
Last year, that's correct, Justice. Ma'am.
How many stints, how many terms did you get?
In total, I think I've made 52 weeks. And in most of all of them, except maybe one in 2019, it was the full term. When I'm saying 2019, it was twice. The first term, it was full, one in half in Mpumalanga, the other half in Johannesburg, and in the second term, the other last term, by last 6 weeks or in Mpumalanga.
How many written judgments did you manage to produce during those stints?
So far, Justice, I think it's about plus minus 35 that I've calculated from my side, from the record that I had. There might be more because I could not get all the information due to the fact that at one stage the Justice Department had a problem with the laptop, laptops and other things. So we lost some information in that regard.
You do not have any reserve judgments?
I do not have any, Justice Maya.
Well, you're not there any longer. Were you able to get your judgments delivered promptly?
Yes, except perhaps 3 days out for 3 months, I might be out by 3 days or 5 days.
All right. There are quite a number of you vying for a limited number of vacancies. Why should the JSC pick you over the other candidates?
The reason is that I'm appropriately qualified and I've got the skill, I've got the experience, as like Justice Maya said, I've been there, I've done everything, so I've got a vast experience in this regard. So in that regard, and also I believe that I've got the qualities or the characters of being a judge. And I can work under pressure, seriously so, and I believe that, yes, at this stage, if I may just say it, I'm ready and I'm competent. I think that my CV speaks for itself, unless Justice Maya wants me to go more detail in that regard.
No, I have enough for now. Thank you. Colleagues, do you have questions for JP Mlambo? I remember this time. JP Mlambo?
Thank you very much, DCJ. Ra, good afternoon.
Afternoon, JP.
Just some background. Before you came to act in Gauteng, we didn't know each other, did we?
We did not.
You were actually recommended by Justice Molemela. I think she was still JP.
She was JP in Free State.
In the Free State, yeah.
Yes.
That's the one part. But in your attorney days in the Northwest, you worked with the late Justice Monama.
Definitely. He recruited me from the Department of, I was at Land Affairs, as they used to call it, and he asked me to come and join him, and that's where he opened up my eyes, and I started from State Attorney to Land Affairs and to Justice Manam.
Maybe you can confirm this story, because Chief Justice Mogoeng tells it. I'm not saying I'm disbelieving it, but I'm giving you the opportunity that that influence of Justice Monama when he was still in the Northwest, he was a strict person. He didn't just give instructions, but he did instruct black practitioners, including Chief Justice Mogoeng.
I was fortunate or unfortunate, but it was fortunate by working with him. He was hard worker. And you will be at the office for argument. I was still young, don't forget that stage. He will be in the office by 5 o'clock in the morning. And then when we leave, me trying to go and family and whatever, I'll leave, say 5 o'clock, is the, what are you going to do? Are you going to watch TV? And there is a lot of work here. Start sitting. So we'll leave at around 9 o'clock. He was very strict. The other thing that I can say about him, why I'm saying he was very strict, he was also meticulous. He is one person when he comes, for argument's sake, I leave a file or the file in the office. It should be, he says, I should not see the next page. So it should be so close together. And if anything that comes out, he doesn't mind calling you.
Yeah. I was looking at the issue of briefing patterns, because briefing patterns is a problem.
Okay.
Yeah.
So he was, I remember Justice Nkabinde also was still coming up, JP Hendricks, and also Justice Mogoeng. So he was briefing black practitioners, and he had this thing, he says, Colin, what is the difference between you and an advocate? The only thing is that you are not appearing in, by that time we are not appearing in High Court, but prepare your document so that when you give it to the advocate, he'll be able to advise you properly and also to impart knowledge in that regard. And he was really, really briefing, and the firm came to brief black firms.
But he did not hesitate to stop briefing if you delivered shoddy work. Am I correct?
He will brief you the first time. And then next time he says, why did you do that? Just explain. He was not short of confronting you and asking you, and says, if you don't improve, I will not give you work. And he was a straight talker.
Okay. Let's come to your acting stints. You've reflected in your spreadsheet that you've acted for 53 weeks in Gauteng.
Okay.
All right. Most of those weeks were spent in the criminal trial court, am I correct?
That's correct, JP.
But you had occasion to do civil allocations as well.
That's correct, JP.
Right. But you also practiced as an attorney, and you did a lot of civil work as a practicing attorney, am I correct?
You are correct, JP.
I see.
And also at asset forfeiture, and you were preparing the papers. You, as an advocate, you will prepare your own motion or affidavit and make sure that when you sign it with the director, and also go and move it in court. Yeah. So I was doing a lot of work also in that regard. It helps me in that motion proceedings.
You've also given us a list of your judgments, which I've looked at, and any particular problems you had in any part of judgment writing in the High Court?
I did not have, I might just say, perhaps bringing this up as I was looking at the comments from LSSA, wherein they were concerned about my grammatical errors and spell check. It's regrettable in that judgment. I know that we heard the matter. I was with Judge Bakwa, and we heard the matter today, and the following morning, I had to produce the judgment. I think it was 17, 18. So I think I did not give it much attention in that. And as I say, I really regret that errors, and I undertake and I take it that I will not repeat. But I may just add further that because of the kind of skill of profession that I had as a notary and as a conveyancer, one has to be very, very meticulous and very careful of what you do, because it can have an impact on your client. For argument's sake, or as an example, if you are doing a transfer for a client and you spelled his name wrong, it will come back that he has to correct. So one has to be very careful. And also when it comes to notarial work, it's been used overseas. So you have to be meticulous. So that's what I'm saying.
It's a regrettable error.
Yeah, and further that I did not have much problem. I was fortunate whenever I had two mentors in Pretoria when I was doing my sting there. Judge Mamuruti van der Schijf, Judge van der Schijf, I call him Mamuruti, and Judge van der Westhuizen. They were guiding me. They were definitely giving me, and Judge Divorce. I was fortunate to have them in my corner.
Yeah. Well, in your list of judgment, you've listed 41 judgments, but what's notable is you've listed about 25 criminal judgments, 26, and 16 civil judgments. But I think the civil judgments could be more. But you mentioned that the justice IT system crashed, and a lot of information was lost. Do you ascribe that to that?
That's correct. Yeah.
Okay. No. Thank you very much. And you regard your time in practice, your acting stints, and the fact that you are a judicial officer, you are a magistrate of many years standing, that stands you in good stead to say you are ready to take the
permanent post.
The permanent position.
That's correct, JP.
Thank you. Thank you, DCJ. No further questions. And DCJ, MEC Mamabolo has just joined us. He's sitting against me. I don't know why.
Thank you, Deputy Chief Justice. Good afternoon.
Good afternoon, Commissioner.
I just have to declare that you are one of the people who encouraged me to do notary.
That's correct.
Even very late, because you always said, why don't you are a conveyancer, why don't you complete the whole course and do notary? And I did it very late, but it was very, very, I really appreciate that. I do know that you were a convener of a notarial exam for the Law Society of the Northern Provinces then.
That's correct.
So, and you did some lectures, lecturing attorneys on notary. So do you think the standard of notary and conveyancing, because you know why? I'm worried about the failure rate, you know, and they always blame the LPC that we are failing them. Do you think maybe we need to do something about it? Because I know you're very passionate about it.
If I look at the beginning, when I became a convener and examiner, I believe it was very strict and the candidate or the student pupils, I'll call them pupils with due respect, and the candidates who appeared there, they were well prepared. Nowadays, attorneys with due respect also, they are after money. They are interested in making money without looking at the quality of work. So whenever a candidate comes to us, especially for the orals, because in the olden days, most of us will understand that even if you had passed by 50% or how many percent, you still go for orals, because the law was saying you must do the practicals and also no understanding of practicals and theory. Currently, yes, a lot has to be done. The passing rate, if the old, when I'm saying the old teachers or the old conveners and examiners, we are very strict, or we are strict, and we need very strong people who understand the law. And LPC can do a lot by doing the trainings. I don't know whether it still continue, but if they do, it has to be rope in experience, the past notaries and past conveyancers to come and do the lecturing and help in that, and emphasize to the students or that the main is to produce the best and the good quality work, not run after money. So LPC can help a lot in encouraging the students, the attorneys. The passing rate, yes, went down a little bit, it used to be, it was, the last time I was checking, like 21% of all the candidates. And it seems, I don't know whether they are no longer interested, but the passing rate was very poor.
Okay, thank you, thank you.
Thank you. Thank you, Commissioner.
Commissioner Lukies?
Justice, in circumstances where sitting as a judge, just after you have delivered your judgment, you notice that, well, there is an omission in your order.
There is
you intended to say to grant cost of two counsel, but you omit to say including cost of two counsel.
The cost, cost in the cost.
No. What I'm saying, you intended to grant cost of two counsel.
Okay, yes.
But when writing the actual order, you omit to say cost of two counsel. You issue the judgment. You just discover this later. What are your options?
And discovered later when...
After the judgment has been given to the parties.
If you were ready, if in most cases I prefer to read the judgment, especially the order, onto record. So what one will have to do in that regard to make sure, one, is that if it's still there and you have pronounced it on record, you'll be able to find it. But you can still correct the error because of saying, for argument's sake, you said cost, and you wanted to say cost of including for two counsel. So in that regard, you can still rectify the mistake as long as you are not going to change you are not changing the whole judgment as whole.
No, I'm not sure whether you follow me. I'm saying we have issued the order, the judgment. It's already given to the parties. You discovered in the morning, hey, when you look on this judgment, I did not include cost of two counsel. What are your options? Do you have any options?
The option is to call the parties and rectify the mistake, because you wanted to do that in that regard. Otherwise, the only option which will sometimes be left now is to take it on review or take it up on appeal, but it's costly because it's just a mere mistake in that regard.
Who must take up it on review or on appeal? Is it you as a judge? You say, you will advise the parties to review your judgment or appeal?
On appeal, or just take it on appeal for the cost sake. But in most cases, you can still rectify it in that regard.
my last question, which is the second one. Now, in a trial where there is an expert to give an evidence, an expert gives an evidence. Now, when you are judging, when you are approaching that expert evidence, what are the guidelines? How should you approach an expert evidence in your judgment?
Remember that an expert, as much as he's called by the parties to come and testify, he is there to give guidance to the to assist the court in that regard. So you must make sure that he knows or he fulfills the requirements of being really an expert, and during his testimony or the time that he was called, you have clarified and you know that he is knowledgeable about in that field, that he's coming to give you an opinion about it.
Otherwise, your point is that my point is how, I mean, are you bound by that evidence? What an extent is that evidence?
You are not bound. He's there to assist the court. But the last word, or if you feel that you cannot go with it, that you are not bound with his opinion in that regard.
President Pete? Oh, sorry, Commissioner Nyambi came before you. Commissioner Nyambi, sorry.
Thank you, DCJ. Morning. Afternoon.
Good afternoon, Commissioner.
It's been a hectic day. Having acted in the Gauteng Division, what were your observations regarding challenges that you think elevation to the bench will assist to deal with?
There is one thing, so far, I will say, I'm not buying the JP's face. He's doing everything that is best, that is good. He has an open door policy. If you've got an issue, you've got a problem, you'll be able to go to his office. Even if you are at home or whatever, you call him at night or anytime, he'll be able to assist you. So challenges that are there mostly, I will say, we've got shortage of researchers, because if you do judgment and you want to pass it over, that it has to be looked at by the researchers. If it can be empowered or given more work extra staff. The other challenge is that in most cases, when acting judges come and act, you bring your own laptop, you bring your own apparatus, I'll call it that way. And then you do your own judgment, you type your own judgment. So it will somehow help by getting, even if it's a desktop in that office, so that he'll be able to. And certain offices are, it's just a desk and a table. It's a table and a chair. They don't have library, and you have to. I know nowadays you can Google and find, not Google, but look into the system. So into the computer and look for research and do that. But it will help if something is there that can assist, especially acting judges in that regard.
If you can share with us your understanding of the connection between the rule of law and democracy.
Okay. South Africa, it's one democratic, one sovereign democratic state, where it's founded, among other values, being the supremacy of the Constitution and the rule of law. The Constitution is the supreme law, and any law or act which is inconsistent with it is invalid, and one has to comply with all the obligations of the Constitution. the law, it's equal. Everyone is equal before the law. Let me say, everyone is equal before the law. The legislature and the executive receive their powers from the law, and it is the duty of the judiciary to look after, as the guardian to the constitution, to make sure that the legislature and the executive apply the law accordingly. So the rule of law, it's one of the cornerstones of our constitution and also of our Bill of Rights.
Is there a connection between the rule of law and democracy?
There is a connection because you have to be sure. I mean, if one is not doing the law or correctly applying the law, the democracy won't be any democracy in that regard. It look like a sovereign state wherein we only believe in one state. So yes, there is a connection between the two.
Thank you. Thank you, DCJ.
Thank you, Commissioner Nyamdi. President Pete.
Thank you, DCJ. Good afternoon.
Good
Mr.
afternoon.
Matsitsa.
Good afternoon, Acting President.
Mine is more of a comment than a question. And I'm happy that as a conveyancer, you were acutely aware that an error in a deed could be costly for a client. And the same applies to a judgment, especially the order. Because if the order is ambiguous or contains a patent error, a litigant would then need to invoke Rule 42 and go back to court for the correction of the error. So all I want to say to you, if you are recommended for appointment, you must always keep that at the forefront of your mind.
I really appreciate the Acting President for enlightening me, for reminding me that. Thank you very, very much. I'll keep it in the back of my mind all the time.
Thank you, Mr. Matsitsa.
Thank you.
Thank you, DCJ.
Commissioner Ramkhoi.
Thank you very much, DCJ. Good afternoon, Mr. Matsitsa.
Dumela. Good afternoon, sir.
No, ke a leboga. I just want to find out, as a magistrate, right? Currently, in the people who are accused or who are suspected of having had committed crimes, and they are arrested overnight, maybe on Friday, there are provisions in the Criminal Procedure Act for them to be able to either apply for a police bail or a prosecutor bail, right? And in practice, it seems like that process is not working for honest attorneys and practitioners. In other words, you will be called at 10 o'clock because you don't have the connections and dynamics of the area. You will be taken from pillar to post, and your client might not be released, and will have to go to court on Monday to do that. How best can this issue of out-of-court bail be used to benefit those people who are suspected and arrested of crimes at that level? I'm not sure if you are aware of the challenges that I'm talking about.
If I may answer that by saying, Joburg magistrate, they've got prosecutors who are standby. It can be put in that fashion, or in the sense that prosecutors are there the whole night. They're supposed to be available. Even if he wants to go for a gig or anything, if you know that you are on rotation, it's like, I will say in the High Court, when you are on agent, you should make sure that you are available. So if it's kept strict and observed that who was on the roll, who was doing the work on that weekend, that he must make himself available. That's in regard to bail at the, for the prosecutor. And also, the prosecutor must have, if possible, I know that magistrates mostly do not act during the night, but if the system can also introduce to help that we or the magistrate also, somehow it's your turn this weekend to work, so that whenever they call you in that, so that when an accused or an attorney is able to the police are running around, he can take the matter straight to the magistrate, failing which I know that it's costly, but he has the High Court to bring an urgent application. I know it's a lot in that regard, but in order to assist as much as what we are saying, I have been there as an attorney also, that you find that worst part of it is that the police will move the accused from one town or from one police station to another. When you get there, he's nowhere to be found. When you ask the commander, he also switches off his phone. But if you've got a dedicated, there is a, let's say, cell phone that is known, that is given that in this area, if you want help, this is the person that you phone, or you phone that number, then in that regard, it will be able to get, you will be able to get some help.
No, thank you very much. My last question is in relation to, generally, not generally, there are instances where most of the cases that, or some of the cases that are coming up on review from the magistrate court to the High Court, where judges show their displeasure at the level of responsiveness from the magistrate, right? And with the quality of the queries, the way they are actually responded to, and the time within which those responses are actually provided to the judges for them to be able to successfully look into this, and the preparation of the record and all those things. I'm not sure, in your experience at the regional court, and of course with your discussions with your colleagues, have you experienced this? What really is the root cause of this? Because it goes into the fundamental rights of the accused, some of which might be, at the time when this review is going, they might be behind bars.
Sometimes I will say, I don't know, some magistrates are afraid. When they get a letter or some query from the judge, instead of answering, he will duck and dive without responding to the set issue, what is being called. Yes, it's a problem. It has to be addressed. In most cases, I will say, perhaps if it can be taken with the commission, the magistrate commission, that it must be one of the rules, and it's there. It's one of the code of conduct that you have to respond very fast or in that regard. Maybe for those who were attorneys, we know that by not responding to the letter of your colleague, it's regarded as you can be disciplined for that, for failing to respond. The same with magistrate. I know they are independent, we are independent, but you have the duty because you are affecting the rights of other people. Perhaps even to make it worse, you find that you are delaying and the poor person is lingering in custody. If you are the respondent in time, that regard you will have, he should have been released. But what can be done, it's one problem, but perhaps engage the JP or the Chief Justice, the office, because they've got the meeting always that they meet, and emphasize, and if need be, he can request the Chief Magistrate or the Regional Magistrate to provide him with the list of, if you've got the list from the judges, saying, since I wrote this letter, I know that we, as a review, you put it, the file, you put it, and then it goes to the registrar's office. Sometimes they don't even follow it up. But if it's, the JP knows, and he's being given the list, and even worse, the name of who is responsible. It's Colin Matsitse, why are you not responding? Can you give us a written explanation why is not being done. So in that regard, it can be assist a lot in that.
Yeah, Leboga. Thank you very much,
Thank
Deputy Chief Justice.
Commissioner Makwanis?
No, thank you very much, Deputy Chief Justice. Good afternoon, sir.
Good afternoon, Commissioner.
No, I only have one question. I think you are the best person to answer this question because you have practiced as an attorney, you have been a magistrate, and you have been part of the public service. Do you think that state advocates and prosecutors should be allowed to be acting judges? And if yes, why? If not, why not?
I won't say that it's a simple one, but depending whether they will be able to be impartial and be able to be free. Because in most cases, in the olden days, I would say in the olden days, in the sense that the prosecutors were a little bit independent. They will be able to can take a decision without, nowadays they say there is circulars, and a prosecutor who appears before you, he can't even take a simple decision when he's appearing before you, whether to withdraw a case or whether to say he's proceeding with the case. He will say, I'm taking it to my SPP. And SPP will delay most of the time. So I know it's not easy to say that, can they come and act in that regard as prosecutors? I mean, as acting judges. I will say, like the magistrates or prosecutors are also appointed as magistrate. For prosecutors, they should also follow the same line, be called on to act as magistrate in a district and get to know before they get to be acting in the High Court. With regard to the advocates, also they can be allowed or given a chance to advance, but it will be in a, I would say, up to a person. Is he able to can balance, saying that when you are on the bench, you are not for the state, you are not for the litigant or the accused, let's put it that way. You are there for justice. You are there to obey, to follow the Constitution. What does it say? And in that regard, I will say, yes, and also be given a training in that regard. Thank you.
Thank you, TCJ. Thank you, sir.
Thank you, Commissioner Makwanis. Are there questions from the virtual platform?
Yes, Deputy Chief Justice, if
Go
I may.
ahead, Commissioner Singh.
Thank you very much, Deputy Chief Justice, and good afternoon, Mr. Machita.
Good afternoon, Commissioner Singh.
Thank you. Just one question. You know, we speak of the fourth industrial revolution, and it's become a revolution which all the young people just take like duck to taking to water. I would just like to understand your technical competencies in being able to manage this 4IR, because you would realize that even during the period of COVID, the system didn't shut down. There were still matters being heard on a virtual system. So if you can just speak to your technical competency in that regard, and whether you think it's something that's here to stay.
It's here to stay, if I may put it there. Not talking for my alma mater, UJ, the professor there is pushing it, and it's something that you cannot run away of. And I would say it's a good thing, and it's something that has to happen. I'll give an example. When people are growing up in the rural areas, if at the tribal office, everybody, let me just start by saying, everyone has a cell phone. It's easier for a person to can log in and wherever he is, be able to can conduct the proceedings, be able to stay. Yes, we have a problem of load shedding. And if we are in one area, it will be easier for people to can go and join at the tribal authority or a tribal office. And with solar system, which is being introduced, it won't be that much of a problem. But I will say it is here to stay, and it's going to be be applicable at all the time. And it will cut costs of people moving, like witnesses' fees and things like that. I don't know whether I've answered you, Commissioner.
Yeah, and just as a follow-up, how have you beefed up your technical competency over the years to deal with computers and etc.?
I used to work with Mr. Judge Rachivumo, and he also encouraged me in that regard of when it comes to computers and all that. I won't say I'm a computer guru, but I do understand it, and I do help my colleagues when it comes to computers and setting up and all that. I have a bit of a knowledge. I like to challenge, or I like a challenge and go in and look at that. I'm one person who, besides reading, also like technology. I love technology. For me, cell phones or whatever that is got technology, I would like to join and see how far it goes.
Yeah, that's very good to know. That's very good to know. We're all trying in that area. You presided over cases where gender-based violence and violence against women and children, and one of them is the baby Daniel murder case.
Yes.
Do you think that there is a further role for the judiciary to intervene with and having due regard to the separation of powers, so that you can make, as a judiciary, a meaningful contribution to reduce the scourge of gender-based violence, particularly against women and children?
One will say it's growing. I'm saying it's growing, and there is, when it comes to children and women, and what I can say is that the judiciary is there as a guardian, as I said, guardian of the Constitution. So it's got a big role to play. That one cannot go away. So when it comes to GBV, the act has also, or there's been an improvement. The latest act which came in, even the domestic violence, which started, the certain sections started with August in this regard. So it is there, and it can be done. The judiciary can also help by, whenever they do judgments and things like that, that they bring it up more and more. And people are taught and given a chance to say what is right and what's supposed to happen in that regard. I don't know whether I've answered.
No, well, I'll accept that answer. Thank you very much, Deputy Chief Justice. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Singh. JP Wegley.
Good afternoon, Mr. Ashile.
Good afternoon, Commissioner.
Sorry, I didn't get. Oh, thanks. I'm a bit deaf. Sorry, thank you. Good afternoon. You are one of the few people who has been admitted as a notary public.
I beg your pardon, sir?
You're one of the few that I know who was admitted as a notary public. It is one of the most frightening things for every attorney to go and sit to a notary public examination. It's a very specialized field.
That's
and you didn't only do it and become a notary public, you also lectured in it, or trained in it, set exam papers. So you were one of those people who frightened all candidate attorneys and attorneys. But I want to know is, since you've been a magistrate, which is from 2015, have you kept in touch with the developments in the notary field? And I ask this because you might be just one of very, very, very few people, judges, who actually admit as a notary public if you are recommended and appointed as a judge. So my question is, have you kept abreast with the developments?
I like to read. I do like to do a research. You have to, once a notary will always be a notary because you are called upon at any stage to can give an advice, I mean, not give an advice, deal with a matter that deals with this kind. I'll give just a small example. There is a recent judgment by Judge van der Schijf, wherein the question, it involves, I know, matrimonial property, especially wherein it's a marriage out of community. And it involves, I will say, a notary because it's out. It's a marriage out of community. But can the person benefit with regard to pensions and others? So one has to keep on abreast with development in this regard and all the laws that is applicable. Yes, I have been keeping contact.
Thank you, because I remember about 25 years ago, I was rushing to court an urgent matter, and I had to speak to the judge, and I told him, I'm coming to perfect a notarial bond. And he asked me, perfect? What do you want me to do? You know, I'm sure whoever phones you will not have that problem. And I'm also sure when your JP gives you a matter to deal with the confusion in an ANC, you will know it's got nothing to do with the African National Congress.
Thank you.
Thank you.
And commercial matters. Thank you.
Can I follow up, DCJ?
Sorry?
Can I follow up on?
Yes.
Yes. I'm sorry, Ramatiti, I just want to understand. Perhaps maybe I did not understand quite well. Are you saying that if somebody is married out of community of property and out of community of profit and losses, that person will be able to share in the pension benefits should they divorce?
Okay.
Is that your proposition?
No, I was saying it's a judgment that is being done by my colleague, Judge van der Schijf, which he declared one of the sections that are on the Matrimonial Act that, because the rule is one, or when you are married out, I always call it out. We don't share anything except the blankets. In that regard, when it comes to your benefit, pensions and things like that, you don't benefit. But what about the person who has been home taking care?
Oh, I understand. No, thank you very much, Deputy Chief.
You don't appear to like the answer, Commissioner.
I think the last part, I kind of like agree with it. I was concerned with the first part.
Okay.
Oh.
Well, we've reached the end of your interview, Mr. Mashisa. Thank you very much. You're free to go.
Thank you very much, Justice Maya. Thank you for the time and everybody. Thanks to the Commissioner.
Good afternoon, Advocate Ntlokovane. Are you comfortable over there? Switch on your mic, please.
Good afternoon, DCJ. I am comfortable. Thank you.
All right. You hold 3 law degrees, a BUris, LLB, and a master's in family law, right?
Indeed, DCJ.
You also have certificates. You have an advanced certificate in ADR.
Indeed, DCJ.
And you did a course in arbitration in the construction industry.
Correct, DCJ.
Right. You started your legal career in 1998 in Kimberley.
Correct.
Where you were a trainee registrar.
Correct, DCJ.
But you never bloomed into a full registrar. Why did you leave?
I was told back then that the department recruited more than what they needed, and we were made to choose between being estate controllers and being public prosecutors, and I went for the latter.
And you became a public prosecutor.
Yes.
Then, shortly, well, a month after, you were a public prosecutor for 3 years. Is my count right?
It is, yeah, just under that.
And left to become a researcher at UCT.
Correct, DCJ?
Sorry?
That's correct.
You've done a whole lot of things. You worked with the gender advocacy program as a project manager in social policy.
Indeed.
And then you went back to the DOJ as a senior legal administration officer. Why did you go back there? Why would you leave such an interesting job to go back to government?
Can I just, I didn't get the last.
I'm asking why you would leave that exciting job with GAP to go back to a dreary job with government. Minister Lamona, I didn't hear that.
Oh, okay. It is, I think GAP was an NGO and it was funded. And I think the funds, were drying up at that time. And I then approached the national office, and I was fortunate to be offered a position as a senior legal admin officer at national office, and which was also kind of taking the same toll, the same, responsibility in a different way as what I did at GAP.
I'm sure you would have picked up strong administrative abilities from that position.
Definitely, DCJ, it goes without saying.
Then you worked with UNICEF as a child protection specialist.
Yes.
How did you find that that stint for how many years? 5 years?
It was about
3 years.
3 years at DCJ. It was a beautiful learning curve, and I think it was positioned at the time that South Africa needed technical expertise from that, because I assisted a lot. I was working very closely with the likes of Advocate Machokweni in setting up the TCCs. In fact, it's an abbreviation for Tutuzela.
You mean the Tutuzela care centers?
Yes. So you can see, DCJ, it goes straight to the issues of family law and gender-based violence that are quite close to my heart. And I found the opportunities quite important to be plowing back to the South African community in that role.
Your bio says you also provided, in addition to technical support, you provided financial support?
Yes.
In the development of the guidelines?
Yes.
How so?
I was managing a project which literally funded the TCCs. We would go and site visit, make sure that they are secured in all these other provinces that TCCs are. So the funds would be coming from the project I was heading. Other than that, I would provide the technical support. We would make sure that we hire staff, legally qualified staff to can assist the victims in all those centers throughout the country.
Yeah.
It was a very important role that I fulfilled there.
And then you joined the bar
Then I went to the bar
in 2012.
in 2012, and I'm still at the bar, TCJ.
And you've done a lot of work whilst at the bar, mentoring of the youth. You work with the People Age Program.
Correct.
And you've been mentoring young people.
On the SAC, the IWJ, Gauteng Wing, that too.
Your mentees actually graduated into something serious. And
I woke up this morning, if I were to be specific, to one who graduated last night and sent me beautiful pictures. I was quite thrilled. And the other three are candidate attorneys, and I can count, they they successfully completed their programs, and their others are actually practicing as advocates in my group.
that is service.
It is.
And
It
it's
is,
to be
it is
highly
fulfilling. It is fulfilling.
Yes,
TCJ.
yes. All right, to come closer to why we're here, you've acted in a number of divisions as a judge.
Correct.
Limpopo, Northern Cape, Mpumalanga, and then Gauteng. I
Yes.
count a total of 126 weeks of
It
acting
is.
stints.
Yes, it is, TCJ. It's exactly that.
Well, it was time you applied for a permanent appointment then. You have been able, we have the thick bundle of some of the judgments you've
That are
written.
penned, yes.
Any of them reported?
There is one that I can quickly think of from my head. I was in a full court seated with JP Likhodi when I was in Mpumalanga, and he afforded me the opportunity to scribe that judgment, and he immediately after it came from me, he made a mark that it must be reportable, and it was on customary law.
Only one of your judgments?
Marriages.
Sorry?
Yes, I think that's
Okay.
the one.
And only one of your judgments has ever been taken on appeal, which failed?
My order was confirmed by the SCA, yes.
Yeah. You list four reserve judgments in your questionnaire. Have they been delivered?
Yes.
All right.
Yes, TCJ, they have been all delivered.
Okay. Well, thank you. I'll hand over to my colleagues to put questions to you. You first, JP.
Thank you very much, TCJ. Good afternoon, Advocate Logovana.
Good afternoon, Judge President.
Let's just start with background. You started acting in Limpopo in 2016.
Indeed.
And that was after you had no call from Gauteng. Am I correct?
Not really, JP, not really.
Okay. But you then acted in the Northern Cape.
After the Limpopo.
After Limpopo,
yes,
yeah.
Yes,
And then you acted in Mpumalanga,
correct, JP.
where you also applied for permanent appointment.
Last April.
Yes. And then only in 2022, you came to act in Gauteng.
You afforded me the opportunity to act in your division.
Yes. But you know the reason why you were not called earlier.
Even though you never said, but I wanted to believe that those small divisions that I acted in prepared me to come. And I remember one day you met me in one of and then you said, keep on doing the great work, your time will come.
one day I'll invite you to my division. And that's exactly how it unfolded.
Yeah, I think the problem with us in Gauteng is sometimes they say we're too formalistic. I discussed it with JP Makhuba, who told me you were acting there and you were doing well. And I said, well, he must continue supporting you, but in Gauteng, you won't be called for another 3 years to come and act in
Is
Gauteng.
that so? I didn't get that part.
Well, the bars in Gauteng, no. The threshold was 15 years at the bar.
Okay.
Oh, no, not at the bar, but in practice.
Okay.
Yeah, but that has dropped to 12.
12.
Yeah, you are aware of that.
I am.
Yeah. So just for the commission to know why you only acted in Gauteng recently. How did you find the tempo of the work in Gauteng compared to the other divisions? And don't call them small, because those JPs will take serious exception to that.
Yes, I must correct that. They
Yes.
are smaller. Okay. They are not as big as Gauteng.
Okay.
Maybe I should put it that
Yes.
way. In Gauteng, the workload, it's quite unique as opposed to where I was coming from. But to come to your question that how I cope with that, I had to hit the ground running. It was a steep learning curve, but I am happy to report to you that it is worth it. I had to put a lot of longer hours working so that I can make sure that I come to court prepared all the time. And when I have an opportunity to listen to matters, I put a lot of hard work so that I can produce judgments and finalize them expeditiously and efficiently.
Yeah.
So it really had to take a lot of compromise and cut a bit of a social commitments to give so that one can be up to speed with one's work.
Yeah.
So I can report to you, JP, today to say it was a steep learning curve that is worth it, and I can look back at the judgment I produce, and I'm proud of them. They are satisfactory.
Yeah. In fact, you are very kind. You should have told the commission that we really threw you into the deep end. Because when you came here, the first time you came, we gave you a full term, which we hardly do for first-time acting appointments. But this was based on you having acted elsewhere.
Elsewhere.
So that's a full judge's load. And the second term you came to act, we also gave you a full term. You remember? And then term 3, we gave you another full term.
Indeed.
So you know what it is like to carry a full term in Gauteng.
And in between, you gave me a recess duties for 2 weeks.
Yes. And I also threw you in the agent court. In fact, DJP Lidwaba threw you in the agent court in term 3. How did you find that?
I was thrown in the agent court in term 2 and term 3.
Yeah.
And there as well, it was quite challenging. And 1 week, I had about between 14 to 16 matters. And I had to I delivered extempore, I had to reserve others. And I saw myself producing judgments within 4 or 5 days in those matters that I've reserved. But in the whole, JP, it was an experience that when I look back, I was like, yeah, because one had to be on her toes all the time.
Yeah. Let's just go back to term 1, 2022. You had 2 weeks in the opposed motions. You would have got nothing less than 10 matters per session, am I correct?
A week.
Right. So roughly you had 20 in the first time you acted in Gauteng.
Correct.
And if you don't deliver extempores in those that you are confident in, it's easy to pick up 20 reserve judgments just from that week. But you also sat in other matters where you could have picked up reserve judgments, am I correct?
You are right.
Yeah.
You're correct, Chief.
And throughout this, you coped.
I coped. I'm seated before you today. I don't even have one reserve judgment in that division. Through all of that, I managed to, whatever that I've reserved for the past 3 terms, has been delivered.
Yeah. My last question is, you've given us a list of the judgments you've handed down in all divisions. Now, the one fact that we always look at here is how long it took you to hand down these judgments. I note that there's one or two in Gauteng where we don't have the date when the judgment was handed down, but we'll pardon you. But for the other divisions, Northern Cape, Limpopo, and Mpumalanga, the dates are not there. Is there a reason for this?
There is, JP, a reason. I was literally battling to get to that states. What really assisted me were my notes from the bench books that I still possess.
Yeah.
And I tried to reach out to some of the registrars in that division to no avail.
Yeah.
But JP, if I were to put you to be comfortable, I left all those divisions without having not even one
Yeah.
reserved judgments, and no judgment of mine in those divisions was longer than 3 months.
I see. I wanted to confirm that. You have one in Gauteng, which took you, I think, 6 months to do. The Mokhaladi, Teda, and others case. You had it in February 2022 and delivered it on 14 July 2022. Was there a reason for that? You can check
JP,
your
can I
list.
check?
Yeah, you can check your list. It's not criticism.
I just want to check something, JP.
Yeah. It's listed as number 12. Do you have the right book in front of you?
I don't have the right book. I just found the right book now.
Okay.
JP, may you assist me with the page, please?
I'm looking at the electronic. Well, I've saved my documents different to how the OCJ has arranged them. Where's the separate folder? Yeah, let me go grab it.
Okay, thank you.
Where's 12?
12 it's not even my JP, this one. This is not my list.
These candidates' documents are not here. They're not here.
DCJ.
What exactly are you looking for, Mr. Doroban?
No, sorry, DCJ.
Is she closer to finding it?
She just needs to confirm the fact I put to her that in one of her Gauteng judgments, she took 6 months. She needs to look at the case and remind herself about it.
Okay.
What's the name of the case, JP?
It's the
Citation?
Teda. No, it's Mokhaladi, S. Mokhaladi, Teda, and others. It's listed as number 12 in her list.
You have it on your laptop, JP?
Yes, I have it on laptop.
Why don't you just borrow the laptop for the present purposes? She won't run away with it.
Yes. I found it. Thank you. Thank you so much, JP.
Thanks anyway, JP.
I see exactly what is happening here. JP,
Yeah.
the judgment that has been delivered
Yes.
on the 2nd of September, because really I was trying to, it is not the main judgment, it's the leave to appeal. You can see there it's also noted as leave to appeal.
No, but
So
if
the
you
main
look,
judgment.
let me disturb you. Look further up. You had the matter on the 17th of February.
Okay.
And delivered the judgment on the 14th of July. You see that? And then you had the leave of appeal on the 30th of August and handed down that judgment on the 2nd of September, the leave to appeal judgment.
This judgment, JP, the main one was delivered just under 4 months, not 6.
Oh.
Yes, from Feb. Yeah, it's not 6, but it's just over, it is over 3 months.
5 months.
Yes, it is over 3 months. What is important is over 3 months, and it was involving a CEO of the, it was quite complex. It had novel matters, and I needed to apply my mind on that. That's why it took a bit longer than the ones. But if you can look at the trend, you will see that. And it was appealed, and then I had to write 2 judgments in that matter.
No, you're correct. The trend is, it shows you deliver your judgments expeditiously.
Thank you.
Yeah, I was saying, I wasn't criticizing you, but I was just saying it was against your trend of handing down judgments. And I wanted to know why, what happened.
I hope I have answered.
Thank you very much, DCJ. No further questions.
Thank you, JP.
MEC Mamabolo, do you have questions for the candidate? Okay. Commissioner Nyambi.
Thank you, DCJ. Afternoon, Advocate Ndlobovan.
Good afternoon, Commissioner.
The last time you were here, when the former Chief Justice asked you, how are you? You said you were very nervous. Today, the same question was asked by Deputy Chief Justice. You were more than fine. Probably if you can share with us the secret as a commission to assist others and those that are following the interviews, because the person that you interviewed then and the one in front of us today, it's a totally different person. So I'm interested in understanding the secret behind that.
Commissioner, I'm not sure it's a good or bad thing. I must say, I think I'm in a good space. And secondly, I took a lot of colleagues, senior colleagues at the bar and in the bench. They said, when they were wishing me well, they said, relax. And I think that's what I've been practicing, just for me to be in a very calm and calm space, and I found it to be working. Not that I don't take this process serious at all, but I thought with calmness, one is quite level-headed, and I so wish it can really be everybody's approach. I found myself to be quite calm this time around, as opposed to the first time.
My last question, thanks. It's assisting. My last question, over and above what has been asked by the JP about the acting sting and what you have said about the preparedness, between then and now, any other thing that is most significant that we have to consider that was not considered then, that must make you to be seriously considered this time around?
When I came last April, Commissioner, I have not had an opportunity to act in Gauteng at all. So in my experience as an acting judge, I was 31 weeks less than what I am. And not that I did not think at that time I was prepared, but I think what is significant this time around. The workload that I've been exposed to really assisted me to have the approach to judgment writing and just presiding in general. And I think all these other formal qualifications that I'm possessing, I see now them all coming to fruition. And I am now finalizing my matters quite quicker than I used to, and I used to in the past. But I think that what is really important now, that is significant, that you have to also consider, is that the Gauteng stint, and especially presiding in a division with a unique workload as in Gauteng, should come as a very significant point in your assessing my application.
Thank you, Advocate Ndlogovana. Thank you, Deputy Chief Justice.
Thanks, Commissioner Nyambi. Commissioner Moimang?
Thank you, Deputy Chief Justice. Good afternoon, Acting Judge Ndlogovana.
Good afternoon, Commissioner.
Just 2 questions from my side, which emanates from one of your judgments that you have listed, El Mambani.
Which one, Commissioner?
El Mambani and 2 others. It is it is in book 2 of 3, page 27, the paginated one.
I've got the list in front of me, Commissioner. You may proceed.
Yes. What attracted me to this case is the work that I'm doing, where I'm deployed, on particularly because the judgment concerned the prescribed minimum sentence in Part 2 and Part 5 of Schedule 2 of the 1997 Act. But I think key to this is the damage to the essential infrastructure in the provision of basic services. This is what has attracted my attention. Now, despite the coming into effect on the 1st of June 2016 of the Criminal Matters Amendment Act 18 of 2015, the theft of cables and disruption of railway lines and electric or transmission lines continues unabated. What lessons from this judgment could be learned to arrest the mushrooming of the business of scrap metals? Secondly, because you refuse to interfere with the findings of the facts of the trial court. What usually will guide the appeal court whether to interfere with the sentence of the lower court or the findings of a lower court? Thank you.
Thank you. Yes, Commissioner, in this matter, it was an appeal. It was a full bench appeal. I was seated with my sister.
Thank you, Deputy Chief Justice. Can Acting Judge move closer to the mic? We can hear.
I apologize for that. Is it better now? Thank you. In this matter, I remember well. It was a appeal. I was seated with my sister Mozzarella in this matter, and she afforded me an opportunity to scribe the judgment. It indeed entailed the theft of cables, yes, and we listened to the hearing. We listened to the submissions. We read the record, and we then found that the court accord did not misdirect itself in coming to convict. There were about 4 of them, I think. Yes. So there was no misdirection from the Court, and we felt that there was no need to interfere in that record, which is basically the test for in any criminal appeal. I'm not sure if you are satisfied with the response.
Yes, what are the lessons that can be learned from the amendment of this Criminal Law Amendment Act to arrest the mushrooming of theft of cables? Because that was the latent spirit of the Act, and the minimum sentence in particular.
I think the minimum sentences, the Act was designed for a particular purpose, which is to make sure that certain certain offences, they get a prescribed minimum sentence, and the case law in that regard is very clear that at what point must the court deviate from that, and we had found that there was also, because it was a conviction and a sentence, there was also no reasons for us to deviate from the sentence that was prescribed, and I hope I have attended to your question.
Thank you.
Thank you.
Deputy Chief Justice.
Thank you, Commissioner Mokonish.
No, thank you very much, Deputy Chief Justice. Good afternoon, ma'am. This side.
Good afternoon, Commissioner.
Thank you. No, I only have one question. My question is triggered by the Pan-African Bar Association. For some time, they've been advocating for the construction law training. To what an extent has the arbitration in construction industry helped your practice? Thank you.
Commissioner, may I ask you to repeat the question, the last part? I couldn't get them. To what extent the construction?
You did a course in construction industry. In a certain extent, has it helped your practice, if at all?
It actually, it came very handy, and I was on a retainer brief for about 5 years, and the client was in civil engineering and in constructions, and I saw at the time a need as far back as 2015 to equip myself so that I can be of value to that retainer brief. And I think my approach generally to any other brief was to, when you get to work, you make sure you work hard and you produce good results. And that's exactly what I did. I saw some other construction briefs coming in. They were not as much as one would have expected, but it was not just that alone. And I saw some other referrals, and they emanated from the retainer brief. I hope I've covered.
No, thank you very much, DCJ. Thank you very much, Advocate.
Thank you. Commissioner Stenberg.
Afternoon, Advocate Ndlukovane.
Good afternoon, Commissioner.
You'll see that in the GCB's evaluation, they say that your judgments are balanced and well-researched, but they raise a query as to whether you have knowledge or experience in constitutional law, because it wasn't evident in the judgments they could find. Could you perhaps answer that question for us?
I saw that comment, Commissioner, and the first thing that came to my mind was the Constitution is the supreme law in our country. Once you have acted and you have had an opportunity to act and have produced the kind of judgments that I've produced, there's no way one can miss that, because each and every aspect one can even make an example in and go as far as unopposed motions. There's always there's always constitutional imperatives in all matters that we are seized with, and it kind of took me by surprise. But I would not stand here and defend and say I'm a constitutional expert. I will not say, but I'm sure I'm saying what I'm submitting to the commission today is that the very same bar, I think comments said that there's a blend, and they've seen me the judgments that are produced. I have legal principles that are sound and satisfactory, and that again tells me which legal principles will be then sound, and they are not married to the values of the Constitution. But there is a lot of room for improvement. I believe that. I'm always keen to learn, and I'm always keen to learn, but I just do not see myself not having a clue at all in terms of what our Constitution is all about. I don't know if you are covered.
Can I follow up, DCJ?
Excuse me?
Oh.
I don't think that anyone was suggesting that you don't have a clue. Okay.
I'm sorry, Commissioner Steinberg, you're speaking away from the mic. I can't hear you.
Excuse me?
You're speaking away from the mic. Just
I was saying that there was never a suggestion that the advocate didn't have a clue.
I'm happy.
On the contrary, as you say,
are you there, commissioners, on the virtual platform?
Yes, we are. You must have had load shed at your place.
Yes.
No, we're
Thank
fine,
you.
thanks.
Okay, let's just give it a second. You may continue, Commissioner.
Thank you, DCJ. It's just that there's a difference between applying constitutional principles and tackling, for example, a constitutional challenge to a statute or something like that. Have you dealt with a complicated administrative law case?
Commissioner, before I can answer your question, DCJ, with your permission, may I have water for myself?
Oh, of course.
It's just so far. To come back to your question, Commissioner, whether I've dealt with a complex administrative law matter, I don't think so, not a complex one.
I guess my concern is that sitting in Johannesburg and Pretoria, it's really the Johannesburg and Pretoria are the place where many administrative law cases are heard, because the administration sits in Pretoria, for example. Do you not think it might be to your advantage to act a little longer and to get a better grasp of these issues before you're permanently appointed?
I don't think so. I don't think so. I think the acting stints have prepared me to understand the basics, that in terms of judgment writing and how to apply the facts to the law. And in the event that I'm allocated a complex one, if I were to come to, I'm sure once one has the basic things of what to do, I'm sure it cannot harm for me to produce a satisfactory and a sound judgment. And also, I can also say that if it will comfort you, it will. I don't think the GCP's comments were that I be considered for the permanent position, and they've cited the reason. I will not reiterate them, but I am really a person who is keen to learn. I'm very much aware that I will not be an expert in all areas of the law, but I'm sure that I am ready, as the DCJ has also said earlier on, that I should have availed myself long earlier for a permanent position. And I believe that I am ready to ascend to the bench for a permanent position. Thank you, Commissioner.
Thanks, DCJ.
It's a follow-up. Oh, I thought you had a follow-up. Oh, okay. Go ahead, Commissioner Kalba, sorry.
Thank you very much, DCJ. Good afternoon, Advocate Jogovani.
Good afternoon, Commissioner.
How are you?
I'm good, thank you, Commissioner. How is you,
I'm
Commissioner?
very well, thank you so much.
Thank you so much.
Advocate, society is losing skilled legal practitioners to the bench. Is it really fair to society?
Can I answer?
Please. Yes, please.
I will be serving the very same society, even if I am appointed permanently, but on a different level, and I do not think it is fair. All society that the society needs is to have people or legal practitioners who are committed to social justice, and I think that's the person that you are seated, that you are looking at. And I believe that even though I were to be appointed permanently, I will still serve the society.
Must we as society be happy that we are losing skilled legal practitioners to the bench?
I think the society must be happy to see that this commission is not just doing lip service to fast-tracking women to the bench, but it's actually doing exactly what it's supposed to do by also recommending me to the bench. And I'll go back and I'll take good care of the interest of the society and the public at large.
No, thank you very much. I thought I should just ask you a question.
Thank you, Commissioner.
Just Jay. Commissioner Pillay.
Thank you, DCJ. Good afternoon, Advocate Ndlokovani.
Good afternoon. Good afternoon, Commissioner.
May I ask you about the Pieterse judgment?
Yes.
I see that you were allocated a case involving what by anybody's account appears to be a serial rapist. And in fact, you make very serious findings against him.
I declared. Yeah.
Including the fact that he's a serial rapist, he preys on women and children. And at some point in your judgment, you say he doesn't demonstrate remorse. And for as long as he is on the streets, women are not safe.
Indeed, Commissioner Bill.
What troubles me, though, is that when you get to your order doesn't quite reflect that degree of severity. You sentence the accused, and on the face of it, your sentences all seem fairly severe. I mean, you deal with each count. I have questions around how you work out your quantification of your sentencing, because different rapes attract different sentences. It's not quite clear to me the basis on which you arrived there, except obviously for the rape that occurred before the minimum sentencing legislation came into effect. So that's my first concern. I'm concerned about how you quantify the sentences for the remaining rapes, given the fact that you seem to treat them almost a lot, as if they took place within the same factual matrix. But my deeper concern is this. What you do is you include Order 9 to your list of orders. And Order 9 says, I mean, you give him multiple life sentences for different rapes, rapes of minors, multiple rapes of women. And then you say in Order 9, it is ordered that all sentences run concurrently with the 3 sentences of life, which life imprisonment will also run concurrently with each other. So effectively, in one fell swoop, you reduce everything he has done to 1 life sentence. Was that your intention when you included that order? And did you envisage him being eventually released in whatever way?
May I reply,
Yes,
Commissioner?
please.
I remember that case very well, Commissioner Pillay. And I think it's just that I don't see it in front of me, but I'm sure your questions I'll be able to answer. There's one.
You can look at it at page 338 of the bundle in front of you. That's where your judgment and your order appears.
Thank you for that assistance. Yes. As you've rightly pointed out, that some of the rapes some were attempted, some were for children under a certain age, others were for elderlies, and there I got guided by the minimum sentence. So you'll see that I've given I've ordered the sentences as in the minimum sentences, and then it is the last order that I said, which life imprisonment will also run concurrently with each other. And I have factored for me, what was important was if the minimum sentence is prescribed a certain sentence, he must get that.
Yes.
Then it is the concurrency that I then said, then that is one. And then on the last one, what was
You see, sorry, if we can just stop there. The concurrency is the issue I'm raising with you. Because what you do is you go to great lengths to say there are no substantial or compelling reasons which will warrant a deviation from the prescribed minimum sentence. All right?
Yes.
But then you include the concurrency. And that's what I'm asking you about. The decision as to whether it should be consecutive or concurrent is also a decision which has to be explained in your judgment. And you don't tell us why you opt for either concurrency or consecutiveness. And what troubles me from reading this is that you opt for concurrency, but firstly, you don't explain why, and secondly, when you do, you reduce the cumulative sentence just to a single life imprisonment sentence.
Yes, I think I did factor everything, and that was the order I was satisfied to order. That was sentence I was satisfied to order at the time, but I want us to also, Commissioner, to also, and in answering your question, to look at the other orders where I said even if he had to go out and be in the community, he can not work in an environment where there are. So I think I look at all of that holistically.
And that was exactly the second part of my question. In your order, you certainly seem to envisage that at some point he's going to go back into society. Even though you've made a finding that as long as he is on the streets, women will be unsafe.
Yes. In so doing, I was also considering that there are certain other penal provisions that the correctional services are having, and in the event that those are in place, the children remains protected, the women remain protected, even though, because at that time it will not come back to me, it would have passed me. So at least I wanted to, for me it was important to make sure that even if he gets one day that opportunity to be outside, but it does not take away the seriousness of what you convicted him for. I hope I've covered you.
Well, let's leave it there. I just want to turn to a second issue, and that's, it was quite gratifying to hear that you had been on a retainer to get involved in construction work. You'll know that it's an area of the law where there are precious few black women involved in that area. May I ask, and you indicate that there were a number of instructions that came afterwards. The retainer. Can I ask, in the course of you carrying out your retainer and in the subsequent instructions that came, did you utilize any opportunity to expose other black juniors to the work? In other words, did you bring on black junior women to assist you in those matters?
I did. Maybe I should have asked whether you are done.
No,
with
you may
question.
proceed to answer.
Yes, I did. I remember one instant. I even I applied to the Bar Council in terms of Rule 7, I think, to get assistance, and there was afforded a junior counsel to assist me, and he was paid from the transformation fund of the bar. So I was very much alive. It was something that I would have wished it was done to me as well, so it would not have missed my mind. So to answer shortly is that I made sure that in that brief and many others, I involved junior counsel to work with me, and preferably black females.
Can I just get a sense of what that means? You're saying that you applied to the Transformation Fund and you were given the go-ahead to bring on one junior. That was a black woman junior.
It was Advocate Chabalala, to be exact, of Group 16, and she assisted me.
And in any other matter besides that matter?
Yes, and there's many. I'm happy to list them, Commissioner, if you want. I'm happy to list the names of junior counsel I've worked with, and I'm happy to mention the matters. You can just perhaps indicate if you need that. It is something that is on the tip of my fingers.
I don't need you to list the names. Just give me a sense of how many black women you worked with.
Counting a total of about 12. Quickly,
so
out of my mind.
Okay.
About 12.
And these were all construction matters?
No, it is a mixed bag. It was ranging from family law, unlawful arrest, construction, and the likes.
And in construction matters, how many black women?
I think it was the one incident that for construction, but for the other areas of law, it was about, say, 11.
All right. Can we just discuss the construction matters? You say you've only managed to bring one woman junior on. Why were you not able to bring on more women in other matters?
I brought in other matters because there was an indication that the attorneys would be able to fund a second counsel, and then the ones that I've applied for the Rule 7 one, it was that indication that there were no funds from clients, and then I sought assistance from the transformation fund of the bar.
Right, so you're saying you requested a junior, but your attorneys weren't able to fund a junior?
The client, rather.
The client didn't want to fund a junior?
Yes.
Right. Thank you, DCJ.
Commissioner Balu?
Thank you, TCJ. Good afternoon, ma'am.
Good afternoon, Commissioner Palo.
Yes. I see that you have acted a total of 126 weeks.
Correct.
Which is quite impressive. And you started in 2016 through to 2022. Now, maybe the first question that I must ask is, these statistics, and let's look just at the 2022. You've acted 31 weeks so far. And the question that it raises sort of unavoidably is, but what does this mean for your practice? Does it mean you do not have a practice? Is that why in 2022, in September, you already have 31 weeks of acting, and so on with the other weeks? Can you just say something about your practice?
Thank you, Commissioner Palo. It means that I still have a practice, even though it is compromised by the number of weeks that I spend at the bench. There is a practice, but as you would appreciate, Commissioner Palo, that once you are at the bench, there's definitely nothing that you can do. There's not much that you can do, but there's some positiveness in that. I have some of my work that I get from private attorneys, and I would speak and engage them to have a replacement for the time that I'm at the bench. And I've seen about few of them who are really taking good care of my practice, agreeing and being amenable to afford me an opportunity to have counsel to replace me. And once it is the recess, and I'll be having an opportunity to take over from where they are. There are some of the matters that will be finalized without waiting for recess, and it will be a result that I will accept.
Can I perhaps just explain the reason for or what is behind my question? It is really a concern about what does it say about your experience and exposure that you spent so much time acting, 31 weeks in 2022 already. How much have you had opportunity to do the proper stuff of litigating as counsel? And what kind of matters are you doing or that remain in your practice that actually are of significance for purposes of us assessing your experience and exposure?
Could I add, DCJ, with your permission? Because I think my question would be better answered if it's an addition to Commissioner Baloyi.
Yes, please.
Oh,
go
thank
ahead.
you, DCJ. The other thing I would like to know, Advocate Glogovan, is what I could see from your CV is that I think you appeared in the SCA once as junior counsel.
Correct, Commissioner.
Yes, all right. So I just wanted to get a sense of that as well in terms of outside of the judicial experience of acting, what other experience do you have as an advocate? I'm just talking the core of the job, which is being an advocate. The other thing, perhaps, that you could, as an addition to this, the answer you gave, I think, to Commissioner Baloyi, is that when you've acted you've taken some of your work and given it to other colleagues, and which you say is a positive thing. But I would like to question that a little bit, because what that means is that you've left your attorneys in the lurch. They've briefed you because they want you to argue their cases in court. But then you've gone to accept an acting appointment, which is why they must now find a replacement. Which is why when Judge Mlambo is asking us to act, we say to him, no, we're busy. As soon as we get a gap, we will come. But during that gap, we make sure that we don't take work, so that we don't have to be asking for replacements and asking for postponements. So I would really question what you claim to be a positive attribute of your acting. But just in addition to what Commissioner Baloyi was asking you.
Okay. Thank you, Commissioner Ngogaitobi, for that. Yes, I have appeared as counsel, as a junior at SCA, and that very same matter was escalated at, it went to Constitutional Court. And once more, I was a junior there, And I would just like to indicate something about what you said, in response to what you said. The beauty about Judge O.J.P. Mlambo, when he wants to make use of you in his division, he will not surprise you. He will let you know, and he will find out from you when you are available, and you will be able to then indicate and arrange the work in your practice as an advocate. And I must mention that there were those that I had to unfortunately pass on, and to colleagues. And coming back to that needed a work of services of counsel, I beg your pardon, during the time that I was not available. Then also, coming to what Commissioner Baloyi also checked with earlier on, is that it was also along the lines of passing on work to whether there is a practice or not. What I have found, though, Commissioner Baloyi, has happened is that they have been quite sought after in urgent matters. And in all the recesses, in the 22 weeks I've acted, I've been mainly in urgent matters. Now, we both know what that means. It means you get there, your services are required, and you go and appear at court, you draft and you appear at court, you come back, the matter is finalized. So that's what I've seen coming quite often. 2 days ago, I was appearing in Thohoyandou on an urgent application in a matter that I started a while back, and something came up on an urgent basis in that very same matter, and I was available, and I attended to that matter, and next week, Tuesday, is another urgent matter. So if I were to allay your concerns, is that I've seen especially private attorneys, because you do appreciate that sometimes the state attorney work will not really allow that leeway, but from private attorneys, I've really found that happening quite often lately.
Could I just follow this up? Because I'm sorry to trouble you with this. because it does raise a very important issue about judgment. My concern is that it seems to me, and that's what I was trying, maybe I got the facts wrong. So if I've got them wrong, just correct me.
No problem.
It seems to me what you do, you take cases from attorneys. You also then accept an appointment. They clash, which is inevitable in practice. And then your attorneys are forced to look for replacements. And instead of telling the JP that, JP, I'm sorry, I cannot help you, go and find somebody else so that you can discharge your mandate to your attorneys. That is what I'm putting to you from the answer you gave to Commissioner Belou. That is what worries me, that this idea that, no, they can find someone else is really unsettling for me. And that's what I want you to, tell me I've got it wrong, or this is a wrong impression, or what exactly is going on?
Commissioner Ngokaitobe, I think you've got it wrong, and if I didn't clarify it, may I take this opportunity and do so? Agent, I don't think that's definitely how it pans out. I don't, for once, leave my attorneys not knowing or having to get somebody else. That does not happen like that. I've said in agent matters, agents are things that really come up on an agent basis, and I've seen that happening often on recess. For example, I'm currently on recess now. I'm not on an acting stint. I've then been fulfilling my duties as counsel. So I have mentioned earlier on that there are those few matters that it was unavoidable that when a counsel was needed, I was at the bench. There were those, and there were few, and I would be upfront with the attorneys, and they would understand. And it was mainly private attorneys, and they would get a replacement for me. But I don't think it is what the scenario you are describing. I think you've got it wrong.
DCJ, if I may, with your permission, I have a second question, if I may just put it. There's a significance to me that you've acted for so long, and the next question that I'm going to ask you, hopefully you can allay my concern. Now, in the judgments, your 2022 judgment, it's 2022, and if you would just look at page 124, it's the matter of Masange versus Minister of Home Affairs. You remember the judgment? And this is about Rule 35.
Yes, okay? Commissioner Bono.
Someone who needed to file a replying affidavit. Now, if you're there, you go to page 152. Now, this is an application to discover, because somebody wants to file a replying affidavit and they want documents. You dismissed the application. You remember that? And you find the order at 152. And I raise this with you because I'm confused about what happened here, and hopefully you can explain, and I'll tell you what my concern is about it. At 152, you say the interlocutory application is dismissed. You see that?
92.1.
Yes, 92.1. You say the application is dismissed. But when you go up to 91 on costs, you say, since both the applicant and respondent are partly successful, for that reason I make no order as to costs. So you say that partly, each of them is partly successful, and in the very next paragraph, you dismiss the application. Unless there's something that I don't understand, I would like you to explain how you do that. You seem to have mangled it up somewhere. And before you answer that, maybe make a note of that so that I just finish off this question that I want to ask. And my concern about it, let me say, this is a 2022 judgment. And for someone who's been acting since 2016 for as many weeks as you've done, I am concerned that you would do that. And in similar vein, if you can go to page 154, that's your judgment in the matter of Maimela Lika City. And 154, just hold on for me. Yes, 154 is where it starts. Now, this was about, you properly, I think, identify what the issue is, and you say this is about the vicarious liability. And you have that at paragraph 3. So you say this is vicarious liability of a store owner for injury to someone who happened to be in the shop, an injury caused by an employee. And so it's clear, it's a delictual claim. But then you go to your order, right at the end, at page 165. But before that, you say you find there is a sufficient link. At paragraph 27, there is a sufficient link between this person who shot and the one that was shot and the owner of the store. But then at 28.1, you say the defendant is held vicariously liable for damages. So far, nothing wrong with that. In the form of loss of support, nothing wrong with that. And then you say resulting from the murder committed by the second defendant. How do we get there in a delictual claim? And I'm particularly concerned because this is in 2022. And you've been acting for all these years, and we end up with this in orders. Can you just explain and why, in the light of these kind of things, the Commission should still recommend that you be appointed?
Let me start with 152. 152, Commissioner Baloyi, you were saying the application is dismissed. This matter of Masange came twice before me, and it was a review. And the review came on an urgent basis, and what came before me was the interlocutory application, which was the Rule 35. And subsequent to that, there was a leave to appeal, which I've had, and I'm just trying to think the grounds of the leave to appeal. And if you look at, I'm not sure if you have there is this one that have a spreadsheet, the bundle that have a spreadsheet, and it is in number 8, where the leave to appeal I had on the 15th of July, and I delivered it in a month's time. From that, it was also a judgment. And I think the parties there exercise the leave to appeal, and I cannot tell you correctly out of my head the grounds for appeal, but what I recall, I agreed with them that there was a patent error in the order, and I granted them the leave to appeal. So that is the position in respect of Umasang. And then let me come to the second one. Out of the shooting, it was in a bottle store in Pretoria East. And the shooting took place in that, and as a result of that, the husband of the plaintiff passed on. Let me just, yes. the husband passed.
Ms. Lokofane, if you would just give me the chance, I don't mean to be rude, let me I'm worried about the hour of the day.
Okay.
If I can just try and direct you that it's not about the facts that I'm asking you about, so it's not necessary for you to explain the facts. What I see from the judgment is you are dealing with a case of vicarious liability, right?
Yes.
However that arises. Someone was shot in the store and they're suing the store owner because the shooting was or the death was caused by an employee of the store. So the facts are that simple, right?
Yes.
You in your order you speak of a murder they're liable because a murder has been committed. You have mixed up completely unrelated concepts of law and areas of law. The one is delict, the other is criminal. And the question I'm asking is how do you in 2022, having been acting for so long, how do you end up in a situation where you mix up concepts in this way, legal concepts in this way? And really the question, the significance of the question is, how can we trust you that, when you're on the bench, you have sufficient experience over the years and you're good to go. You don't need any further training and development and exposure. That's really the thrust of my question.
From the 28.1, Commissioner Baloy, the order that's there, it is clear that the employer is vicariously liable for the actions of the employee, and that you can really see from that order. And I will not take it further than that, and I hope it does sit well with you.
Thank you,
I think, yeah.
Thanks, DCJ. Let me take you back to my earlier question of a skilled legal practitioner. How do I assess the skills of the candidate if I do not have any information before me? For example, you go to 6.2 of the questionnaire. The question is, what proportion of your litigation work has been in the field of, and then they list the different fields: criminal law, administrative law, constitutional law, labor law, and so on. And you indicate the percentage, 10%, 50%, and 5%. Then the question I will have is 50% of what? Because there is no information before me that gives me the sense of the work that the candidate ever, performed or contributed into. This question is reinforced by 6.3, which says, which cases in which you appeared list not more than 10, which you would regard as being the most significant and why, and you list one, and that is the only thing that I have before me, right? Are those percentages that mean nothing because I don't have any record of your performance, and then this only one case where you appeared as a junior counsel, and it ends there, and there's nothing else. Now, I'm trying to assess the skills of the candidate that is before me, and apart from what you will see on the record as your recorded performance on the bench, but I'm now looking at you as a practitioner. Would you want to make a comment on that?
Commissioner, may I, just before I respond, may I get just clarity whether you are asking whether this commission or you as just an individual, or it's an hypothetical? I just need to understand that first.
Yes, as one of the commissioners, because when we deliberate, I will comment on that during the deliberations.
I would submit to you that you have quite a number of things or factors that can assist the commission, and that dates back from the formal qualifications I possess, where I started up as a public prosecutor, up to all those formal qualifications as earlier alluded to by the DCJ, and I've confirmed them. The training I attended, aspirant judges training, not only that, the work experience that I've been exposed to over a number of times, including the acting stints, as have been also alluded. I will not repeat that. So I'm submitting to you that you will not find difficulty to find the qualities that you are looking for, because they are right in front of you.
So do you therefore agree with me that this percentage, in the absence of any information, these percentages mean basically nothing?
I want to believe
Because
they are just a guide.
Sorry, because I can't, they cannot be independently verified.
Yes. I would submit to the commission that they are a guide, but one will have to really go further. And they are a guide to assist, but you need to have a cumulative and a holistic understanding of the person who is before the commission and who is raising the hand, and those the experiences and the portfolios that I've been exposed to have prepared me for the positions that I'm raising my hand for. So yes, Commissioner, you will have to, not to look at 6.2 alone, you will have to look at judgments, you will have to look holistically at the experience that I'm coming with, and that's what you need to look at.
No, thank you very much.
I hope it assisted.
Advocate.
Just a comment, Ms. Logovan, you know, your colleagues from that side articulated a thought I had as I was leading you on your acting stance, but I did not say it out loud. But what I was thinking to myself was that from 1 July 2016, you have not really practiced, because you went to act for 3 months in 2016, from July to September. You were acting as a regional magistrate in the Free State. And then from there, you went to act from October, the very following month. After you acted as a regional magistrate, you went to Limpopo. And then, I mean, the whole year you were gone. You acted in Limpopo till December.
I beg your pardon, TCJ, you are.
I'm muffled, sorry.
Yeah, I can't hear.
I'm saying, I thought to myself as I led you earlier that from 1 July 2016, you have not really practiced as an advocate. You know, from...
Correct.
Yeah. I'm not castigating you for that. Don't misunderstand. Because you acted as a regional magistrate for 3 full months, and then you went to Limpopo, and from there, until to date, I did not put the other thing you mentioned in your application form, that as you were filling in this application form, you had actually been invited to act again in the Gauteng Division during the third term.
Yes.
So you have not really been in chambers in 2022 as well. Isn't that the sum of your CV really? That you practice as an advocate from 2012, April or May 2012, until end of June 2016. And that's the sum of the time you've spent at the bar.
I'll assist. Are you finished, DCJ?
Yeah, would that be a fair assessment of your trajectory?
DCJ, I will assist DCJ further, and in saying, in as much as most of the time, as you have correctly pointed out, I've been at the bench in the various divisions. The DCJ must also look at, before 2016, from 2013, I was right through an advocate. There were no acting stints, and those were the those years that really when you need to get and learn the ropes at the bar. And there were full 4 years uninterrupted where I was working as I was working as an advocate, and I was not having any acting stints. Then we come to 2016. There were 2 terms of 2016. We come to 2018. The entire year in 2018, I was not at the bench at all. The questionnaire will also state that. And then the other years are the ones that you correctly pointed out. So when you look at the trajectory, it is not as really what comes out. Yes, 126 weeks of practice. Now we can quickly do our arithmetic. If one has been in practice since 2012, but let's count out the year 2012 because it is the year that I was doing pupillage. And then when one looks at 2013, that's actually the year one has run a practice. And when you remove 126 weeks of that, one is actually left with quite a substantial amount of time that I have worked that I have executed my role as a counsel, and I hope I have addressed your concern, DCJ.
No, we say the same thing.
Okay.
And I said I'm not castigating you. If you left your affairs in order when you went to the bench, then there's absolutely nothing wrong with what you did, and you've been able to maintain your bar dues and whatever it is that you have to do there. I was just pointing out something.
Okay, thank you, DCJ. Thank you.
DCJ, I would like to just clarify, to add on your question to make sure that I've also got my notes right. Does that mean that, Advocate Ndlokovan, you went to act after 3 years at the bar?
I don't think that's correct, Advocate Ngaitobi. I can quickly count on my fingers. 23. Yes. Yes.
So which one is not correct?
You are correct, Advocate Ngaitobi, but I just need to also, if you allow me to also add something on that. And this is what
So it's correct that you went to act after 3 years?
When you count from 2013 is 2016.
Yes, that's the time. You see, yeah, because pupillage really ends in November, and practice starts in January.
Yes.
And then you went to act in 2016.
Correct.
So that's 3 years in my calculation.
You are correct, but I want to add something so that you can have, I want to put context to that. And the context is, when I joined the bar in 2012, I had 15 years of working experience in different portfolios, and they are there in my CV. So when I came to the bar in 2012, I was having a 15-year service under my belt of working experience after my formal qualification as a lawyer.
As what exactly, this experience?
I can repeat, it was alluded to by the DCJ earlier on. If you allow me, I'm happy to repeat. This is, at that time, I was a prosecutor. I was a former prosecutor. At that time, I had worked at the United Nations in the portfolios that I've mentioned. I had worked at the gender advocacy program. I had worked at national office. I've worked at UCT, law researcher, training magistrate. And so it is in summation.
No, I've got it in front of me. My reading of this is that you were a prosecutor in April 1999 to March 2001. That gives me 2 years
Yes.
of actual court work.
Yes.
Thereafter, you became a researcher, a project manager, a legal administration officer, and you worked at the United Nations, and that was the end. Thereafter, you went to pupillage. So your actual experience as a lawyer, it seems, was 3 years.
I don't think I've got it that way. I don't think I've got it that way. Advocate Gauteng, with due respect, with due respect, from all those portfolios that I've occupied, they required a person who was legally qualified. They were not, they were, the job at the UN, they would not have appointed. Yes, I was not at court daily, but I was fulfilling portfolios of an advocate, not an advocate. By the way, I was already admitted as an advocate in 2007. You make it sound as if it was all in vain.
Well,
I
if
don't
it
No,
gives-
no, no, I
if
understand.
it gives you
Thank you.
comfort, Ms. Ndlogovane, I had practiced for only 5 years when I was called to act in the CPD.
No.
Make of that what you will.
No, Commissioner Mqaitobi, DCJ makes it feel as if it was all for nothing.
No, it's all very good, but I just wanted to get it clear that the actual years in court, that's 3 years. But that doesn't mean one discounts the previous period, one adds into it.
I'm sure.
Yeah.
I'm sure it can count. It is.
All right.
Thank you, Commissioner
I think
Mqaitobi.
we've exhausted
Yo.
this aspect.
Yo.
Any questions from the virtual platform, commissioners? Commissioners on the virtual platform?
No, DCJ, I had questions, but they've been covered. Thank you very much.
Thank you.
Thank you.
Thank you. Thank you, Ms. Ndlogovane. Thank you so much for making yourself available for the interview. You're excused.
Thank you so much, DCJ, and to you all commissioners.
Is it still afternoon or evening? Good afternoon, Advocate Swanepoel. How are you? Good.
Excuse me, I'm very well, thank you.
All right. Exactly a year ago, it was on this very day that you sat in that position, wherever the JSC was sitting on that occasion, and you were interviewed.
That's correct.
For a vacancy in the Gauteng Division. And we have that, a record of those proceedings in our pack here. And it was quite thorough, as I recall. Now, I'm not going to take you back to your CV. We know about you. We've interviewed you publicly, so the South Africans know who you are. I'm just going to ask you to elaborate on two aspects mentioned in your application form. At page 9, at paragraph 6.1, you seek to elaborate on a matter, an aspect that you feel you did not address properly during those interviews, and I suspect you think it may have something to do with why you were not recommended, I don't know. So if you want to just talk to us about that.
Yes, thank you, Deputy Chief Justice. I was asked on the last occasion why I should not be appointed before a member of the, for instance, the Johannesburg Bar. And the question was that the members of the bar are at the coalface of the profession on a daily basis. I think I let myself down a little bit with that answer. What I didn't make clear, I believe, is that I have 35 years' experience as a prosecutor, as an attorney, and as counsel. On virtually every one of those, days that I was at work, I litigated. I litigated in a wild field of law. I've set out in my application the law that I've dealt with. So what I didn't make clear is that, in fact, I'm an experienced litigator. It's not a question that was when I was an attorney, for instance, that I sat in the office. I did the litigation myself. As counsel, I've done the litigation myself in a wide area of law. That I didn't make clear, I believe, Deputy Chief Justice. And perhaps you're right. Perhaps that did have an effect on whether I was recommended or not.
So what have you done in the past 12 months that you think would have enhanced your resume,
well,
such as to impress the JSC to find in your favor this time around?
Thank you. That is a question which I was hoping to be asked. Deputy Chief Justice, I have an additional 13 weeks under my belt on the bench, and it takes my total to 86 weeks in total. Of those 13 weeks, I spent 4 weeks in the urgent court. In the 1 week, I was the senior judge. So from that point of view, I feel I've got a lot more experience. And I must say that what resonated with me yesterday was Judge Wiener's remarks, that in this particular job, experience, I believe, is all. It's very important. So I have a lot more experience. The second thing that's happened is that I was very fortunate to be allocated a long trial, a medico-legal trial during the course of last year, and I wrote a judgment in February, quite a complicated judgment, which I wrote in a matter of 11 days, I believe it was. And since then, I have been allocated a number of medico-legal matters, I think 2 long trials recently. So I've gained a lot of experience in those matters, and I think I can add value hearing those kind of matters. Mm-hmm. The third thing that's happened is as a result of this commission, quite ironically, I was rightfully criticized last year for the lack of depth of my knowledge of the Constitution. I have subsequently worked hard on it. I've read widely. I believe I understand the Constitution and I'm able to apply it properly in matters that come before me. That was the third thing. And the fourth thing was that, and this stemmed from a comment that I heard Commissioner Malema make in an interview with an SCA candidate in the previous interviews. And he asked the candidate, well, is a court intentionally intimidating, and what effect does that have on whether justice is seen to be done by people appearing there and people attending court? And that resonated with me. It made me realize that what one needs to do is to make sure that people feel comfortable in a court without affecting the dignity of a court. And to make sure that when people leave there, that they understand that they have been heard and that their case will be properly considered. So I've, specifically in the last few months, I've worked hard at creating that kind of an atmosphere in my court. So I believe I'm a better judge than I was on the last occasion. Those are really the four things I think that have changed in the last 12 months, Deputy Chief Justice.
But have you produced a judgment on a constitutional issue?
I have. I've produced two directly on the Constitution.
Two.
The one was relating to Section 3(1)A of the Agricultural Products Act, Standards Act, where I was asked to declare the section unconstitutional. I found in that matter that it was not inconsistent with the Constitution. It was not invalid. I was also asked in another matter to find that the education policy of the Correctional Services Department is unconstitutional. I did not find it was unconstitutional. Eventually, towards the end of the matter, the attack by the applicant was focused on and based on PAPUDA, Section 14 of PAPUDA, that it was discriminatory. I found that. I did not find that the act itself was invalid. I found that there was unfair discrimination towards an inmate. So yes, I've written those two. I've written a number of matters in respect of PAJA. So I have some experience in PAJA matters as well, Deputy Chief Justice, yes.
All right. Well, the professional bodies have sent us generally good comments on you, on your abilities. But Nadel has asked us to find out what involvement, if any, you've had in advancing transformation within the profession and also ensuring access to the profession. What would be your response to
Yes, thank you for
that concern?
For me to properly answer that question, I have to explain where my career took a little bit of a sharp turn, which I'm actually grateful for now. Towards 2008 and 2009, I was working with a lot of single practitioner, young upcoming attorneys, and some of them black attorneys, whose clients didn't always have the wherewithal to pay for counsel and to come to my...
I'm sorry, Advocate, for some reason I'm struggling to hear you. Can you perhaps
I'm sorry.
put your mic closer?
Is that better, Deputy Chief Justice? Is it better?
Marginally, but yeah, it's better.
Is that better?
Mm-hmm.
Thank you. My attorneys weren't representing people with financial means to a large extent. I was doing a lot of pro bono work and I was doing a lot of work at reduced rates. So it wasn't always feasible for clients to come to my chambers in Sandton, where I was at that stage. At the same time, I became very much involved in community work. I became involved with the New Beginnings Foundation. We worked with a homeless shelter with 1,500 people in it. We did their pro bono work. We worked with their youth, etc. At the same time, I was also running a language classes for people who couldn't speak English with the view to try and get them into the economy.
Oh, no, we are well aware of your
No, but
involvement with the
sorry.
community projects that seek to assist vulnerable members of our society.
Yes.
We're fully aware of those. We're asking about your efforts within the profession.
Yes.
Yeah.
Sorry, Deputy Chief Justice, I'm sorry if I was long-winded. What I wanted to say was my career path wasn't one of being at the bar where I could bring in junior members of the bar. It was never that kind of a practice. So I wasn't able to do that. But what I have done is, over the years, I've mentored a lot of the young attorneys who have briefed me. I've mentored their article clerks. My door has always been open to them for advice. One of my attorneys particularly has appointed black women as article clerks, and I've mentored those people. Recently, my last stint, one of them was in my chambers when I was doing urgent court, and my practice is to take the papers, explain to them, take them to court, and afterwards debrief. So I've tried to add value in that regard, Deputy Chief Justice. My career path was really not one where I was ever in a position to, my clients couldn't afford 2 counsel, sometimes not even 1. So it wasn't the kind of career where I could say I want to uplift, for instance, black women, or and advance them in that fashion.
All right.
I'm talking about counsel now.
Yes. All right. Thank you. Do you have questions for the candidate colleagues? Oh, JP Mlambo.
Thank you very much, Deputy Chief Justice. Good afternoon, Advocate Sonapolo.
Good afternoon, JP.
I'm not going to go deep because I asked you a lot of questions about your spreadsheet last year, which speaks for itself. I mean, it's now a total of 86 weeks you've given to the division. And I think, like Advocate Holland Muter, you've told us that should we find ourselves in a predicament, we can call on you and you'd be able to come and assist. Am I correct?
That is so, JP.
And in fact, that's what you've done throughout your acting stints.
Yes, I have, JP, except when I've had other matters when I really couldn't get assist, I would have tried always.
I mean, what's remarkable about you, of all the Gauteng candidates, is the spreadsheet suggests 11 weeks in the agent court. I think there are statistics missing if it is indeed 11 weeks. But I've counted 6 weeks, that is 2 weeks each. In 2021 and 2022. But you can correct that. Have you done 11 weeks? I actually get a sense you've done a lot more than 6 weeks in the agent court.
JP, this isn't accurate.
Yes.
What happened from time to time is I would, for instance, finish my opposed role by Wednesday, and then I would spend more time in the urgent court. I'd make myself available in that court. I spent an entire week, I think, in 2020, the week before the lockdown. I spent in the urgent court because the second urgent judge had gone into isolation. So I took over with Judge Mayer, and we ran the 2 urgent courts just before the lockdown. So that has happened much more often. I've spent more time in the urgent court than is actually reflected here.
Yeah. And you've done 3 weeks in the special motions, as well as 11 weeks in opposed motions.
Yes, that is correct, JP.
Right. Have you ever reserved any judgment longer than 3 months?
I believe there were 2, JP. The one was a matter in which arose from my unopposed motion court. I saw that the matter was ripe for hearing. The parties said they would hear it, and I heard it in the afternoon of my unopposed motion court. Yes. But then, to give the parties an opportunity to put their case, finally I invited them to do heads of argument, which only came to my attention on the 90th day after the matter had been heard. And when I got the heads of argument, I wrote the judgment in 2 days. The other one was an extremely complex matter. Amendments had to be brought in a 750 million rand claim. It took me a while to get all of those. The papers ran into something like 150 pages, just the plea and the particulars of claim. And I had to be very particular about reading the papers. So that took me about 3.5 months.
Yes.
But other than that, other 116 judgments, I think I've delivered in 11.17 days.
Yeah. I think you've addressed some of the issues that arose in your previous interview that the DCJ raised.
Yes.
The fact that you left the conventional bar but you continue to practice, are you in good standing with the LPC?
Yes, I am, JP. I've been a member of either the bar, the LPC, or the Law Society for 27 years. There's never been a complaint against me, and I am a member in good standing. I always have been.
Yeah. And you've told this commission that since your last interview, you've written 2 constitutionally involved cases, and you've dealt with a number of PAJA cases.
Yes.
Right.
JP, in fact, that was before the last interview. I'd already written those, yes.
Okay. And I've seen in your spreadsheet that you've done a number of full-term stints, so you know what it's like to carry a full judge's load in Gauteng.
Yes, I do, JP.
I see. And you regard yourself as ready?
I do believe I'm ready. It's something that I've grown into, and I've become comfortable with, and I believe that I can handle the work.
I see. Thank you very much, DCJ. No further questions.
No, I'm okay, thanks.
Thank you very much, DCJ. Good afternoon, Judge.
Good afternoon, Commissioner Moahe.
You wrote one of the most, I operate in the pension law space, right? You wrote one of the most useful judgments in pension law. I'm not sure if you still remember it, Swart versus Lukaimani.
Yes, I do remember it on
Section 36,
Section
7
36,
of the
yes.
Pension Funds Act.
I do recall that,
7C
yes.
of the Pension Funds Act. I just want to pick your brain because I agree with everything in that. I think it's one of the, and I'm happy that you marked it reportable. What do you think should be done in relation to the way in which retirement funds distribute death benefits and the way they exercise their discretion? Because we are yet to find solutions in relation to this provision, Section 37C of the Pension Funds
Yes,
Act.
yes.
We currently had a decision, Collards versus Collards, that came out, but we do not have absolute clarity as to how this section should actually be dealt with. What is your view on that section?
What struck me in that matter is the arbitrary manner in which the pension fund had gone about deciding on the distribution. And even when it was pointed out to them that the facts that they were basing the decision on were wrong, they still nevertheless stuck to their decision. So I think that it might be good to give guidelines to the pension funds. Perhaps the legislation should be more particular about what factors should be taken into consideration when a pension fund does distribute funds. But at the moment, it seems to me be a completely arbitrary process. Without any guidelines that would cover the entire industry. So it seems to me to be from one pension fund to the next to be different, which is not acceptable.
Thank you very much. Thank you very much, DCJ.
Anyone else here? Commissioner Steinberg.
Good afternoon.
Good afternoon, Commissioner.
You were asked last time about the question of self-review. When a public entity reviews itself.
Yes.
What would you answer this time about how the public entity should approach that?
Are you referring to the Gajima judgment specifically?
No, just generally.
Well, I would imagine if I thought about that answer that I gave, and I said that they should walk away from it. Once an administrative action has been taken, I realize you can't just walk away from it. So something has to be done about it. And in which case, in Gajima, the Concord has said that you can't review by way of PAJA. You're going to have to review by way of legality. So once you've made an administrative decision, you can't walk away from it. You have to take action to have it set aside. That's how I understand it. I think my answer last year was completely incorrect.
You were also asked about Section 172.
Yes.
And discretion. How would you answer that now?
Well, Section 172, if one makes a finding of invalidity, that a provision is inconsistent with the Constitution, you have to set it aside. You have to declare it invalid. Then one can make any order that is just and equitable, which includes limiting the retrospectivity or suspending the declaration. So I recently read the judgment of Blind SA that the Con Court handed down, which to me gave me an extremely wonderful idea of how it should be, how 172 should be applied. There was a finding of invalidity in respect of the Copyright Act, and Justice Unterholzer wrote a judgment there in which he very finely and with a rapier, in a rapier-like manner, wrote into the Act, Section 13A. So that's how it seems to me one should approach it. If there is a finding of invalidity, then one must be very careful about not encroaching on the legislature, but you must then try and find a solution that's just and equitable, and even if it's in the interim, as it was in Blind SA, to find a solution to that invalidity in the provision.
And if, for example, you have a matter concerning a tender before you,
Yes,
and you find that the tender was unlawfully awarded,
yes.
what are your discretionary powers in that situation?
Well, like in the all-pay case, there the tender was set aside, but because of the implications to the general public, the tender was left in place until another service provider could be found. That's one of the alternatives. If it is feasible, one just sets aside the tender, but one has to look at all of the surrounding circumstances, the implications for the general public, the implications for the service provider and for the state. So all of those considerations would come into play, I would imagine.
And then your options are what? What would your order look like?
Well, I would make an order that the tender is set aside. If I was to keep it in place like in all pay, I would say that the declaration I would say is suspended until a new service provider can be appointed. I can't recall what the all pay order looked like, but I would imagine that's how it would, at very basic look.
No, in fact, in a case like that, the order is that you declare the tender, the award, unlawful, but you don't set it aside.
Well, if it's invalid by way of because of the legality, then I would imagine you would have to set it aside, but keep it in place. I can't tell you, Commissioner. That's as far as I can take it. I neglected to read the order in all pay. I should have.
Could I please follow up, Deputy Chief Justice? Because, you know, Mr. Swanepoel, Advocate Swanepoel, the problem is that administrative law is the heartland of litigation in
Yes.
Pretoria and in Johannesburg.
Yes.
So that's why I'm going to ask you these questions. What was the jurisprudential basis for the finding of the Constitutional Court in the Gijima case that legality is the gateway to judicial review in self-review cases?
Yes. Thank you, Commissioner. In that matter, CETA and Gijima entered into a settlement agreement, which it was common cause was contrary to procurement policies. So about 22 months after the agreement was entered into, CETA went to court and asked for an order in terms of PAJA for the reviewing and setting aside of that agreement. Now, PAJA was enacted in terms of Section 33 of the Constitution, which required the state to enact legislation in order to deal with administrative affairs. The High Court and the SCA held that, in fact, PAJA was applicable, that this was administrative action. In the High Court, I believe they found that because of that, in the 180-day period having been exceeded and no application for condemnation having been made, that CETA was out. The Concord went into quite a detailed analysis of the reason why Section 33 was in the Constitution, and it held that Section 33 was only available to persons. It wasn't available to the state. You can't have the state complaining against its own conduct. But it said that was not the end of the case. The conduct could still be reviewed under the principle of legality. And there it found that because the proper procedures had not been applied, the conduct was not lawful, and therefore it was set aside. Yes. There also, the result was that although that was set aside, Kojima wasn't divested of the advantages that it got out of the settlement agreement.
All right. I asked you about the jurisprudential basis, not a narration of the facts. The jurisprudential basis was that Section 33 confers rights on natural persons.
Yes.
And not on?
Not on the state, yes.
Yes. Now, the second thing I want to ask you is the discretion that Section 172 of the Constitution gives to a judge when they have found the award of a tender to be invalid. I don't want the case, you've discussed that with Commissioner Steinberg. I want the principles of law that flow from Section 172 of the Constitution.
Well, the first principle is if there is a finding of invalidity, you're obliged to set aside the provision or the...
No, Mr. Sonapul, that's actually incorrect. You're not obliged to set aside. You're obliged to declare the act invalid.
Yes, excuse me, yes.
Let's go to the next one.
Yes, of course. So you're obliged to declare the conduct or the law inconsistent with the Constitution and thus invalid. What you can do then is you can read down into the provision and try and read into the provision and try and find a way to cure that inconsistency. Or one can sever certain words from the provision and make it consistent with the Constitution.
No, Mr. Sonapul, that's also incorrect. That applies to a declaration of invalidity of an act of parliament, not
Yes.
to a decision
of
a tender.
Excuse me, sorry.
I'm talking about a tender. Give me the second step.
The second step in respect of the tender, well, then one would, if you set aside the tender, then one would try and find a solution in the sense that you would try and create a situation where the effects of the setting aside of the tender are alleviated as much as possible. So one could, like in all pay, hold that the contract still stands until another service provider has been found.
All right, that's also incorrect. What happens is that the judge exercises what is called a just and equitable
Yes.
jurisdiction.
Yes.
In which he can suspend the effects of the invalidity.
Yes. I believe I said that before with respect, Commissioner. I said that it can make any order that's just and equitable, including suspending the invalidity, yes.
Now, under what circumstances could the invalidity be suspended?
Well, Commissioner, it would be suspended if the circumstances are such that one cannot simply terminate that service. For instance, and again I raise all pay, if there are thousands of people, hundreds of thousands of people relying on that service, then the only thing one can do is to suspend the invalidity.
So thank you, Mr. Swanepoel. The reason I'm asking you this, I gave you the preamble, that the heartland of Johannesburg and Pretoria is administrative law. And my problem, I need to put this to you now, is that your grasp of the principles is very shaky for me.
Commissioner, may I answer that?
Yes, it's indeed intended to solicit a response.
Thank you. Commissioner, there is not a single judge in this division who knows everything about every facet of the law. But what we are is we are able to research. With respect, you've heard about my judgment in Lukaimane versus Swart, where Commissioner Marumoahe said that he thought my judgment was correct. Before I wrote that judgment, I didn't know much about pension law, but I was able to go and research it, and I was able to find the solution, and the correct solution. So I've worked very hard, Commissioner, at improving my knowledge of the Constitution, and I intend to continue to do so, because I believe we're all scholars in this job. We never stop learning. So I've never shied away from the fact that I am not a constitutional scholar, but I'm able to apply the Constitution, and I'm able to research and find the solution and write a good judgment on it.
Thank you, TCJ. I've got nothing else.
Thank you very much. I have only one question. Good afternoon, Advocate Sonopon.
Good afternoon, Commissioner.
Yes, no, thank you so much. I'm looking at at the questionnaire. You obtained your BA Law in 1992 and the LLB in 1994, correct?
Yes, that is correct, Commissioner.
And you were appointed as a state prosecutor in January 1987, is that correct?
That is correct.
And between 1984 and 1987, you are not telling us what your occupation was.
I didn't have an occupation. I was doing National Service, Commissioner. So I did 2 years National Service as a law officer in 1985 and 1986.
Why you did not think it necessary to reflect that so that we don't have to ask it?
Commissioner, I didn't think it was relevant to my professional knowledge, but I don't shy away from it. And if you want my reaction to that period now, I would gladly tell you how I feel about it now, if I may.
No, it's fine. You were then, in 1988, you were appointed Attorney General.
I went to the Attorney General's office in the middle of 1988.
And you resigned that post 6 months thereafter?
Yes, that is correct, Commissioner.
Is there any reason why you resigned from the post?
Commissioner, I had very quickly gone from being a district court prosecutor to being in the office of the Attorney General. But it had always been my dream to go to the bar. By the time I was at the Attorney General's office, I realized that prosecution wasn't for me. It was something which I enjoyed, I gained a lot of experience in, but I wanted to be in the private sector. So instead of prolonging my career at the Attorney General's office, I resigned 6 months later and I joined the bar.
Thank you very much, Advocate. Thanks, TCJ.
TCJ, may I do a follow-up on that, please? Yes. Oh. Thank you, DCJ. Good afternoon, Mrs. Swanepoel.
Good afternoon, Commissioner.
Can I just following on that line of questioning, I just want clarity on the timeline of your career. You joined the bar in 1989. That's what you just said.
Yes, I signed the Red Book, I believe, in July or August 1989.
And then you say in 1.7 thereafter you were headhunted by a firm.
There was a large firm of attorneys on the East Rand that was doing a lot of litigation, and they made me an extremely good offer, which I felt at that stage, being a young counsel, with a new career that I couldn't turn down. So I went there, and I continued to do litigation on a daily basis.
But in what capacity did you join the firm?
I was an article clerk eventually, but in the beginning, and then, but effectively I worked as if I were a partner.
Just take 2 steps back. You said you were an article clerk.
Yes.
Does this mean you now were placed on the role of attorneys?
Yes, I was. Well, I joined the firm. I signed a contract of articles, and in 1993, I think, I was admitted as an attorney.
Sorry,
93, I think. I served 2 years articles, yes.
Yes. So I just need to get this clear, and this is where my confusion stems from. You were first an attorney, and then you joined the Joburg Bar in what you've just said now was 1989.
No, I was a prosecutor until 1988. I realized that I wanted to go to the private sector. I then joined the bar. I wrote my bar exam in July of 1989. A year or so later, I was made this offer by this firm of attorneys. I did my 2 years articles there, and I became an attorney in about April 1993, if I'm not mistaken. And I then worked as an attorney for the following 10 or 11 years.
So you were, at the time when you were Attorney General, were you not in the role of attorneys?
No. The Attorney General's office is the Director of Public Prosecutions equivalent now.
All right. I just want to be clear. So you were first on the role of advocates.
Before I became an attorney, yes.
Yeah. Can you just take it slow? You were first on the role of advocates.
Yes.
You removed yourself from the role. When was that? What year?
That was in 1991, I believe.
All right. And then you placed yourself on the role of attorneys.
Yes.
In 1993.
Yes.
And then you say you appeared in criminal and civil appeals, etc. And in 1.9, you says, as counsel from 2004 onwards, I was briefed by attorneys.
Yes. Yes, that is correct.
So what happened after you were placed on the role of attorneys?
I became a director in a firm we were 3 or 4 directors in 1994. And I worked in that firm until 2004. In 2004, I realized that even though I was doing litigation to a large extent, I really needed to go back to the bar. I wanted to focus solely on litigation. And even though I was doing litigation as an attorney, there are other duties that you have to do as an attorney which are administrative nature and so on, which I didn't really enjoy. So I went back to the bar in 2004. I had myself removed from the role of attorneys and put back onto the role of advocates, and I'm still there.
All right. Now, can I just ask you to go to page 19? Now, this is the certificate of good standing from the LPC.
Yes.
And you'll know how these certificates of good standings these certificates of good standing are obtained. You provide the LPC with your various court orders, and they provide you with a certificate of good standing.
Yes.
Now, the certificate says that you were admitted and enrolled as an attorney in 1993.
Yes.
And then it says that your name was removed from the role at your own request in 2005.
Yes, that's right. I'm sorry, it wasn't 2004, it was 2005. Correct.
Yeah, but my confusion stems from the fact that you've just said to us that you were a member of the Johannesburg Bar before that.
Yes, I was. Between 1989 and 1991, I was a member of the Johannesburg Bar. I then became an attorney. I became a member of the Law Society, as it was at that stage, when I qualified to be an attorney in 1993. I remained an attorney until 2005. I then went back to the bar. I removed my name from the role of attorneys and enrolled myself as an advocate.
So you just neglected to tell the Law Society of your previous stint as an advocate?
No, 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 not at all. The Law
Sorry,
Society,
the
the Law
LPC.
Society just deals with these periods that are relevant to them.
No. The LPC, when it issues you with a certificate of good standing, has to record all the points in your career where you were admitted on the roll and removed from the role of the various professions. That's
Yes.
the role of the LPC,
Yes.
to pull all of that information together. What I just picked up is that your certificate of good standing doesn't reflect your earlier time at the bar.
I'm sorry, Commissioner, I didn't realize that it was supposed to. I thought that it only had to deal with this period when I was an attorney and then became an advocate. I didn't realize it had to reflect what happened before. If I had known that, I would have had it rectified. I simply asked for a certificate of good standing, and this is what I got. And this is correct. It might be incomplete, but I'm sorry about that. But that was not my understanding that it needed to reflect the earlier period as well. But I take that on board, Commissioner.
Thank you. Thank you, DCJ.
DCJ, sorry, you're inaudible.
DCJ, your mic. Your mic is off.
Thank you. Do you have any questions for the candidate, Commissioner Singh?
Yes, thank you very much. I couldn't hear
You may put them.
Okay. No, thank you very much. Good afternoon, good evening, Advocate Swanepoel.
Good evening, Commissioner.
Yeah, I'm very interested in your response on the Section 37C, where you said legislation needs to be more particular and it's quite arbitrary. And I'll tell you where I'm coming from. Some of the commissioners seated there and I sit as trustees on the Parliamentary Office Bearers Pension Fund. And 37C has always become a problem for us in explaining it to our members of Parliament. Because in most instances, they argue that if they fill a beneficiary form, then the trustee should honor what they've indicated on the beneficiary form. But when we sit as trustees, we've been told that in terms of the Act, you've got to look at all of those who benefited financially when the particular pensioner was alive. Now, when you suggest amendments, what are you saying in terms of what we are faced with? And how do we resolve this kind of situation that we find ourselves? Because we are called all sorts of names as trustees because we do not honor the wishes of the pensioners who are alive when they fill those forms.
Yes. Commissioner, thank you. Commissioner, I haven't really given any thought to what it should look like, but what I can tell you is what is happening at the moment. And as you say, I'm sure you get a lot of complaints, is that in this particular case of Swart versus Lukamane, the deceased had nominated his children to receive the pension benefit. And the pension then decided, well, they weren't going to do that. They were going to give everything to his wife. Now, they did that based on incorrect facts altogether, and that's why the matter was reviewed. But it seems to me that any pension fund can decide really in any manner that it wishes to allocate funds. There isn't a set standard by which the fund must consider the different claims from the different parties. So it might be useful to say, well, what weight must one put on a nomination form? Can it just simply be ignored? What weight should one put on the different family relationships? Is a wife entitled more because she is the wife? So those are questions which I think are quite vexing, which would have to be thought about. But at the moment, it is a problem. And it has been in other matters that I've also dealt with in private practice. I'm not sure that I've helped. Sorry, I'm not sure that I've helped you, Commissioner.
No, I think you've helped Advocate Swanepoel because we are looking for ways to re-look at 37C and try and make sure that those members who bring their complaints to us are catered for in one way or the other.
Yes.
And their argument to us as trustees and members of parliament is, well, we make the law, let's change the law. But it's not only a law for members of parliament, but it's a law for everybody who receives a pension. But I'm sure we'll be contacting you and the good Professor Commissioner to talk about this 37C further.
Thank you, Commissioner.
Thank you, Commissioner Singh. Commissioner Nyambi?
Thanks, DCJ. I was covered by DCJ about what happened the last time we were here. But to be fair to you, because we'll be having the deliberations, Commissioner Ngugaitobi asked you about your shaky understanding of the core business of what is happening at that division you want to go. And you said you are going to learn there. Did I understand you well?
Sorry, no, Commissioner, I'm sorry, I didn't hear the question.
When Commissioner Ngugaitobi gave you an opportunity to comment about your understanding of
Yes.
your administrative law,
Yes.
and then you said, we are ready to go and learn. Did I understand you well?
No, Commissioner, with respect not. Expressed myself incorrectly. I have a good understanding of the constitutional framework within which we work. When it comes to a specific subject relating to a constitutional matter, I am able and I will study myself into the subject to the extent that I can go and write a good judgment, that I make sure that I'm correct. The two constitutional judgments that I've written both haven't been attacked. The one was taken on appeal and the appeal was dismissed. So I'm able to gain an understanding of the subject I'm writing about. And I won't write until I've got that understanding. That's my philosophy, that I can't just go into a judgment willy-nilly. I must know exactly what I'm writing about. So that's what I'm saying is, yes, I have not had administrative experience in my private practice, although I'm now busy with a constitutional matter in private practice. But I have written on it, I've been upheld on appeal, and I will make sure that I study myself into the subject properly. So it's not a question of going into a judge's job to learn.
Study properly.
To study. We always study, Commissioner, so it's an ongoing thing, yes.
Oh, thanks. Thanks, DCJ.
Can I do
Thank
a
you,
quick
Commissioner.
follow-up, please?
JP Mlambo?
Thanks, DCJ. I just need to clarify one thing about this certificate of standing, Advocate Swanepoel. Are you the one who gave the LPC this information, or it's the LPC that issued this certificate?
Yes, how it works, JP, is this. There's a lady who works at the LPC, you phone her up and you say you need a certificate of good standing, and she emails it to you. You pay the fees and she emails it to you. I have never been au fait with what the requirements are for the certificate of good standing. I assumed that it was correct, as it is now, because the information is correct in it. It might be incomplete in respect of my early days, but it is correct.
Thank you, DCJ.
Just to follow up, DCJ, I think this is important. I think and Judge President raises a very important point. My understanding is this certificate actually operates from a period to a certain period. You don't get it in eternity. In other words, you get it, you have to apply for it every financial year. Because there are possibilities that you might be in good standing now, but next year not be in good standing.
Yes,
and the one I have doesn't list all the information. Just said this person was admitted on this particular period and still in good standing. So
yes, Commissioner, that's how I understand it. This is about the third or fourth certificate. No, the third certificate I've applied for in the last 3 years, and they've all looked the same. I sincerely didn't realize it was supposed to be more complete than that.
Commissioner Steinberg, first. There are 23 commissioners, and I have to make sure that everyone has a fair chance to ask questions. You will now get your opportunity to ask your follow-up question. The candidate is still here. He's not going anywhere until we've questioned him as much as we want. No?
It's just to finish the previous line of questions. I think we all accept that nobody ever knows everything. The concern we're expressing is that you've showed a lack of knowledge and understanding of one of perhaps the first principle of constitutional and administrative law when it comes to remedy. And that's that you can set aside conduct, but not, you can declare conduct unlawful, but not set it aside. And the fact that you can't differentiate between the two is very disturbing, because that is truly the ABC of remedy in administrative and constitutional law. So it's not that one would expect you to know everything, but that is really the basics, and particularly acting in the Gauteng courts, a judge just has to have the basics of administrative law.
Commissioner, thank you. I hear exactly what you're saying to me. But can I just repeat this? I've written extensively on Paja. If I say extensively, I've probably written 5 or 6 or 7 judgments on Paja and reviews. As I say, I've written those 2 judgments on the constitutional issues. And in all of those cases, I've never been overturned. And it's because in that particular case, I've made sure that I understand the subject matter. I've never been asked to set a tender aside. So I've never read on that particular issue. It's not something that's come before me, but I can assure you that if it had come before me, I would have mastered it. I can only point you to the comments of the GCB on my judgments. They say specifically, I can maybe read it to you. They say specifically that my judgments are sound and well written. I'm meticulous in setting out the law, the applicable facts, and then dealing with the vexing issues in CASA. So I make a particular effort before I reach a decision to understand that particular field of the law completely. So with respect, that is why I believe that I have been able to write really good judgments, for instance, in medical legal matters, and for instance, in the matter that has already been referred to. No, I don't hold myself out as being a constitutional scholar. I hope to be at some stage. I hope to have your breadth of knowledge of the Constitution, and I'll get there. That's really as far as I can take it, Commissioner.
Thank you, DCJ.
Follow-up, DCJ?
Yes, Commissioner Bernard.
Advocate Swanepoel, have you ever been overturned on appeal, any of your judgments?
I haven't, no, Commissioner.
Thank you, DCJ.
All right. Any further questions, colleagues? Advocate Swanepoel, we've reached the end of your interview. Thank you so much for making yourself available.
Thank you, Deputy
I don't know
Chief
if
Justice.
there's anything else you want to say to the Commission before?
No, thank you. It's been an interesting time. Thank you, Commissioners.
All right. Thank you, sir. Good evening, Mr. Wilson.
Good evening, Deputy Chief Justice.
How are you?
I'm fine, thank you. I hope you're well also.
I am. Will you please tell us why you qualify for this job? Crisply.
I have an unusual, I would say, unique range of experience. I'm an academic. I'm an adjunct professor at WITS, recently published a book and got my PhD. I've also run a law office, a human rights law office, for 10 years, between 2010 and 2020. And I've also had 12 years as an advocate practicing at the Johannesburg Bar. And I think that range of experience has prepared me for the acting appointments that I started a little over 18 months ago. I've now acted, I'm in my 32nd week as an acting judge on the Gauteng High Courts. By the end of this term, I will have completed 40 weeks. And I've done the full range of work that's available to an acting judge on the High Courts, everything from criminal work to the full range of civil work, mercantile law, family law, opposed motions, unopposed motions. And so I feel ready. I think most importantly for me, this is a job I love. You get to go into court every day and two very intelligent people try to persuade you how to solve a problem about justice through the application of law. And then you go away and you think very hard about it and you get to write what you think the right answer is. I can't think of a job I've ever enjoyed more before. And I can't think that there's another job out there that I would enjoy more in future.
You found it, Seri. You didn't mention that.
I founded, well, I said that I ran a law office. Perhaps I should have been a touch more specific. Yeah, I founded the Socio-Economic Rights Institute of South Africa together with Jackie Dugard in late 2009 and built that organization up into what I would suggest as one of the leading public interest law organizations in South Africa at the moment. I left in 2020, well, at the end of 2019, and my successor was Nomzamo Zondo, who is still running the organization.
Some of the commissioners are struggling to hear you. Will you bring your mic closer to your face, please?
I'm very sorry, that's not usually a problem people have, but
I
I'll do my best to project my voice. Yes.
Yeah, that's better.
Thank you. And now the organization is run by Nomzamo Zondo, who worked with me for much of the time that I was director.
How have you found, well, in the statement you submitted, you say that pursuing research, advocacy, and constitutional litigation on behalf of poor and vulnerable communities is your passion. I'm paraphrasing. Now,
yes.
Half the work you do in the High Court is just black letter law, which someone like you might find a tad tedious and even dreary on occasion. You have not had that experience.
Tedious is the last word I would use to describe my 32 weeks as an acting judge. There is, in every case, in what seems to be sometimes the simplest unopposed motion, there's a social relationship. And that social relationship is mediated by law and the Constitution. And there's always something interesting to consider in any cluster of unopposed motions that you might have to do. And there are always considerations of social justice to apply your mind very carefully to. So I haven't found anything I do tedious at all. I even find things very interesting in case management court, which I did recently, because there you apply the practice directives to move civil trials forward, and the way that the process works has consequences one way or the other for how issues are matured for trial. So even that has its interest.
You've appeared regularly both in the Constitutional Court and the SCA.
Yes.
And ever as lead counsel?
Yes. I've appeared as lead counsel in the Supreme Court of Appeal 5 times, and as lead counsel in the Constitutional Court, I believe 13 times.
How many judgments have you been able to produce during your acting stints? I remember seeing a staggering number. What is it?
Well, I've
51 judgments.
Well, that was with my application. I've now produced, as of the latest table I provided to the Judge President, 56 written judgments. The Judge President said I must include my extempore judgments. So if you include those, we get up to 70, but written judgments, 56.
Yeah. And some of them have been reported?
Yes, 3.
You've written a number of peer-reviewed academic articles and book chapters and 2 books.
Just one.
And what is the book on?
The title of the book is Human Rights and the Transformation of Property. It seeks to explain how the interaction of the right of access to adequate housing and the common law of property has driven social change in South Africa over the last 25 to 30 years, and it tracks the jurisprudence and suggests how changes in the jurisprudence might create spaces in which poor and vulnerable people can act more effectively for themselves to bring about the realization of their socioeconomic rights and a more just distribution of land and housing in South Africa.
Yeah. Do you have any reserved judgments?
I have one reserved judgment. I reserved it this morning. But other than that,
it doesn't
none.
count then?
I'm sorry?
I'm saying that doesn't count. It doesn't
if
count.
it doesn't count, I have no reserved judgments.
Yes. Have you been able to have your judgments delivered promptly?
Yes, I generally between 2 and 3 weeks. I think at the outside, I took 6 weeks once, and my quickest, I handed down the day after, or maybe 2 days after.
Okay. You also have extensive research experience from your time at CALS.
Yes.
All right. Commissioners, do you have questions for Advocate Wilson? Aye, JP, I'm sorry. Well, I explained my predicament.
Thank you very much, DCJ. Good afternoon, Advocate Wilson.
Good afternoon, Judge President.
And is it correct to describe you as a social justice activist?
I think it would have been correct when I was the director of the Socioeconomic Rights Institute, and more precisely to describe me as a legal activist for social change. I certainly have opinions about the nature of constitutional law and how it can contribute to a more just society now, but my primary role now is as an independent advocate at the Johannesburg Bar and as an acting judge.
Now, your appearances in the Constitutional Court, in particular, you say 13,
I think,
where you appeared as lead counsel.
Yes.
Right. Tells me that your area of specialization or expertise, or whatever you want to call it, is around the Constitution.
Yes, that's correct.
I see. So you live and breathe and dream the Constitution.
Yes.
I see. You argued the matter before a full court in which I presided.
I did.
Regarding search and seizure activities of the police.
Yes.
And you went on to win it in the Concord, am I correct?
Yes, I mean, we did quite well in front of the full bench, but we expanded the terms of the judgment and the order in the Constitutional Court.
Yeah. Now, in terms of your work in the division, I think the DCJ has covered that aspect. You've done work in the agent court. I think you had, the spreadsheet says you did a week.
Yes.
In the agent court. How many matters did you have, just for interest's sake?
I think in the end it would have been in excess of 15 or 20.
Yeah, because there's 2 judges in the agent court
Yes.
every week, isn't it?
Yes.
And then that full court week you spent, did you write that full court judgment?
I did.
I see. And I think in opposed motions you've had 3 weeks.
Yes.
Yeah, that's where on average you'd get about, what, 10 matters
Yes.
for the week?
Yes.
Okay. And your stint in the criminal trials, how
Yes.
did that come about?
Well, by the time I'd finished my first term in civil court, I was beginning to think that this is something I might like to do permanently. And if I was going to make this application, I wanted to be able to say I could do the whole job. And so I asked you if it would be okay with you if I were allocated to criminal court duty, and you said yes.
Well, it's remarkable you made the request because it's unusual for such a request to come from someone who's had the practice you've had to ask to go to criminal trials. I will leave it at that, but to say, I wanted you to tell the commission how it came about.
Yes.
And you ended up dealing with one highly publicized matter during your criminal stint.
Yes.
How did you find it? What was your experience in sitting in criminal trials?
In that particular criminal trial or generally?
No, generally.
I have, Judge President, some criminal defense experience. And very early on in my practice, I spent a lot of time in the Protea Magistrates' Courts defending trespass matters. And a little bit later on, I led the defense in a murder trial. And so criminal law is always something that I found quite interesting. But I wouldn't pretend to be the world's foremost expert on it. And so the initial response, once I realized I was going to sit in criminal court, was to tabulate in my head all the things I could get wrong, and to try my best to foresee them and ensure that I didn't get them wrong. And it was quite an extensive learning curve, and understanding not just the criminal law, the content of the criminal law and the content of criminal procedure, but how the various institutions involved in criminal trials work.
Yeah. But I'm sure you'd agree with me that the extent of your constitutional law knowledge stood you in good stead, because the judges who do criminal work tell me that to walk into any trial is like walking into a constitutional minefield. Yours as a judge is to avoid stepping on those mines.
Yes. I mean, the Constitution supplies the basic foundation of fairness to a criminal trial.
Yeah.
So if you are familiar with basic constitutional concepts, you are equipped to conduct the trial fairly. And in that sense, you're quite right, Judge President.
Yes. But the unfortunate part is this tends to prolong criminal trials because of all the ups and downs that are brought up before a judicial officer.
Yes. I mean, it need not. If you conduct a criminal trial with a degree of deftness and skill, you can foreshorten the delays, but they do happen.
Okay. I see you've written 2 judicial review judgments.
Yes.
The ESCOM Siemens matter.
Yes.
Yeah. But other than that, were you lucky enough to get any matter along the field you specialize in as counsel?
Well, the first 2 matters I heard in the Pretoria High Court in my first week were reviews of decisions of immigration officers. And those raised interesting questions of the applicability of PADGER as opposed to the principle of legality, and the factual bases on which immigration decisions could be made. So I found those quite interesting.
Okay. Thank you, DCJ. No further questions.
Thank you, JP. MEC Mamabolo?
Thank you very much. I must say that it wasn't my intention to ask you a question, Advocate, but there's a matter that interested me. in your responses to the Judge President. And when I look at your CV, that you are an expert in constitutional law, did I get it right? And maybe you can share with me your views about the principle of the rule of law, and not just to state it.
Yes.
Because when I listen to most people talking about the principle of rule of law, they just state it as it is. But I'd like to pick up your insights and understanding. If somebody were to say there are encroachments into the principle of law, crude subjectivity, personal beliefs and experiences of people, but also the South African context, where we come from, our history. Will you say that the still effectiveness of the principle, and if somebody was to raise those questions about erosion and, of course, encroachments into it, what will be your take on that?
I'd like to start, if I can, by stating what I understand the principle to be, but mindful of your request that I go a little bit further, I'll then go a little bit further.
Sorry, I didn't hear the first part.
I'm sorry. I'd like to start, if I can, by stating what I understand the principle to be, but then mindful of your request not to stop there. I'll go a little bit further. The rule of law is simply that we have a society that is governed by rules and not the personal preferences of those who have power. And it's actually derived from erosions into early European monarchical power. Over a period of time, personal rule was replaced by rule by law. So the idea of the rule of law is that there's a series of rules we all agree to in advance, and they encase and limit what we can do in the pursuit of our political goals. And if you live in a constitutional state, the rule of law also defines what those goals are. The fundamental law is obviously the Constitution, and it doesn't just talk about how the game is played, it talks about where we should be going towards, a more just society, where everybody can live with freedom, equality, and dignity. And so the rule of law can actually be an extremely rich concept that talks not only about the process of politics, but the values that we should be striving towards as well. It doesn't extinguish politics. It doesn't extinguish people expressing their personal opinions or beliefs or pursuing a particular political ideal. It just sets the terms on which those ideals should be pursued. So it's not, I don't think it's particularly should set the alarm bells ringing if we have a society where people pursue what might be termed by others their crude political preferences. As long as that is done constitutionally, through constitutional means, there's nothing wrong with that. The rule of law is there to police politics. It isn't there to replace it. I'm not sure I've answered your question.
Can I make a follow-up, Deputy Chief Justice?
Yes.
Yeah, I think you have covered good ground, but I still wanted to check your comment on the extent to which there's been the role of subjectivity in applying that principle. For example, I thought you'd also talk about judicial independence.
Yes.
And in our context, I thought you'll practically get into, is it effective in our country? There are people who are raising questions. So that's why I wanted to get your insights into whether you think there is or there's not creeping subjectivity that impacts the effectiveness of the principle applied in our country. So I wanted more your views, your insights as a scholar in the area, looking at your qualifications as well.
My experience of the last 12 years as a practitioner has been, on the whole, one of the enrichment of the rule of law, not its erosion. It's only through challenges, through meeting our challenges as a country head-on, by reference to legal rules, that we can enrich the rule of law and work out what it means for us. And so the criticisms that there may have been that the rule of law is being eroded by this or that particular form of political conduct may be part of the story, but I think it really misses the point. The question is, how do we respond to that conduct? How do we deal with what is considered to be abuses of power, corporate malfeasance, political malfeasance? And the answer to that question, more or less on every major issue in the last 12 years, has been, well, we ask what the Constitution says, and we try and guide ourselves with that document. The fact that people might disagree about what the Constitution requires is not a problem. It's the fact that it's constantly being referenced and it's constantly being applied that gives me a great deal of optimism about the rule of law and its enrichment in this country.
Prof.
Thank you very much, Deputy Chief Justice. A good evening, Judge.
Good evening, Commissioner.
I just have one question for you, and in relation to, I know that you are well-versed in the Constitution, but I know that you are extremely well-versed in one particular section of the Constitution where you have done extremely well, at least academically, Section 25
yes.
of the Constitution. There are people who have referred to this section as a true dignity clause in the Constitution, and there is a debate going on in the country. On the one extreme of the debate is this section has sponsored the continued landlessness that people are actually experiencing. On the other hand, there are those who are saying, no, this section is actually fine. It's just that it's not implemented the way it should be implemented to ensure that people have access to the land through expropriation. I just want to understand, where do you stand in light of what I've just said, or if there is any other extreme that might be inherent in the debate? Perhaps maybe you can shed a light on that as well.
Well, I think that the Section 25 of the Constitution has preservative and reformist clauses. The effect of Section 25 is to freeze property holdings in South Africa as they were as at the date of its adoption. And there's no getting around the fact that that is at least partly a conservative effect. But that's not where Section 25 leaves things. Section 25(1) allows for non-arbitrary deprivations of property for the public good. In other words, deprivations of property or interferences with property that don't require the state to pay compensation. Then there are all the expropriation clauses. And then there are a whole series of clauses later on that seek to foster land, water, and related reform through the passage of legislation. Section 25 of the Constitution actually gives everybody in South Africa a right to tenure to the extent provided for in an Act of Parliament. I recently wrote an opinion on whether that has been given effect to. And so the question is that Section 25 is such a protean clause, it goes in so many different directions, that I would find it very difficult to characterize it either as an inherently conservative instrument or as an inherently revolutionary one. It embraces a wide range of potentials, and of course it's easier to exploit its potential as a document or as an instrument that might be in favor of just leaving things the way they are. But I think the vast majority of people in this country have to accept and do accept and have a great deal of desire not to leave things the way they are, but to use the reformist parts of Section 25 to create a more just and equal society.
Thank you very much. Thank you very much.
JP Wakely.
Thank you, Deputy Chief Justice. Mr. Wilson, when I read your CV, I cannot help but get the feeling that you are very passionate about the constitutional aspects, about housing and property law. And it's commendable that one is so passionate about these things because it does so much for so many. But my concern is that I think if you make yourself available for this position, aren't you in fact abandoning that passion? Because if you, I would think that a judgeship will be limiting in the role you can play in promoting these aspects of the law. Becoming a judge, an ordinary judge of the High Court. How many matters will you get that deal with constitutional issues? You're one of 76 judges in Gauteng. You know, when you act and it's enjoyable because you're doing those matters for a term. When it becomes permanent, a full-time job, you're effectively changing your whole lifestyle or what you've done in the past to something very different. And my concern is, are you ready to abandon that passion and take on this new?
Well, first of all, I have to concede that when you become a judge, you leave certain things behind. By founding and developing SERI for 10 years and creating an institution that is self-perpetuating, I think that sort of puts paid to any question of abandonment. If you leave an institution behind that is capable of taking forward the projects that SERI does, then you can move on and pursue, to some extent, other interests. And certainly after 10 years at SERI, I decided that that's what I should do. I don't find my judicial work unengaging at all. I find the opportunity to layer different forms of law together with constitutional norms and values immensely satisfying. I have not had an uninteresting week in the High Court, precisely because there is such a rich intellectual challenge. There are no two cases that are alike, and the facts are always different. The law is always slightly different, and the way the Constitution applies, whether directly or indirectly, doesn't obviously apply in all cases, but more than you'd expect, certainly at the interpretive level. And all of that I find intellectually incredibly exciting, so that I simply don't see the abandonment of an intellectual commitment to the Constitution in moving on to the High Court. Of course, the role of a High Court judge is different to the role of a public interest lawyer, and my approach to the law and its administration will change and has changed when I've been doing judicial work. But that's a change I welcome and that excites me.
No, but do you accept, Mr. Wilson, that having done a stint or two at the High Court, that issues of constitutional law, are not issues which come up regularly? You won't find that in a divorce matter. You will seldom find it in a criminal matter, definitely not in the RAF matters. And these are the run-of-the-mill matters. My fear is that as a constitutional lawyer, trained, steamed, and have done so much work, you get into the High Court, would you not, within a 6-month period or a 1-year period, become despondent? That's my only fear. That's why I ask. Because as a judge president of the court, one does not want judges whose heart and soul is not in doing the job, but who think of, when am I going to get a constitutional law matter? Because you may not get it. As far as housing is concerned, I can't see you getting any at all. Because as soon as there is a matter, if you are allocated I would suspect that one of the parties will apply for your recusal, immediate recusal, because one looks at the amount of work you've put in, but each work has a slant towards certain aspect, direction. And that's my fear as well. So my fear, when I say my fear, I mean, is it something that you would be able to live with? Or would you abandon the court after a while?
I certainly
As well,
wouldn't.
I mean,
I certainly wouldn't abandon the court. If I can answer the question in two parts. The first is to address the proposition that you don't get, the constitutional issues don't arise in run-of-the-mill High Court work. They don't arise in every case, every week, but they arise more often than perhaps is being recognized. Rule 43 court, for example, as the Constitutional Court has said, has critical aspects of gender equality about it. Power relationships in divorce proceedings, and how Rule 43 ought to affect those. I said in answer to the Judge President that constitutional law provides the value basis for fairness in criminal proceedings. So I think the Constitution can apply in multiple different ways, and I wouldn't just define a constitutional matter as a matter where you get to strike down or not strike down a statute. I know that isn't the suggestion, but there are lots and lots of different ways that the Constitution aids interpretation and conduct. So if I can set that point aside and just move directly to accept the premise for a moment that there won't be much constitutional work. I am a constitutional lawyer, but I'm not only a constitutional lawyer. I've done a range of other work, property law, labor law, quite a bit of landlord and tenant law, some criminal defense, as I said to the Judge President, and that interests me as well. The process of law interests me. The discipline of writing judgments and telling a story interests me. The whole range of the work interests me. And even if I were not to find another constitutional issue to come before me for the however many years I would serve on the High Court until retirement, I would still be interested in the work, and I would still be interested in the discipline of doing the work well. My career since becoming an acting judge has been one of massive variety. I just don't recognize a repetitive and boring strain to this job. I just haven't had it. And so I suppose in answer to your question, no, I won't become despondent. I'm sorry, Commissioner, I can't hear you.
I'm sorry. I see that you did say the whole range of work interests you, but that's not reflected in any of your articles, is it? I mean, there's only one aspect you deal with in article after article and after article. That's it's got to do with land, it's got to do with property. I have no problems with it.
Yes.
But thank you very much. Thanks. Thank you, Deputy Chief Justice.
Commissioner Ngoito.
Thank you, Deputy Chief Justice. Good evening, Advocate Wilson.
Good evening, Commissioner.
Very funny, strange to call you Advocate Wilson, but anyway. So, just the one proposition. I mean, I've certainly been becoming despondent about the constitutional project and about its very possibility, because it is undermined by inequality, by deepening levels of poverty, by crime and personal violence. And I think that sense of, is the constitutional project safe, has been a prevailing sense probably for the last, maybe since Marikana really. And Marikana represents this pinnacle of this crisis of constitutionalism. And one of the more hopeful constitutionalists that I know of is you. And your recent book, Human Rights and the Transformation of Property, is probably the most optimistic story of the constitutional success in the last 25 years. But its power, I think, lies in localization, in taking one topic and conducting an empirical analysis of that topic. and then looking back at whether or not the project was worth all of the sacrifices, and then coming to an optimistic view of the constitutional project. So the reason I make this outline, I think it's in part to follow up on what Commissioner Wegley, Judge Wegley was talking about. There is a way of looking at the Constitution as a subset of law, but there is also another one of looking at it as foundational to the law.
Yes.
And I think your conception of the Constitution is the latter and not the former. And in that sense, what you live and what you breathe is in fact the constitutional system. Perhaps let's start there and I'll come back with another question.
I'd certainly accept that characterization of my attitude to constitutional law, Commissioner.
Yes. And then there is also the optimism, right? But that is not I would say, an optimism of a young man. You are now much more refined. Perhaps you were pessimistic when you began, but you ended on the optimism side about the constitutional project and its viability. And in a sense, that is why I think your application is a very exciting project on its own. The taking of your own learnings and transporting them to the bench and trying to infuse virtually every legal question that comes in front of you with the, I would say, spirit of constitutionalism. Is that the way that you see your role? I mean, I think it's transformative in many respects. I hear your point about Section 25 potentially being preservative. We can debate that. I think it's only revolutionary. I think the preservation is the political compromise. But the text, which abandoned the right to property, which was in Section 23 of the interim constitution, abandoned that preservative element to it. Anyway, let me leave you to answer the basis of this optimism about the potential of the constitutional project.
Yes, I mean, your analysis of Section 25, Commissioner, I think makes you the optimist more than me. But I'll leave that there. Well, more of an optimist than me. As far as my own optimism goes and the way that I would seek to apply the Constitution as a judge, just on optimism generally, I just don't think we have any choice but to be optimistic. There's a Constitution. In relation to the MEC's question, I find optimism in the fact that people turn to law and legal concepts, politicians and ordinary people turn to law very often to describe what they want, and turn to the Constitution very often to describe their aspirations for a better society. That in itself is a cause for optimism. As a judge, I think that there are multiple ways in which the Constitution can be applied through my practice. And although it will be rarer for a constitutional value or a constitutional principle to be applied in a loss of future earnings case in a road accident fund matter, and I find contingency calculations fascinating. I know I'm probably in a minority of one when I say that, but there will be more opportunities to apply constitutional principles. There will, of course, be cases, perhaps even the majority of cases, where the existing law is sufficient to solve the problem. And then what you do is you apply the existing law to the facts and you explain your reasoning. But I think that's where the fun begins. It isn't where it ends.
Yeah, and then the last point, I mean, there is another source, of course, to optimism, and that is your clients. It's remarkable that despite what they have gone through, the abandonment, the abuse, the beating by the police, they still remain optimistic in the value of the rule of law itself, and that they think that their salvation lies in lawyers and the legal institutions. And that is an inspiring story, which you actually tell beautifully in your book, that kept you at Seri for the 10 years that you were there. But how do we sustain this optimistic view of the Constitution? How do we sustain it when the World Bank tells us that we are the most unequal country in the world? How do we sustain it when we've just had the sort of July violence, and some intellectuals claim that in part it is influenced or fueled by the deepening levels of poverty? And how do we sustain it when we've seen the outcomes of the Zondo Commission report, and the political class has betrayed the constitutional vision? So how do we sustain this optimism that you describe in your book, that the first 25 years we end with a note of optimism, and then make sure that in the next 25 years we continue on the same trajectory that you describe? Where do you see us, and how should we do it?
Those are extremely demanding questions to answer, Commissioner. But I will, in a sense, it's going to be a repetition. What's optimistic about the State Capture Commission is that there was a State Capture Commission, and the things that it documented are open to public scrutiny and debate, and will aid in non-repetition. It's exactly the reason to be. I haven't just written about housing and property law. I've written about the Truth and Reconciliation Commission and education policy, but particularly in my work on the Truth and Reconciliation Commission. The thing to be optimistic about, as far as the TRC is concerned, is that there was a TRC, the truth was documented, and it will aid in non-repetition. And so, and again with the July riots, one of the major responses to the July riots was with the decision of the government to not to completely abandon something that looks like a nascent basic income grant, and to continue what was the COVID grant, and to continue the accretion of a welfare state in this country. And welfare states the world over are institutions of equality and institutions of justice. And it's not so much in the events themselves that I find the optimism, but it's in how we've been able to respond to them that I find the optimism. And on the two examples you've just given me, that's what I find, that's how I sustain the optimism.
I see the DCJ is given me a moment to sneak in another question,
I'm back.
but I won't.
I'm back in my chair. Commissioner Ngwaitobi, your turn is over. I've given you too much leeway as it is. Commissioner Nyambi?
No, it's thanks, DCJ. Evening, Advocate Wilson.
Good evening, Commissioner.
It's one question from my side. In your impressive CV, you have spent your entire career, you have devoted a lot of time representing the poor and the vulnerable. Probably you'll assist us, especially on the side of the Commission as politicians, because many times when we argue about this issue of access to justice, if maybe you can share what you view as the real impediment to these poor South Africans when it comes to access to justice.
I think that there are two principal impediments. The first is in fairly severe limitations that public interest law organizations try to address in the dissemination of legal literacy amongst poor and vulnerable populations. It's not just knowledge of the content of the law. When I talk about legal literacy, I don't just talk about knowledge of the content of the law. I talk about practical plans and workshops and discussions about how to access the rights that the law embodies. And sometimes to do that without fully fledged legal representation, without lawyers, without attorneys and advocates, but to make the Constitution and the law work as a layperson. So paralegals in particular have a critical role to play in the expansion of legal literacy and in that sort of first line of practical application of law and the Constitution. And then there's the cost of legal services. The cost of legal services in South Africa far outstrips what can reasonably be afforded by most people. And one of the ways to address the cost of legal services is to expand the scope and the resources given to the Legal Aid Board, which, especially in criminal court, in my experience, does a great deal of work with very few resources. But also, perhaps in the future, to look at regulating the cost of legal services. So those are the two principal barriers that come up again and again in my practice, and the beginnings of how one might begin to address them.
Thank you, Advocate Wilson.
Thank you,
DCJ.
Commissioner Dudu?
Thank you very much. DCJ, good evening. Advocate Wilson.
Good evening, Commissioner.
I have two questions for you. The first one relates to your dual citizenship.
Yes.
And you still hold dual citizenship.
I do.
Yes. I'm asking this question while aware that Section 174 of the Constitution indicates the eligibility to be a judge as far as the Concord judges are concerned, that you ought to be a South African, and it is open to other judges. It means even when you're from Taiwan or Pakistan, you are eligible to be a judge in South Africa. I'm quite aware of
Yes.
that.
Yes.
Now, my question is, in your good conscience, do you think that it is okay, notwithstanding that this is possible, this is lawful, in terms of the South African law and Constitution? Do you think in your good conscience, is it okay that you become a judge in South Africa whilst you hold dual citizenship? I'm asking you this question precisely because when you are a judge, you take an oath in terms of Schedule 2 of the Constitution, and that you shall be faithful to the Republic, you shall uphold and protect the Constitution. In your case, if I put it to you that you are not only faithful to the Republic of South Africa, but you are also faithful to King Charles III, what will you say if I say that to you?
Well, I first of all suggest that when I take the oath, there will be, if and when I take the oath, there will be nothing in my in the fact that I hold British citizenship that would stop me from executing that oath to its fullest. I suppose faith and the fact of citizenship are two different things. If one talks about faith, if one talks about my identity, I feel 100% South African to the exclusion of feeling British. I have married a South African man. I have a South African daughter. The entire core of my moral and professional being has been invested in the project of justice and dignity and equality in South Africa. I can't imagine being anywhere else or being invested in anything else. The fact of the matter is I wasn't born in South Africa, and that's why I have British citizenship. I'm not sure I want to swear fealty to King Charles III.
In fact, let me just follow up that. In fact, on the balance of evidence, with what I read about your profile,
yes,
and that is to your advantage. There is no question about your commitment to to fight for socio-economic rights in this country. I don't doubt that with what I see, that commitment. But my question is, if you become a judge, will you renounce the citizenship of another country? I'm just asking.
I'm not.
And be faithful to what you believe in, where you take an oath to be faithful to that country and to uphold and protect its constitution.
I don't think it would be necessary to renounce British citizenship in order to be faithful to the South African Constitution. If I renounce British citizenship, I'm not sure that my sister and my brother would be particularly pleased with me, and it wouldn't be particularly easy to go and see them and go and see my family in the UK every so often. So that's the only practical reason why I wouldn't practically want to renounce British citizenship. But I don't see my British citizenship as an obstacle to my capacity to pursue my judicial oath. And for that reason, I don't see that it's necessary to renounce British citizenship. And I don't understand it to be a condition. You prefaced your question with an acceptance that it isn't a condition of becoming a judge either. So I suppose the one-line answer is that my birth citizenship absolutely doesn't preclude me pursuing and implementing my judicial oath to the fullest extent.
Okay, it's not for me to judge you,
yes,
or to say anything negative about you, or to say I can't consider you because of that,
yes,
because that will be unlawful. All that I'm saying is that it's a bit odd, and it's not for this commission to resolve this matter,
yes,
but it's just so odd that you can be elevated to judgeship when you hold dual citizenship. CJ, can I go to my second question quickly? Quickly.
Yeah.
Yes, okay. My second question, and as it is, you're very strong proponent of socio-economic rights, the Bill of Rights and all of that. In the year 2000, there was a Courtroom case that was resolved by the Concord. I'm sure you are familiar to it.
I am, yeah.
In terms of Section 25 of the Constitution. So it's a landmark case. In your respective view, do you think that authorities in South Africa across the board have done enough to ensure that everyone has got access to housing? And if that's not the case, what is it that we can do to enforce that judgment, to answer to that principal question as encapsulated in Section 25 of the Constitution?
Yes, thank you, Commissioner. The Courtroom decision was, of course, about emergency housing. And the way that Courtroom has changed the game in the right of access to adequate housing and in property law since it was handed down is to create a principle that, generally speaking, eviction shouldn't lead to homelessness. I think great strides have been made by a number of government entities across the country in implementing emergency housing programs and ensuring that emergency housing is secure and dignified for people who would otherwise be homeless. So that's the positive side of the balance sheet. Generally speaking, if one looks at the housing subsidy scheme and the construction of what used to be called RDP houses but are now called National Housing Subsidy houses, again, the number of housing subsidies that have been issued and the number of houses that have been built has been a success story. I think we have to acknowledge that. There have been difficulties with allocation. There have been difficulties with the location of RDP houses, and no form of social policy is problem-free. But there have been successes. I think the biggest single barrier to the implementation of the right of access to adequate housing is the non-availability of land, and that the state should be doing more than it probably is to ensure that land is released and made available, not only for emergency housing, but for secure tenure for poor and vulnerable people who face eviction on a daily basis.
Okay, thank you, DCJ.
Commissioner Matolotlepe, is it a follow-up?
Yeah.
Well, you didn't ask me, so that's why I called somebody else.
Yeah.
Go ahead.
Okay. Yeah, it's on the first issue, Mr. Wilson, on the dual citizenship.
Yes.
I see here in terms of section 1741, with regards to the Concord, it is specific that you need to be a South African citizen.
Yes.
And I see your practice has mostly been on constitutional law and so forth.
Yes.
Are you not aspiring to one day be in the Concord? And don't you think this dual citizenship at that stage might raise some issues?
I wouldn't even begin to imagine that I'm going to end my judicial career anywhere other than the High Court at this stage. It's not for me to choose myself for promotion to the Supreme Court of Appeal or the Constitutional Court. It's going to take a good many years for me to amass the experience as a High Court judge that would be necessary to be considered for an acting appointment to the Supreme Court of Appeal or the Constitutional Court. Once I reach that bridge, I will cross it if there is an opportunity to do so. As I interpret Section 174 of the Constitution, there have been Constitutional Court judges, certainly Constitutional Court judges who weren't born in South Africa. I'm thinking particularly of Cato Regan, who was born not far from me, or not far from where I was born. She was born in Liverpool, I believe. I don't know whether she held dual citizenship at the time she was a Constitutional Court judge, but there have been Constitutional Court judges who weren't born in South Africa. And I would interpret Section 174 of the Constitution to permit a South African citizen to be a judge of that court, irrespective of what other citizenships they hold. But it's just not even on my radar at the moment, Commissioner. I'm applying to be a High Court judge, and in my foresight is a career as a High Court judge.
Oh, okay. Thank you, DCJ.
Commissioner Matolotlepe.
Thank you, Deputy.
You have a follow-up, Mr. Matthias? Okay, go ahead.
Just on this issue of dual citizenship.
Your mic is too far from
Sorry,
you, Commissioner.
just on this issue of dual citizenship. If you have a South African citizen, does it matter that you have another citizenship? Are you not a South African citizen?
I am a South African citizen.
Yeah, look, it's just that I don't follow this. That's why I want to clarify it to you. Because all what is required, you must be a South African citizen, and you would be a South African citizen.
Yes, Commissioner.
Okay. Commissioner Matolotlepe.
Thank you, Deputy Chief Justice, and good afternoon, Advocate Wilson.
Good afternoon, Commissioner.
You know, I looked at your CV, I don't know what you call it, with admiration, and I'm asking myself, what's wrong with this picture? I looked at your age, and I'm asking myself, what went wrong in South Africa, where hardly women are seen, have what we have. South African black women who aspire to appear in constitutional court, like my friend here.
You're speaking away from the mic, Commissioner.
We are aspiring to appear in the constitutional court, and we can't get those opportunities. I'm asking myself, what's wrong? What's wrong with this picture? And since we are there, how do you assist us to have women, black women, or women in general, to appear in the Constitutional Court? Because after all, we are more than men in South Africa.
Yes. Well, of course, I've appeared with a great many women in the Constitutional Court. My most recent appearance, I was led by Adela Hassim SC. she wasn't ultimately available to argue the matter, but she settled the heads of argument, and I worked on the team with her. I have led a great many, I've led a number of black and women juniors in the Constitutional Court and appeared with them. And it's, for me, it's part of what I tried to do when I set up SERI and developed it, was to create that space for black and women practitioners to be directly involved in some fairly complex and high-profile constitutional litigation. And all of the people I'm thinking of now who have been a part of SERI have risen to that challenge extraordinarily well and are some of the best lawyers I know. So I suppose the answer is institution building, creating an environment, as I've tried to do at SERI, which is diverse, which is not just diverse, but also broadly representative of the race and gender composition of South African society, and then treats everybody with dignity and equality, and treats everybody as if they are able to bring something important to the table in every constitutional matter. And I think we created that at SERI, and I think Nomzamo, my successor, Nomzamo Zondo, my successor, has continued that spirit. One of the letters written to the Commission was by a former candidate attorney at SERI. And when I read the letter, I was most pleased by his comment that my door was always open and I always wanted to know in every matter that he was involved in what his opinion was, even though he was a junior candidate attorney on the matter. And he could see that his opinion and his view influenced my thinking. And it's the creation of that sort of environment where people will give their opinions and know that their opinions will be valued. That's what I've tried to do when I've built SERI as an institution, and I think that's the way to ensure a diverse and a dignified and an equal legal profession.
Have you finished? She has to finish first.
I follow up or not?
Yes.
I understand we need to create an environment, but I'm asking you, what other extraordinary measures we can take to have those women appearing in the Constitutional Court?
If the question is how do we ensure that black and women advocates succeed in their career to the point where they would be leading interventions in the Constitutional Court, there are a number of things that need to be done in order to reduce barriers of access to the legal profession. Probably so many that we'd be sitting well into the night if I listed them all. But the principal one for me is that we have to start paying pupils as of right. PABASA has started to do it. The Legal Practice Council has introduced the CETA grant. But it just seems to me that the biggest barrier to access to the advocates profession in this country is the failure to pay pupils, because we know that economic hardship falls disproportionately on black and women entrants to the profession. And what we're asking those black and women entrants to the profession to do is work for a year without any remuneration at all, and then take on what we're sometimes doing is asking them to work without any remuneration at all, and then take on the onerous obligations of economic obligations of practice from day one. Often while trying to understand and address briefing patterns which often put black and women practitioners at the back of the queue. And I think that we're just setting ourselves up for failure if we can't at least make sure, as a fairly well-remunerated profession, that pupils are paid as of right.
Okay, thank you, Deputy.
Follow up, Commissioner Steinberg.
Good evening, Mr. Wilson.
Good evening, Commissioner.
Just a comment on the last point that was raised. You and I have been in the same group for over a decade, and
Yes.
you are very well known as an advocate who actively incorporates black and female advocates as juniors and trains with great dedication. And you can only be commended for that.
Thank you, Commissioner.
If I may, DCJ, to add on this point, you know, when Seri first briefed me in 2013, and I was still a junior, you insisted that I can only accept the brief if I had a black woman.
Yes, carry on.
Can I just follow up from
Yes.
the comments? I'm not saying Advocate Wilson is not. I'm saying, how do we get there and have 10 of them to get there, not 1 or 2?
Yes, that's how I understood the question.
Commissioner Pillay?
Thank you, DCJ. Good evening, Advocate Wilson.
Good evening, Commissioner.
I do have one concern about your application.
Yes.
And I'll tell you what it is. I've looked at your proportion of litigation work, and it struck me that you don't have any experience in commercial law. Now, obviously, you'll know that the division is basically the busiest commercial division in the country. And ordinarily, for reasons you've mentioned around briefing patterns and the structural factors that work against black women, one would overlook that if you were dealing with a black woman candidate. But in your instance, perhaps you can just help us as to what we do with that. You know, you
Yes.
do lack commercial experience,
Yes.
and there aren't any factors which would mitigate that
Yes.
in your case.
Well, I first want to discuss what counts as commercial experience. Commercial arbitrations, competition law, black letter contract law, I would accept the proposition that I have very little experience in, no experience in competition law or commercial arbitrations, and relatively, actually very little experience in black letter contract law. I wouldn't accept that because of that I don't have experience in commercial law. A great deal of my practice for 2 or 3 years was all about banking law. Banking law from the perspective of debtors rather than the banks. But I still had to know what the National Credit Act was. I still had to, I appeared as leading counsel in both the Constitutional Court cases that dealt with the meaning of Section 129 of the National Credit Act. The housing and eviction law raise fundamental commercial and contractual issues. I've appeared in the Rental Housing Tribunal. I've litigated rental housing issues all the way up to the Constitutional Court. Again, fundamental issues of landlord and tenant arising there. I would suggest that I've had exposure in my practice to commercial issues, although I would accept the proposition that what people would ordinarily expect to label as commercial law is a weak point in my practice. I'd point out that I have written judgments on commercial matters. The one that's leaping to mind at the moment is a judgment in urgent court about intellectual property that I had to write and that I've included in my application. And I have shown the ability to get at the core issues in commercial matters that come before me, and to evaluate those issues and make the right decision, or make a decision that is defensible, but come to a well-reasoned decision on that matter. There's another trial I presided over about insolvency. In fact, I've done 2 insolvency matters, but there's a trial I presided over about the impact of insolvency on damages to be claimed in terms of breach of a lease or following on breach of a lease. And again, that required me to research and to apply commercial, what you would call ordinary black letter commercial law, very, very carefully. There was also, obviously, I've done opposed sequestration and liquidation applications. I've most recently been involved in my practice in an application to liquidate a housing association. Again, something that requires knowledge of liquidations, which are perhaps as commercial as they come. With those various caveats, I would accept a part of the proposition that you've put to me, Commissioner, but I'd want to qualify it in the ways that I have done. And so the question is, what do you do with it? Well, I would ask you to accept that you will, if you recommend me for appointment, you will be recommending a judge, a candidate whose background may well be in constitutional administrative law, but has been able to show that he can understand and apply commercial law in its entirety.
Thank you, DCJ.
Any questions from the virtual platform?
I have no questions. Thank you, Deputy Chief Justice.
Commissioner?
No question.
No question, DCJ.
Thank you. Well, we've reached the end of your interview, Mr. Wilson.
Thank you, Deputy Chief Justice.
You're excused.
Thank you very much, and thank you for the time.
Good evening, Advocate Van Aswegen.
Good evening, Deputy Chief
How are you?
Justice. I'm fine, and yourself?
I'm fine too. I must first apologize for the earlier mishap and thank you for accepting our invitation to join us this afternoon, well, this evening now.
No, it's my pleasure. Thank you.
Thank you so much.
Thank you, Chief Justice.
All right. You hold what is your first degree?
A BLC, Baccalaureus
BLC.
Legum Civilis, yes. And I then subsequently did an LLB degree.
All right. Both at the University of Pretoria?
That is correct.
All right. You started your legal career as a prosecutor?
Yes, I
In
started.
the regional court?
Yes, initially I started in the district court where everybody starts. So I started prosecuting in December of 1993, and I prosecuted for a period of 3 years in the Randburg Magistrates Court, initially in the district court and later on the majority of time in the regional court.
Mm-hmm. And in 1997 you joined the Johannesburg Society of Advocates.
That's correct. It was a passion of mine to always come to the bar. I loved litigating whilst when I prosecuted, I realized that I loved litigating, and that is the reason why I then decided to join the Johannesburg Society of Advocates.
Mm-hmm. And what kind of practice have you had?
I have had a general practice in the sense that I've done commercial work, I've done banking law, I've done family law, I've done defamation work, I've done children's court work and curatrix ad litem work.
Any criminal work?
Initially, yes. In my first few years at the bar, I would say a period of 3 years, because the instructing attorneys knew me from prosecuting days, they referred the criminal work to me. So yes, initially for the period of 3 years, and ever since when the opportunity arose, when there was a fraud or a theft case, and it was one of my civil attorneys, they would brief me in the matter and I would appear in the criminal matter as well.
Mm-hmm. You have acted in the Gauteng Division of the High Court, not so?
Yes, indeed so.
How many acting stints have you had?
I've had...
And when?
Yes, the first acting stint was in July of 2019, and subsequently I've had an acting stint for 4 weeks, also in this year, in July of 2022.
Mm-hmm. Totaling?
5 weeks, indeed.
5 weeks?
That's correct.
I see. Did you manage to write any judgment during that brief period?
Yes, I did
How
write
many?
judgments. I've included that in my curriculum vitae. It is next to the papers under section 8. I've written the judgment of Ramatuduana Investments and City of Joburg Property Company, CC. I also wrote Melomet versus Helivac and Rand Water versus Urban Dynamics. And since then, during this last stint, I had several matters, 14 matters, in which I gave some summary judgments, I gave extempore judgments, and in the more intricate matters, I wrote judgments as well.
Mm-hmm. And you reckon that this period sufficed to prepare you for permanent appointment?
I know that if one has regards to the references by the legal bodies, they say that I lack experience. However, I'm here to persuade you that that is not the situation. Although it is so that I have only acted for a period of 5 weeks experience does not equal a competence. I'm a competent advocate. I've had a successful practice for 25 years. I started out that practice in 1997. I built that practice despite many disadvantages that came my way, and I've built the practice till where it is today. I can also indicate to you that my practice has been a court-going practice. So what I mean by that is that I spent the majority of my time in court. I spent 2 to 3 days a week in court. And as any pupil at any bar will tell you, that the place where you learn the most about court is in court. I see the interaction between judges as well as advocates. And whether you sit behind the bench or in front of the bench, the law that you apply is exactly the same. I also do believe that you might find a person that's been appointed and has been appointed for 15 years that merely does the work from day to day, whereas a person that might be appointed has the energy, the transformation, the initiative to be like a new broom and really cleans.
Did you struggle at all with the workload and the pace one is expected to work at in that division?
I will say no. I say so due to the following reasons. I was under Judge Valley, who was the senior judge in the post-motion court whilst I acted. I was given 12 matters. He phoned me and indicated whether I was prepared to also deal with 2 additional matters. And I was willing and prepared to accept those matters. And I sat long hours, but I did finish that particular role. I was also fortunate to be in the urgent court with Judge Meyer Frawley, and both her and myself were indeed or we could cope with the workload that came our way whilst we were in urgent courts.
You don't owe the division any reserve judgments?
Pardon me?
Do you have any reserve judgments?
No, I don't have any reserve judgments, except I must add that I appeared in a full bench trial appeal with Judge Matujani and Judge Keatley, and there's still a full bench appeal judgment that is outstanding. But pertaining to that judgment, as I understand it, I'm busy doing a draft, and I've done a draft note, and those draft notes will be handed to Judge Matujani, who will be the scribe at the end of the day. So that is the only one that has not been written.
And when was that matter heard?
It was heard in July. It must have been around about the 22nd.
All right. And the one was it an application? The one application for leave to appeal against your judgment was dismissed by the SCA?
Yes, it was dismissed by the SCA.
All right. JP Mlambo, do you have questions for your candidate?
Thank you, DCJ. Good evening, Advocate van der Zwijgen.
Good evening, JP.
Let me start by thanking you for doing work in the pro bono court.
It's a pleasure, JP.
Because the assistance we get from advocates who come to do work pro bono, as you would have seen, helps the judges deal with the workload, normal workload of the division.
I understand.
So when you guys come to offer your services free of charge, it helps them deal with the work of the division, and it helps us not accumulate backlogs.
Yes.
So thank you very much for that.
Yes, Chief.
And you've already told the DCJ you've acted for 5 weeks.
Yes, indeed, sir.
And one of those weeks was in the urgent court.
Yes, it was indeed.
Are you able to tell the Commission how many matters you had in that week, just as an individual? Because it's a busy court.
Yes, it is a busy court. I don't want to lie. It must have been, I suppose, anything between maybe 20, 25.
The norm is 30 per judge in a busy urgent court week.
Yes.
So you would have got between 20 and 25 yourself?
Yes.
Aside from what
That's
Judge
correct,
Mafroli
Judge.
got, yeah.
That's correct.
And how many judgments out of those did you write, or did you deal with them extempore?
What I did is the majority I did extempore, but there was one judgment which I reserved and gave on the Tuesday following the Friday when the matter was heard.
Yes, yes. And I must say, what's remarkable about your acting stint is you've given us a list of 25 judgments.
Yes, Judge.
Out of an acting stint of 5 weeks.
Yes.
That's quite remarkable.
Thank you, JP.
Yeah. Now, you've not had the opportunity to sit for a full term.
No.
That is, do everything that a judge does in a term. You've not.
No, I have not.
And it may be an unfair question to ask you. Without that experience, would you consider yourself that you are ready, even if you haven't acted for a full term?
Judge President, as I said, that experience does not equate to competence.
Yes.
As an advocate practicing at the Johannesburg Bar, what I've done is time management is a skill that you early on learn in your practice, and that is a skill that I possess. I also possess the skills of being meticulous. I'm hardworking. I'm full of energy. I'm wanting to do this, and I don't believe that a person that has all those skills will not be able to cope with the demands. I have had experience in commercial work. I have also had experience in criminal work. Myself, I did not sit in the civil trial courts, but I did do civil actions and I did appear in those matters. So according to me, I will be able to cope with the load. I know it's a very, very busy division, and JP, you don't want a machine that's not oiled well. And obviously you want all the parts to be functioning optimal. I will be a part that will be functioning optimal. I do believe that if you've got time management skills and you are willing and able and you're perfectionist like I am, that you will be able to cope, JP.
Yeah. No, thank you for that assurance. And then I just want to go to the judgments you've listed.
Yes.
You got an email yesterday that you'll be asked questions about one of those judgments.
Yes, I saw it this morning. Yes, JP, yeah. I did receive that.
I see, though, that it's listed in your list. I thought it's still pending. I don't want you to name the parties, but I see
yes,
it's listed as number 23
Judge President,
in your list.
It concerned me because of the fact if you have the judgment in front of you, you would note that it's heading notes on appeal. So,
yes.
So it's not a final, it's a work in progress.
I see. Because that's my understanding. That's why I don't want you to discuss the merits.
Yes, and the parties don't know
yes.
what the outcome is as of yet, no.
But the reason I want to ask you questions about it is one of the reasons we put new acting judges in appeals with permanent judges is for them to give me feedback about how they've experienced the new acting judge.
Yes.
Right. Now, there was a discussion between you and the two judges, or with Judge Matojane,
indeed,
after you sent him your notes, because
indeed, so.
My report is that you, the scribe, it's your judgment that they've allocated you to write, and you sent a note. I don't know if that's correct.
Indeed, so. I sent a note. JP, there must be some misunderstanding because initially Judge Motojani said that he would be writing the judgment, and then I offered, and I do believe that I think that in full bench judgments, the senior judge mostly writes the judgment.
Yes.
However, I offered to write it, and he was he actually indicated to me that he was willing to let me write the judgment. I then said to him that I would send him the notes, and as you say, it's notes on appeal. So obviously I needed to be guided by him as a senior and more experienced person than I am.
Yeah, but I would like you to share with the commission the discussion you had with him
Yes.
when he received your note.
When he received my note.
Yeah.
Well, he sent me an email in which he, I just took that down from where he he enjoyed reading my comprehensive and well-reasoned heads. What I did is I combined the heads of argument and I also set out the facts in the notes on appeal. He indicated to me that he wanted me to have regards to, for instance, Judge Plaskett and Judge Unterhalter and the way that they do their judgments, and that I, in my judgments, have footnotes, whereas he, it seems, preferred not to have the footnotes. I then indicated to him that I was more than willing to go and have regards to those judgments to see how I could better my judgment writing. I must indicate to you that judgment writing, in my opinion, is something very personal. It depends on your personality. And I have gone and I have checked, and even in the SCA, I see they do make notes, use of footnotes. So I think it's a personal preference, but it's something that I'm willing to learn. And I think that I've heard other judges that are experienced judges that appeared in front of this panel who indicated that even they have still to learn about judgment writing.
Yeah. I think what I want to ask you, you mentioned it a bit, that in fact, you mentioned yourself that you combined
Yes.
the heads of arguments.
That's correct.
Of both parties.
That's correct.
And then composed your judgment note on
Yes,
that basis.
That's correct.
Okay.
Yeah.
That's what I wanted to clear with you, because
Yes.
that's the report I got.
That's correct.
That you took the heads from this side and you compiled your note.
Indeed, sir.
Okay. Thank you very much. Thank you very much, DCJ.
JP, MEC? You covered. Commissioner Noties?
In fact, the first question is a follow-up
Yes.
to this debate with the JP. Is it not the full bench judgment
Yes.
that you have said is Judge Matojana who's writing? But now you seem to say
Well,
you are
I
the
think
scribe.
that they must, no. What I said, and I must indicate that very clearly, is initially Judge Matujani indicated that he was going to, and then I offered, and I think maybe out of place offered as an acting judge to write it. He then indicated that he was willing for me to write it, but as I understood it, I would do a draft, and he would then add to that draft.
So that we clear this one, put aside. Are you the scribe in that full bench judgment?
Well, if you say the scribe, yes, I've scribed, but it's notes. It's not it's not a judgment at this point in time. It is a working process.
All right. Now, in a criminal trial,
yes,
is it permissible in the evaluation of evidence to apply probabilities?
Pardon me, to apply?
In a criminal trial,
Yes.
when as a judge you are doing the evaluation of evidence, is it permissible to apply probabilities in respect of that evidence that we have to determine one side of the
No,
measures?
it's a civil measure that you use on probabilities. You'll work on reasonable doubt, beyond reasonable doubt.
So you can't apply probabilities?
No,
that
you
is-
can't.
Like you consider the evidence as a whole, put evidence as a whole, you analyze the evidence.
Yes.
And in the process,
Yes.
in respect, you can't apply the probabilities.
No, you'll look at what is beyond a reasonable doubt.
All right. Then my second question is, in a trial where the defendant bears the onus it turns out at the end that both witnesses for the defendant and the plaintiff
Yes,
were inherently poor,
yes,
but on probabilities, still the case favors, probabilities favors the plaintiff.
yes.
What should be your response? What would be your response?
It favors the plaintiff, you say. Then if the probabilities favor the plaintiff, then in a civil case, the matter will be in favor of the plaintiff.
I think, I'm not too sure, TCJ, whether I can ask this just very last question.
One last one, short.
It's short, no, I'm trying to be specific in my question. And then, right. In the constitution of the court, that is a criminal court,
Yes,
where the section, for instance, prescribes for the presence of assessors,
yes,
it turns out that one of the assessors is not available.
yes.
Is the court entitled to proceed with the trial in circumstances where the accused had called for the presence of those assessors?
If there's only two assessors
There are
available.
two assessors in the initial, but one of them just become unavailable before the trial starts.
Yes, I believe that the court will be entitled if there are two other assessors still available.
No. What I'm saying, there's one of the assessors become not available.
Yes,
You are left with one.
only one
One,
assessor.
yes.
Yes.
That is available. Is the court entitled to proceed with that trial?
And can I just understand rightly? So the accused wanted to proceed with assessors?
No. What I'm saying is the accused elected that for the presence of assessors during the trial.
Yes,
And in terms of the act, the assessors should be two. Now one of them becomes
Is
unavailable.
I understand.
And there are delays. Is the court entitled to proceed in the absence of that assessor who is simply not available?
I understand your question. Thank you for clearing that up to me. I will not, as a judge, then proceed. I will rather see to it that there's two assessors so that accused get a fair and reasonable trial.
Commissioner, Prof. Yes, you,
Yeah.
Prof.
Thank you very much, Deputy Chief Justice. Good evening, Judge.
Good evening, Commissioner.
You wrote a very interesting case, Nedbank versus Msizi, that dealt, it was a foreclosure case.
Yes,
You remember it?
which
It
I
was dealing
wrote.
with property that was executed and
Yes, executability. Now, you might just have to, because
You-
I do lots of those. Is it a
it's a
judgment?
foreclosure case.
Is it one that I wrote?
Yes.
Yes.
You remember it?
No, maybe you'll
Not
just
me.
have
Okay,
to.
let me not deal with, because I can see that you don't have your laptop there, so perhaps maybe you may not be able to engage the fact, because I wanted to deal with the facts.
Yes.
But let me deal with it quite broadly,
Yes.
just to be fair to you.
Please.
This case dealt with Rule 46A of the Uniform Rules of Court, which was
Yes.
recently amended, and the regulations that came through.
Yes.
In relation to the setting of prices, when reserve prices, when the property is declared executable.
Yes.
I just want to understand whether the law is quite clear, or whether the law is, it is at the stage where people whose houses are executed upon can actually get some protection, particularly when the prices are reserved and then the sheriff has to execute, but the property cannot be sold because the market value cannot actually be had. And you find that the banks have to come to court to request the court to reduce the price. In that process, do you have any view as to how should we deal with these issues to protect the debtors' rights? Because if the price is reduced, you'll find that the debtors will still have to do the outstanding amount once the property has been sold. How can we protect debtors? In other words, is Rule 43A adequate in its current formation to protect the debtors, especially when the sheriffs are unable to sell the price at the market value that has been prescribed, or the reserve price that has been set?
That is a very fair question, Commissioner. Commissioner, I don't believe that Rule 46A gives the debtor the current protection that they need. I say this in lieu of the fact that if one sees how courts compute the reserve price, yes, they make use of the market value, the municipal value, they'll make use of information, sometimes the Lightstone evaluations that are given, and you will find that advocates would stand up and one advocate would say, I use this formula, another advocate would say, I use another formula. And often, I do these matters as an advocate, so often the bank will send you a brief, and you'll find that when you calculate the reserve price, even your calculation differs from that. So what I believe needs to be done is, say for the fact that we get the market and municipal value, is maybe for the actuaries on the bank side to come forward and to compute, because they're the experts. We as jurists aren't the experts in the field, but that they compute a specific formula based upon which we can calculate this reserve price. And I think that if that is an actuarial computation, then a debtor will not be able to come and say that it's not a reasonable, because then it will be reasonable. But as long as advocates and as long as the bench need to try and get a reserve price between the market and the municipal value, I believe that one will never, you may be lucky in that you set a reserve price that is reasonable, but I do believe that if the actuaries, and not even of the bank, one can have independent actuaries. Even if I think about it now, I would rather have an independent actuary compute. Why can that not be done? And then I think we'll have a formula that would be a reasonable and effective formula for any debtor.
Yes, and in the judgment, you go to the extent of a market value. I'm not really, I think that is right, and I'm not really concerned with that. Let's say the formula, you reach it and everything is fine and the reserve price is agreed upon.
Yes.
My main issue is in relation to when the sheriff cannot actually sell the property on the amount that has been agreed upon.
Yes.
And then the bank has to come back to court and request the court to reduce the amount so that they actually can sell the property. And of course, the implications on the debtor. I'm just looking at the person who owes the bank. How can we protect this person?
Commissioner, that is why I say, if we've got an actuarial calculation that is done the first time around by the legal practitioner, so if we've got that formula and we can compute that, then a reserve price would be set, and the sheriff will be then able to, if the market is obviously, because the market prices will obviously also fluctuate, and that is why I say that an actuarial, it is something that the actuarial science experts will need to compute. Otherwise, unfortunately, debtors will have to, or rather the bank will have to come back to the detriment of the debtor, who will then have to pay the additional costs.
Okay. No, thank you very much, DCJ.
Thank you, Commissioner.
Commissioner Baba?
Thank you very much, DCJ, and good evening, Advocate Van Aswegen.
Yes, Commissioner. Good evening to you.
Hi, how are you doing today?
I'm fine, yourself.
Thank you so much.
I'm glad.
You see, Advocate, we've received comments from the law bodies.
Yes.
The PLA, the GCP,
Yes.
the Law Society, and Nadel, they all indicate that you lack experience as an acting judge,
Yes.
and that you may benefit from further acting experience, suggesting that it may be premature to nominate you to the bench. And what is your comment?
Commissioner, I wish to reiterate that experience does not equate to competence. I believe I'm competent. I've had 25 years of experience. I'm almost daily in court. I see the interactions between advocates, attorneys, and the bench. And I do believe that those interactions, if you ask any pupil advocate, what is the training ground for a newly appointed advocate, it is the court. And that is, the court to me is a second home. It is a place where I litigate, litigation is in my blood, and therefore I do not believe that because of the fact that I did not sit behind the bench, I stood in front of the bench, I argued matters, but that does not mean that I'm ignorant of what's happening. I must also indicate to you that you would have seen from our curriculum vitae that even at a stage when I didn't even think of coming to the bench when I was much younger, I attended 2 aspirant judges courses. One was at Lily's Leaf and the other one was in Kempton Park at OR Tambo. I don't recall the hotel's name. But I attended those courses in order for me to come to realization about what it is that judges want and require. And in order to better myself, I do believe that those aspirant judges courses also helped me in becoming and adds to the fact that I only have 5 weeks of acting stint experience.
Do you want me to read into your statement or your response that you are not attaching any value to acting stints?
No, not at all.
Oh, sorry, let me put it, that acting stints are not adding any value to people gaining experience.
No, not at all. I think acting stints are very, very valuable. I do think, and maybe if I can give my view on that, I've had acting stints, and I've been fortunate to be in the Gauteng local division under JP Malambu, where the judges were really helpful. They wanted to assist us to make us better aspirant, I can say, judges. However, what I think is needed is like that maybe there should be a more formal structure, because people come and go doing acting stints. And as myself being a practicing advocate, I can afford 4 weeks at a time to act. You must realize that I've got instructing attorneys, long-standing attorneys that I service. I had to pertaining to that, in order to be able to act, you have to make certain sacrifices. And I just think that if there is almost like a pupillage program where there's an acting judges type of program. I know that there's the aspirant judges program over weekends. I don't know whether it's longer now, but where there's also maybe a structure where an acting judge can go before or do mentorship type of thing under a senior judge and can be evaluated by that senior judge over a period of time. That might also be a good initiative to think of. I'm just thinking of ways, because I think that every candidate that sat here today did acting stints. And I don't think whether you sat 50 weeks makes you a better judge necessarily as a person like myself that only sat there for 5 weeks. It depends on your experience, it depends on your personality, whether you wish to transform, whether you want to show initiative. All these things come into play. So I do believe that it all adds up.
So you are suggesting that in the period that you acted in that court, you never struggled?
No, I don't think you can say that you never struggled. I didn't struggle. I've got help from the colleagues who were then the judges. And no, I never struggled. Yes, with the workload, you have to sit long and hard hours. You have to put that in. So if that is part of the struggle, yes, I don't think any judge can say in this division that you don't struggle. You do.
Thank you so much, Advocate.
Thank you,
very much,
Commissioner.
DCJ.
Any questions from the commissioners on the virtual platform?
Yes, I have a question. Okay.
Yes, Commissioner Bernard.
Thank you. Good evening. I'd like to just ask you about the notes that were referred to I'm not sure whether that was actually then a draft judgment of sorts, or was it's something that was totally discarded?
Maybe I can just apologize. I see you in front of me. Sorry. Just to answer your question, a few nights ago, I saw Judge Meyer sat here, and he actually spoke about judgment writing, and Judge Matopu, who indicated the following, he said the following pertaining to judgment writing, and that for me sums up judgment writing. He says you look at all the facts that you've got, you do...
Sorry, no, that's not my question. My question are the notes that were submitted, are they a draft judgment, even though it's just the very early draft?
Yes, it's an early draft, it's a work in progress. So I won't say it's notes to a judgment, yes.
I'm a little bit concerned about just the reproducing of heads of argument. You see, there's this, are you familiar with the Stafford Stores versus Salt of the Earth Constitutional Court judgment?
Yes, I am.
Where the court frowned upon just sort of regurgitating heads of argument and said it has to be done in your own words. I think in that matter, there was heads of arguments copied and a couple of lines of own notes added to the judgment, and the court said that's just not how it should be done. Are you familiar with that?
Yes, can I just answer to that? I don't think that it is fair to ask of me to comment on notes on a judgment compared to a judgment. If it was a judgment, then it is fair to ask that question of me and then to compare it to the state of its matter. This is not a final judgment. It has not even been given. In this division, there's a 3-month period. I'm working with senior colleagues in my division to finalize those heads of argument. So no, it's not a judgment.
What was the judge that you gave it to, Judge Matajani? What was he supposed to do with these notes?
Well, the judges obviously give their comments, and I can refer you to my email to him, which specifically states that it's notes and that I await their input in respect of if I may just go there. I actually commented the following, and I wish to read it to you. I've combined both parties' heads on the 3 relevant points argued and will put them in judgment format. I thank Kyogaile for his valuable pointers on judgment writing. Please, however, bear with me. So that was what I wrote to Judge Matajani.
Yes, I think it's that line where you've combined both sets of heads of argument and will put them in
judgment format, yes.
That bothers me slightly in the light of the authority that I've referred to, the Stafford Stores matter, but We can leave it at that. It's just
I'd like to just answer you, Commissioner. In any judge, when you compile a judgment, you'll look at the heads of argument. And for me to crystallize these facts, I need to look at these heads of argument, and I have to work with them. So I do not think that there's any judge in any division that do not work with the heads of argument.
No, it's not a matter of not working with the heads of argument. I mean, obviously they have to be taken, they be regarded seriously, but the judgment should always be in your own words. But I think you've answered it. Thank you very much.
Thank you.
That's my question.
Thank you very much.
Follow up, DCJ? Follow up?
Just one question from me, Deputy Chief Justice, if I may.
There's a follow-up question, but I can't make out. Oh.
No, thank you very much, DCJ. I just want to correct one mistake that I made. The judgment that I spoke to the candidate with, I said she wrote it, and she did not write it. She was actually an advocate on that judgment. I just wanted to clarify that.
But she didn't correct you, though.
Perhaps.
Yes, Commissioner Singh?
Yes, thank you very much. Good evening, Advocate. I think the last question for the evening. Would you consider the justice system as having done enough to reform or transform the current level of women representation within the system? And here I also refer to race as well. What would your view be on that question? Thank you.
No, I don't think that enough has been done. If one has regard at the skewed briefing patterns and the fact that I think there must be something seriously done in respect of briefing patterns, especially for juniors beyond 5 years. It's irrespective of then specifically the disadvantaged juniors as well as the women at the bar, for instance, and so that those people also get the benefit of the commercial work. I myself can speak from experience in the sense that when I started at the bar, you initially got low-profile matters, and that even the male colleagues that did pupillage with me seemed to be getting better commercial work than I was actually getting. However, times are now changing and things are a bit different in that we've got the second and third advocate rule where you'll see that women and black advocates do appear. However, I would love to see that these second and third advocates also give their arguments in court. And sometimes in all these great matters that you see on television, you'll see that the people that participate are merely men. And I do think that there's a definite need for transformation in that respect.
Just as a follow-up, I think these are legitimate concerns that you raise generally. But coming back home to yourself,
yes,
what opportunities have you provided for black advocates and juniors to join you in matters that you were briefed on?
Well, I was a mentor to 3 disadvantaged female advocates at the bar, Advocate Sanomta Linda, Advocate Amy Rawani Musali, as well as Advocate Sylvia Polu, who at the time that the latter did pupillage was even pregnant. So I'm very, very proud of these 3 women. 2 of them are now in highly successful commercial jobs, and the latter one is just now starting out, but that they are some of my greatest achievements. Save for that, you would also see one of my nominations was by an advocate, Emmanuel Sitole, and I myself do always provide my experience and skills to the people that need it. You would see that even whilst he did not do pupillage with me, that I was able and willing to take him to court and introduce him to motion court so that he can also have the love that I've got for it.
Thank you, Advocate. Thank you, Deputy Chief Justice.
Thank you.
Commissioner Baloyi?
Good evening, Ms. Van Aswerfen.
Good evening. Yes, Commissioner.
In your bundle of documents, at page 31, you
Yes.
you give us a list of the, I think, significant cases.
Yes.
Just hold on, let me get there, 31. And you've listed a number of cases there, and I'm struggling to understand what it is that you are conveying here, because the heading is key cases involved in as an advocate. And you have the first case, which is a class action, that's your listeriosis matter,
Yes.
where you say you appeared.
Yes.
And then the next one is the Harehold versus Wills.
Yes.
You now say contributed to the establishment. I don't know what that means. Whether you appeared, you
I
argu-
appeared.
you argued, what did you do?
Yes.
Okay, and when you say you contributed, what do you mean? You argued successfully and so established law.
Thank you very much, Commissioner. Thanks for that matter, and specifically that question. Pertaining to those key, I think I wrote in my, they are key cases that I was involved in. That is the heading as an advocate. The one being the class action. I was so fortunate to be part of where an instructing attorney briefed me as a junior with Advocate Mandel SC in the listeriosis matter, where what we argued is the subpoena duces tecum that they wanted to compel us to comply with, that we actually brought an application to set that subpoena duces tecum aside. We actually, the High Court then dismissed our application. We took it to the SCA and we were successful at the SCA. So if I say we, then I was a junior in that specific matter to Advocate Tony Mandel. Then the landmark online defamation case, I think it is evident if one goes to the internet as well and to Google that the Harold versus Wills matter is the first matter that deals with defamation and also on the social network and specifically Facebook. I was one of the advocates that in that matter researched defamation and social media, and at that point in time there were not any matters in South Africa that dealt with this specific. So we had to look at Canadian law as well as Australian law, which we did. And His Lordship, Mr. Justice Willis, as he was then, thanked us for our contribution in that respect. Then I also
before you move
I
on.
apologize. Yes.
You see, I was trying to understand what you mean you contributed.
Yes.
Can I just maybe just to to cut through this, you were for the respondent in this application.
Yes.
And your client was not successful in the application. No. All right. I just wanted to check that about it, because my reading of this list was it's matters where you
No, it's key cases that I were involved in. So the class action we were successful. I apologize.
Please work with me.
Yes,
sorry,
I apologize.
Yes. And then the next one, you have Standard Bank of SA versus Rami and another.
Yes.
And you say you convinced the court to come to a different finding in respect of the amended Rule 32 procedural and practical effect. This is summary judgment, right?
That's correct.
And then you say Rule 32 was not retrospective in its operation. I have read that judgment.
Yes. I
think, as I understand it, and please correct me, your client was not successful in this application, and I don't see, in my reading of it, I don't see that you convinced the court, because in fact, I think, as I understand it, the court found the other way.
No, my client was successful, and Her Ladyship, Mrs. Justice Sowendu, found in favor of my client. The argument that was held was there was a previous decision in the same division which stated that the Rule 32 rule was retrospective. And she then asked myself, I think it was Advocate Adams, and I cannot recall the third person, to argue our clients' cases, and we were indeed successful.
All right. Maybe I misread it. You see, the first paragraph says, this application for summary judgment served before me on 29 August. I reserve judgment for submissions regarding the retrospective effect, right?
Yes.
And whether it was competent for a court to entertain the application, and you were asked to make submissions, and then she says, I've determined that it is. So you say that it is retrospective?
No, it's not.
All right, I read it, I think we read it differently, ma'am.
Yes, we read it differently. It was not retrospective. There was a previous judgment. I do not recall.
The judge says, I have determined that it is.
It is not, it was not retrospective.
Okay. All right, I read it differently, I must tell you. I read it the opposite of how you read it. But let me go on to my next judgment, which is the last one. It's you've referred to the matter of Harehold. Just hold on, let me go there.
This is Pilot Fright.
No, I think yours is Harehold versus Wills.
Yes, Wills versus Herald.
Say that again?
Herald versus Wills.
Yes, that's one of the judgments, am I correct?
That's correct.
Just bear with me, DCJ, if you would bear with me. And in this matter you appeared, you say, what do you say about it? You say in your application? What do you say about it?
Well, the application was, my client was the one that was, the court found against my client.
I do apologize. You've answered that. In fact, I wanted to ask you a different one, my last one. I do apologize. It's the hour of the day. You referred to Pilot Fright versus von Landsbeck. That's the one I wanted to ask you about. And you say court came to the finding that non-compliance with Section 346 of the Companies Act, this is a winding up application. Yes. Again, and you were for the applicant, yeah?
Yes.
And the applicant was unsuccessful.
Yes, what happened in that matter, there was not, the judge wanted compliance by not the legal representative, but by the people that then served, whether it be the sheriff or who served on the master specifically.
Can I tell you why I'm taking you through these? It's
yes.
Because you've listed these cases, and you start with the listeriosis case, where
yes.
you were successful.
Yes.
And then it's followed by a list of cases. You do not say you were successful, you do not say you were unsuccessful. You actually use neutral language. And I have to put this to you, that when I read these, I understood them in the same vein as how you have dealt with the listeriosis case. You appeared in these matters, and you were successful, and you contributed to making law in these cases. But in fact, in the rest of them, that is not the case. Your clients were not successful in these applications. So whatever law was created was not because, if it was, in fact, I don't think any one of them creates new law, but none of them was your contribution, because your case was not upheld.
Commissioner, if I may answer that, this is part of my curriculum vitae that you're now referring to. It's under the heading Key Cases Involved in as an Advocate. I did not only mention the matters that I was, so it doesn't say only matters that I was successful in as. I do believe that in the defamation case, I contributed because many of the findings that were made were based on the research that I did as an advocate. Pertaining to
So your own research was used against you because you lost in the defamation case?
Well, sometimes you have to even, to your detriment, point out what is the case law in a different country. So as I say, whether you're an advocate, it's not always that your case is in your favor. So if it is adverse to you, that must also be pointed out.
Thank you, Mrs. Waffen. Thank you, DCJ.
We have reached the end of your interview, Ms.
Thank
van Aswegen. Thanks again for coming here.
Thank you very much.
Despite everything,
Thank you much.
you're excused.
Thank you very much, Deputy Chief Justice.